Good morning. This is the New York City Board of Standards and Appeals public hearing for November 20th, 2018. We're going to take a couple of cases out of order. Item number 19, 2017-47BZ, 1052 East 22nd Street, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Good morning. Lara Altman from the Office of Lara Altman. We did have somebody attend your executive session yesterday. I heard your comments. We made a submission last night clearing up the issues on the demolition plan that you mentioned yesterday. We found a few others as well. We made sure that they match perfectly.
Do you have a copy by any chance?
Of course I do.
Yeah. Just to go over the changes.
And I know that Jella said that she had also forwarded it out to the commissioners, that everybody should have an electronic copy.
Yeah, it was sent, but I didn't have a chance to review it.
If you'd like, I can go over each of the changes.
Yeah, point us to the changes.
What else that I'm looking at? It's page P1.3. If you look on that page, on the top left,
Which, I'm sorry, E what?
P,
P.
1.3. In doing this and reviewing everything, we found there was one error on E4, so we had that corrected while we were at it.
Okay, sorry, just a second.
No. P1.3.
Okay, and the issue was, okay, first floor walls remain, right? And the
Has
other
been
one
corrected.
was,
The notes that
Removed.
incorrectly stated that walls that were remaining and are shown to remain that were going to be removed, those have been removed off the
Okay,
plan.
good.
They were just pointing to the wrong walls.
right, okay. That was the only note, and you said, you found some other?
In addition, there were some calculation errors which we had corrected, but if you look at the bottom right, I've personally checked all those calculations. They are absolutely accurate.
That's the same, on the same drawing?
Yes, it is. And there was also an error in one of the notes. It said first floor on the note to the second floor as well.
Right.
So a couple of inconsistency type of errors that we had all fixed.
Okay, great, thank you. Any other comments from commissioners? Are there any speakers on this? Okay, I'd like to make a motion to close then.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition, the usual condition, that all existing materials shown to remain on the drawing shall remain, or the special permit is secured. So on that motion, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Item number 22, 2017-247BZ, 1367 East 24th Street, Brooklyn. This is administratively adjourned. I don't think you need to be sworn in, or,
No, so it's just to pick another date,
right?
right?
Yeah.
We apologize. There was an error getting the documents from the architect. Everything was submitted.
Yeah, we saw it.
It was due Wednesday evening. It was submitted Friday morning. If we could have the soonest date possible, we'd appreciate it, as you already have the documents.
Yeah, we have 1, 2, 3, 4,
Oh, wow.
5, 6, 7, 8.
Today's your lucky day.
Adjournments for December.
I don't know if I would say that.
Can you, December 4th work?
Absolutely.
There's a
Submission is already
date
in.
because it's already in.
Yes, absolutely.
Great.
Right,
We'll put it on
okay.
for December 4th.
Thank you.
Item number 23, 2017-266BZ, 2303 Avenue K, Brooklyn. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Hello again, Lara Altman from the Office of Lara Altman. We had somebody attend your executive session yesterday and did not hear any comments.
Right, no, the modification of the building is much better and
Thank you.
meets the standards. Are there any speakers on this? So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on the same condition, retention of existing material as shown on the drawing shall remain, or the special permit is void. So on that, a motion to grant.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta.
Aye.
Thank you very much.
Thank you.
Thank you. Okay. Alrighty, going back to the regular calendar. Hold on 1 second. Appeals calendar, continued hearing items. Item number 1, 2017-251A, Brooklyn Queens Expressway at Queens. Item number 2, 2017-252A, Brooklyn Queens Expressway at 32nd Avenue, Queens. And new case item number 4, 2017-253A, Brooklyn Queens Expressway at 34th Avenue, Queens. Not this one. The next one. Yeah. No. Okay.
Good morning, Madam Chair and Commissioners. Patrick Kilduff, Charter Krinsky and Drogan for applicant. I attended the review session yesterday. We heard the board's comments and concerns with regard to these 3 related applications. We discussed the matter further with our client, and as we notified the board yesterday, applicant is seeking to withdraw this.
I understand. So I'd like to make a motion to withdraw.
Chair Promoter,
Aye.
Vice Chair Chanda. Aye. Commissioner Otley Brown. Aye. Commissioner Shetta.
Aye.
Commissioner Shabeta. And this will be for all 3 cases.
Yes.
Thank you. Thank you for attending.
Just give me 1 second. Okay. Item number 3, 2018-22A, 255 18th Street, Brooklyn. Yeah.
Good morning, Madam Chair and Commissioners. Benjamin Hillengass on behalf of the Department of Buildings. I attended yesterday's executive session, and I'd like to take some time to address questions and concerns raised therein. Martha Cruz, Deputy General Counsel from the New York City Loft Board, is also present and can take questions vis-a-vis Loft Board issues. At yesterday's executive session, the board questioned the relevance of the 1999 Alteration Type 2 application. As the department noted at the last hearing, the Alt 1 application pursuant to which DOB issued the relevant CO stated that all work had occurred under this Alt 2 filing. This suggests not only that the applicant should have filed the Alt 2 as an alteration type 1 because it involved a change in use or occupancy, but also that DOB may have subjected the Alt 1 application to a lower degree of scrutiny than appropriate because, according to the description of the work, the Alt 1 represented a no work application. Second, the board asked whether the...
Now, before you, so,
Yep.
but if the Alt 1 application is different than the Alt 2, the drawings are different. There's no setback at the rear on the Alt 2, whereas there is a setback on the Alt 1.
That's correct.
And the Alt 2 shows artist studios, whereas the Alt 1 shows apartments. So, and both of these were self-certified, so whether or not DOB wasn't looking at these applications anyway, so level of scrutiny, I don't think is relevant.
Well, the Alt 1 should have had additional plan review, and my point is that because it was filed as a no-work application, it's possible, and I think likely, that whoever reviewed it may have overlooked certain issues, certain, I think, glaring issues, because of the nature, of the ostensible nature of the work as a no, quote-unquote, no-work
But
application.
that's all conjecture, we don't know.
We don't know.
And it was also a self-cert, so why would anyone look? It's only when it happens to be audited, and at the time, I don't think this particular architect was audited at every single application.
I'm only trying to explain why we think that the department may have missed certain issues here. Second, the board asked whether the department would apply to revoke a CO in other instances if the sprinkler system was deficient. The department looks at the totality of circumstances in determining whether or not to bring a CO revocation action. While I can't speak to hypothetical cases, if the same confluence of factors, a loft board building with major procedural irregularities in the issuance of its CO and code violations that affected building systems like deficient sprinklers do here, were present in other cases, I believe DOB would apply to revoke that CO. I also want to briefly address a possible misconception on the board's part. At the last hearing on this case on October 11th, the board opined that the amount of work needed to legalize the existing sprinkler system by upgrading from a dry to a wet pipe system is fairly minimal. While the extent of the work may not involve radical or expensive changes to building systems, this work does represent a major change in the building's overall fire safety. A dry sprinkler system is not permissible for residential use, and its presence represents a Class 1 violation. Therefore, the department should not have issued a residential CO while a dry sprinkler system remained in place. As the board noted yesterday, the 2000 plans state that, quote, sprinkler drawings will be filed separately. As the building already had its current dry system in place at this time, this would have referred to a retrofitted wet pipe system. I bring up the gravity of this change because I'm concerned that the board is confusing minor necessary repair work with a minor error in the CO. Insufficient fireproofing is a major problem, and it was at the heart of the issues and the errors in the CO in the burn case. Yesterday, the board questioned why this deficiency is not correctable error. I'd refer the board to the arguments we made in the department's November 9th submission. I'm quoting here, if a CO contains defects at the time of issuance, subsequent work that brings the building into accord with its CO cannot cure the initial deficiencies of the CO, quote. While the department might agree that an owner could correct a minor transcription error or a mistake in the CO that doesn't affect code compliance without triggering the need for a new CO, deficient sprinklers are not a minor error when you consider all of the circumstances at issue in this case. Here the errors are significant and the CO was inappropriately issued. Additionally, had the department not issued the CO, the tenants would have had more rights, and therefore the CO must be set aside.
Oh, but this is on, wait a second, don't leap to another right. We're
Understood.
just talking about revocation of the CO, what the situation was at the time that the CFO issued, right?
Yes.
Where, the board was the one who raised the subject of the rear yard deficiency, right? Up until then, DOB said it was only the kind of bizarre lack of occupancy by residential on the first floor, so it's a vacant space. So I don't disagree really with appellant that a vacant space is not an occupancy on the side that was supposed to have been occupied by residential use. And so it's kind of they just didn't proceed with the project. So I don't really see that that's a violation. So we're left with the sprinklers. And the building already had a sprinkler system. So it wasn't like it was an unsprinklered building. It wasn't like a building that would have been unsafe in the event of a fire. There would have been, it would have been, in other words, it has a sprinkler system, even if it takes longer for the water pressure to develop and so on. And I do have to say, by just luck of the story, luckily it had a dry pipe sprinkler system because temperatures in the building went down below 32 degrees and all of those pipes would have burst last winter. So it's actually fortuitous, ironically, that it had a dry pipe sprinkler. But I saw the sprinkler drawings, which are very elaborate because of their addressing lots of level changes and so on within the units. But ordinarily, it seems as if the sprinklers that are at the ceiling level, the only thing that would have needed to be done is change the sprinkler heads. So I don't understand why that's not viewed as correctable error. And then the other part that I don't understand is the drawings didn't show that there would be a change, that there was a requirement to change to wet pipe. So that effectively was either the architect or DOB overlooking a code requirement. We see frequently door swings in the wrong direction, corridors that aren't meeting the right width or standards or something like that, and DOB chooses not to revoke the CFO in those cases. You just change the swing of the door. You know, that's also a terrible fire hazard. In a fire, everybody has to run to that door, and the door's swinging the wrong way, but you can reverse the swing of the door. So I just want to, you know, you're looking at the sort of the conglomeration of circumstances But what I hear underlying all of this is the narrative statement and the loft board. I don't hear sprinkler system as the hazard that would have resulted in a revocation if there were no other circumstances to consider.
I mean, I would just point out that it's not the sprinkler systems alone. I merely mean to point out that the sprinklers are, in our mind, a major issue. It is a Class 1 violation. You mentioned that there's a result, or the result of dry systems is a delay, I think it's up to a minute in providing fire suppression as opposed to a wet system, which is a lot of time in the event of a quick fire. The other issues that we have here, there are myriad irregularities in the CO and its issuance, and I just want to give a litany of those, if I may. So first, as the board has noted, the CO authorizes dwelling units at the rear of the building, but the department should not have approved these without a rear wall setback to provide light and air. Second, the cellar and first floor were at all times used contrary to the CO, as we've noted. And I think this has gotten lost a little bit because of the vacate order and because these aren't issues that necessarily affect the tenants, but the cellar and first floor at no point complied with the CO, and that would have been obvious to anyone looking at this building.
Because the CO said, even though the drawings don't show it at all, so I don't know where the residential units, the two, were supposed to be placed. So you could argue they were supposed to be placed in that vacant side that has nothing in it, right? And then the other portion remained as use group 16. So, and it's true that arguably artist studios aren't use group 16, so that's not, but that's occupancy contrary to the CO vote.
But at the time of CO issuance, that's our point here. I understand what you're saying, that if this all happened subsequent to issuance, we would agree that that warranted a violation for occupancy contrary, but in fact, it was a condition precedent to the CO, or excuse me, a condition that preceded the CO. We have violations that show that there were artist studios both before and after CO issuance at both the first floor and cellar levels, and that there were never dwelling units at the first floor.
Well, the absence of, that's the part I keep, the absence of dwelling units and it just being vacant, raw space.
Well, there were artist studios in place of those dwelling units. The portion of the first floor that's occupied by the artist studios would have, I assume, been where the dwelling units would have been
Why?
located, given that the rest is open storage and was listed on the CO as storage, open storage.
Why do you assume that there would have been on that side as opposed to the vacant area?
I mean,
There are no
otherwise
drawings.
otherwise the first floor is entirely out of compliance with its CO.
No, because the thing that's very confusing about it are no drawings to support the ground floor units being residential. We don't know where they would have gone, right? So why isn't that some kind of an administrative error more than it is a violation of?
I mean, the applicant submitted those plans, and it was listed in the...
plans don't show residential on them.
And the Schedule A, which listed...
Schedule A does have it.
Yes.
So there's a disconnect between the Schedule A and the drawings. I thought the drawings rules. That's the part where I would think that would
Well,
be an
for
administrative
whatever,
error.
that may be the case, but for whatever reason, the dwelling units wound up listed on the CO, and you may think that that's an administrative error, but in either event, it's listed on the CO, and that's what we need to correct here.
Okay. That would just be a correction. That's a different thing than a revocation, right?
Let me continue with the laundry list of issues here. So as we've mentioned, the sprinkler system was a dry rather than wet system. Fourth, there were unresolved ECB violations in effect when DOB issued its CO, which is contrary to DOB policy. 5, the ostensible final sign-off inspection occurred on the very same day that the applicant reinstated the permit, and the inspector responsible for that sign-off inspection, I guess this is 5A, later pleaded guilty to approving fraudulent work.
Now, that's not the fault of the...
No, it's not, but it is an irregularity in the issuance of the CO.
No, but you
So it's
can't
not a
prove
well,
that just because
we're not-
the guy was pleaded guilty to something else,
No,
there
you're-
was an
but it was
irregularity in
approved on the
site.
very same day that the PAA was, that the application was renewed, which I don't know why that would happen.
Which what? That's the thing, a lot of this is supposition. You need to, it really needs to be based on known facts. Okay, you knew there were unresolved ECB violations, right? That's something that you can demonstrate. But whether or not the inspector was arrested
Fair.
that would render, I don't know how many hundreds of buildings illegal, because I'm thinking the person was quite busy up until that point.
Well, I would like to think that if we had noticed that there were other COs that were approved potentially in error with this laundry list of issues by someone in that position, we would similarly bring a case, or at least consider it. Sixth, the building's dwelling units have gas stoves, but the department never issued a permit for cooking gas. 7, the most recent approved plans depict and the as-built conditions reflect mechanical equipment, but the building has never had an approved mechanical application. 8, and finally, Henry Radusky replaced John Scamenti as the applicant of record in October of 2000 without ever submitting a PAA to memorialize that change.
That's enough to revoke your CFO?
I feel like all of these issues taken together are, yes.
And I just want to point out that the department came to us with 2 problems, right? And we identified the third, and now you're adding every single thing you can find for a reason to revoke the CFO. I mean, in other words, in the interest of fairness, you can probably do this with every single building that has a CFO. That at the time of the issuance, the CFO, everything wasn't perfect on the site. And so that's what you're doing. You're looking at everything not being perfect on the site. I'm just looking at to see whether there was something that was not correctable error, which is the standard that Byrne gives us, right? And
It stands for that there has to be substantial compliance at the time of CO issuance.
right,
Or-
substantial compliance and not correctable error. So the minor things could be corrected. Sorry.
Oh, no, it was just, it'd be better to stick to the stronger argument.
So, moving to the question of MDL then, the board questioned whether the department believes that CO revocation is appropriate based on issues with the rear wall. The department agrees that the absence of setbacks constitutes an independent basis for CO revocation. The 2000 PAA, document 2, plans for this building depicted a 5-foot 6-inch setback at the rear wall. This is another instance in which the work did not conform to the approved plans, and any inspection of the building should have revealed that this work was never performed. Respondents' counsel argues that the setback requirement does not apply because zoning should trump MDL in this case. However, citing the MDL, he argues that, and I'm quoting his quotation of MDL here, notwithstanding any other article of this chapter or any provision of law covering the same subject matter, except as otherwise required by the local zoning law or resolution, and quote, non-residential buildings may be occupied as residences. Respondents' counsel emphasizes the phrase "as otherwise required by the local zoning law or resolution," yet neither of the zoning provisions to which he cites establish requirements contrary to MDL. As the board pointed out at yesterday's executive session, embracing the respondent's interpretation here could result in residential buildings in which windows are entirely or almost entirely absent. I want to turn briefly to the question of criminal summonses. While the department has looked into the issue of criminal violations, criminal courts cannot compel owners to perform work, and the most likely result of a criminal summons is the issuance of more fines. On the other hand, if the BSA grants our application to revoke the CO, the Law Board will have more enforcement power. If the CO is set aside or vacated, it will empower the Law Board to proceed with a full narrative statement process for all legalization work and allow tenant input into the alterations needed to make the building comply with the fire and safety standards in Article 7B and other applicable laws.
Before you go on
Sure.
with that, unless you're going to pick that up later, my quandary is how in the world is the Law Board and the Department of Buildings having a conversation at this point where the Law Board admits in a letter from their Deputy General Counsel that the only jurisdiction they have over this site is rent setting, which I understand already occurred, right? So the DOB's constantly makes reference to this idea that the Law Board needs to have jurisdiction, or the Law Board already has jurisdiction, or the Law Board narrative statement is essential to this process. I'm not understanding why DOB keeps making reference to the Law Board. How does the Law Board fit into this?
This is a Law Board registered building.
It's a registered building, but then we talk about the jurisdiction. It has a certificate of occupancy,
That's correct.
and according to the Deputy General Counsel of the Law Board, the only jurisdiction they have over the property once there's a C of O is to set rents. according to the owner, unless the owner is not correct, rents were already set. So according to that, loft board jurisdiction is over unless the C of O is set aside. So C of O is still in place. As of this moment, C of O is in place. Why does DOB keep talking about the loft board?
So Martha Cruz, who's Deputy General Counsel from the Loft Board and is present today, can probably speak to this issue better than I can.
No, actually, this is
Well,
DOB's
let me,
question.
I'll try to answer
Okay.
the question as best I can, and hopefully if I err here, she can correct me. My understanding is that the Loft Board also opines or engages in the narrative statement process with regard to alteration type 2 applications. So in the past week or so, the owner has filed 3 or 4 jobs which affect the tenant spaces, among other things, removing mezzanines.
I know what the scope of the work is, I still don't have an answer to. If the loft board admits they have no jurisdiction as to code or renovations or anything, there's a CO in place. The CO blocks them from participating in any future, I mean, according to that, an IMD building, which is not an IMD building, by the way, you know, loft board controls interim multiple dwellings. Once it has a C of O, the building is no longer an interim multiple dwelling, it's a multiple dwelling. So the loft board should be out of the picture.
But that ceases to be the case if and when the board revokes the CO.
But-
We're not there yet.
I understand.
Right? We're not- So
I'm-
my question is, as you stated, counsel, that the criminal court can't make anyone do anything, but they certainly are much more convincing than, say, the loft board would be. Because not only will you get fines, but there's contempt. They certainly have a degree of enforcement power or a degree of penal power that for the life of me, I just can't understand why that wouldn't be something that looked into. As opposed, not just saying as opposed to what's happening now, but it also could be done in concert to what's happening now.
So the board has raised questions about alternative enforcement mechanisms at 2 hearings now, and I think that's motivated by a concern that CO revocation is insufficient to provoke the owner to act.
My question is how is that path something that's not being considered, or why? Why wouldn't?
The department has prosecutorial discretion to choose which enforcement methods it
We
takes.
understand that.
And I'm only here on the revocation action. I can't speak to possible considerations of criminal proceedings.
I appreciate that.
Right, I understand that, but what's confusing us is every single time we ask about loft board jurisdiction, the response is, well, they don't have it, but as soon as you revoke the C of O, they will have it. Hence, we're working with the loft board and treating the loft board as if it has jurisdiction. So I understand from owner's papers that the loft board has prevented the heating plan from being approved. And by what authority does the loft board prevent something from being approved by the Department of Buildings when the loft board has no jurisdiction? The C of O is currently in place.
I just want to say, again, loft board can speak to this issue probably better than I can, but my understanding is that those heating plans have been submitted to and reviewed by the Department of Buildings, but they still have to go through the narrative statement process
Why?
at loft board.
Why? Because there's a C of O. How do
But
they
still,
have to go?
it's still a loft board
Where?
registered building.
Show me the law that's, no, I'm concerned about this not only for this building, I'm concerned about this for other buildings. Something very strange is going on in Denmark. If there is nothing in the law that grants permanent loft board jurisdiction over a building that had been a multiple dwelling, an interim multiple dwelling, and then receives the C of O, that's the part where the landlords and the tenants celebrate, and they say, yay, we have a C of O, our rents are set, that's it, now we move on like a regular building, not a building that historically was an IMD. Yeah.
I have a question. Is this a standard practice? If it was in loft board and then it got a CO, you still refer to the loft board for the narrative statement to address
My understanding is that this is a special circumstance because
How
this
does it-
building
how is
came.
it- Can you explain to me why this is special and unique from any of the other buildings which may have had loft board?
This building came into loft board jurisdiction
CO.
after obtaining a CO, which is an unusual circumstance.
Yes, to set rents.
But to only set rents, they have been very clear that they have no other obligation on that building.
At this time.
Right, so.
We're
I
talking
think
about
this
at
is the
this
question.
time.
This is the question.
I-
Maybe I'll phrase it different. The question is, we agree that at this time, the loft board doesn't have any jurisdictional power because they already set rents, right? Can we go to that point first?
Can I defer to the loft board's general counsel on this? Mr. Deputy
Sure,
Mayor,
but this
on
is
question?
really DOB practice, this isn't loft board
It's not,
practice.
right, it's not about whether or not the loft, it's about, but sure.
Yeah, okay. Please.
No.
Good morning, Commissioners. My name is Martha Cruz, and I'm the Deputy General Counsel of the New York City Loft Board. So I want to first talk to the point that was made earlier. Just because a building that's in our jurisdiction receives a C of O, the Loft Board's position is that doesn't cease being an IMD or an interim multiple dwelling until the Loft Board issues a final order removing it from the Loft Board's jurisdiction. The building remains an IMD and must be registered annually with the Loft Board. So after the building receives a C of O, the Loft Board then approaches the owner and says, "Owner, you have received your C of O. Let's begin the removal process. Let's begin. Tell me about your units. Tell me whether they're rent regulated. Tell me what the rents are." There are certain filings that the owner has to make, and the owner has done so in this case. In 2015, the owner filed a removal application to be removed from the Loft Board's jurisdiction.
And your jurisdiction was limited to setting rents, is that accurate?
That is true to the extent that what the Loft Board does is while in the jurisdiction of the Loft Board, the owner files with the Department of Buildings an application that seeks to modify or change conditions in the IMD spaces, the Loft Board will require the owner to file with the Loft Board and with the plans, the alteration type 1, and a narrative statement. Because we want to see what action, what
Sure.
conditions is it that they want to change.
You want to remain up to date while it's still.
Absolutely.
Now, when
What?
this was filed with the Loft Board, it was filed and it already had a C of O.
When they registered,
When they
yes, when the
registered.
owner registered.
And therefore, the jurisdictional power of the Loft Board at this point was only setting rents, but you did keep it, you would also would keep an eye on it and on alterations that occur there. They would have to be filed with you as well, so you understood what was going on with a building that was under your jurisdiction. Is that accurate?
It's accurate to the extent that the owner did, once the building is removed from the Loft Board's
I'm
jurisdiction,
not-
I understand that. Once then the Loft Board will have nothing to do with any alteration application that's filed with the Department of Buildings. If the owner had filed immediately and the application was processed and brought before the Loft Board for removal, then the Loft Board would have nothing to do with it. But while the application and the removal application remain pending, the Loft Board is still involved to the extent that the owner voluntarily files
Right.
with the Department of Buildings to make alterations to the building, including the common areas of the building or including the commercial areas. Because we are interested in. We're interested if the owner does not undertake any action that will adversely impact the tenants.
And what if they did?
What if they did? In one situation, we had an owner who wanted to install a hair salon in the middle of the building, which would require the tenants to go through and the customers of the hair salon to go through the common areas of the building. So we asked the owner, and the owner installed a security gate so that the customers could not go through the residential portion or the apartment areas. It was fortunate enough that the hair salon was on the second floor, and the apartments were on the third through, I don't remember the number of floors, but higher than that. So the owner installed the security gate,
What if
so
he
that there
didn't?
is none.
What if he'd refused to install that security gate? What's your jurisdiction? What's your
Well, the tenants could
enforcement?
file an unreasonable interference, diminution of services, a security issue or concern
With who?
But-
with the law board.
Okay, and
No.
what, okay.
Go, I'm sorry, go ahead.
And what enforcement power do you have? If they file those things, what can you then do?
What can we do? What can the law board do? At this point, we've never had to reach that. We've always tried to
I
reach a
appreciate that.
consensus,
I
right?
appreciate that, but I'm not speaking about on a case-to-case basis. I'm speaking about within your rules, regulations, legislation, what is the enforcement power that you have on a building that has a C of O?
The enforcement power that we have. If the C of O remains in place, there's nothing that the law board can do to compel the owner to legalize
Thank you.
that which needs to be repaired.
Thank you.
That's the first question. Let's say the C of O isn't in place. What does the loft board, what enforcement power does the loft board have?
The loft law requires that the owner take all reasonable and necessary action to obtain a C of O. There's a section of our rules that requires that the owner, we can bring enforcement under that section.
What kind
Section
of
201.
enforcement? What kind of-
It's an administrative enforcement. So we will file a notice telling the owner that he has not complied with the law, and we will,
And then?
And
He
that-
doesn't comply, ever. What
Well,
happens?
the tenants won't pay
Yeah.
rent.
No,
They
that's
won't-
what I want to know. What's the response? The owner says, sorry, don't feel like it.
they will, the loft board will issue fines, and the loft board could seek specific performance.
How do you seek specific performance?
As far as I know, the loft board hasn't done it, but
So
They
this is
can.
my experience. So the law board's been in existence since 1979 or something like that, right? I still know open
1982.
IMD buildings where the landlord never got inside of X number of units, never made the repairs, it's still an IMD, there's no C of O, et cetera, and the law board never did anything to the landlord. And, the landlord's explanation in this case might have been reasonable. The tenants wouldn't let the landlord in to do the work, right? But I didn't see enforcement in any way.
with all due respect, that is not a good reason. Not getting access to
What do
a
you
tenant
mean it's
unit
not?
because the landlord has options. The landlord can file an application before the loft board
Yeah.
seeking an order of access. And then if the loft board finds that there's reason to issue such order, it will issue the order. With that order, the landlord can go to court of competent jurisdiction to seek the eviction of that tenant.
Okay.
He's not powerless.
But he has to seek the eviction, and then we don't know how the courts respond to this tenant who's been living there for 35 years, et cetera, et cetera.
Absolutely, but the owner certainly has the
Well,
option
So
to say
let's
that
just
this is
say
an
he
interim
sought-
multiple dwelling, that he's
he sought
required under the
eviction,
law.
And the court said, I'm not evicting this person, they've lived there for 35 years. No. That's the end of that,
Well,
right?
that
Well, I
generally
don't know
doesn't
that it would
happen.
be the
Like,
end
if
of
the
that.
loft board is saying this, will submit evidence stating that they support this because it's in the way of, I don't think that, well, not for me to opine on what landlord-tenant court, what could happen there, but eventually I
Yeah.
believe that you're probably going to, but I think the biggest incentive is for the landlord to correct may very well be that the tenants aren't paying rent.
Did the
And
tenants have the right not to pay rent during the time that corrective action is supposed to be taking place?
While the owner is in compliance with the loft law, the tenants must pay rent.
While the owner is in compliance with, what's that mean?
That means that he's in compliance with the statutory deadlines.
So for
Including-
example, in this very specific case, the heat is not installed, the gas heating system hasn't been installed, but there is an electric heating system, as far as I know, that costs a fortune in most of the units. So what's in compliance? Is
In
it,
compliance is that this building has a C of O.
but it already has a C of O.
So
It
I
has a
think
C of
that
O.
if
These
we-
tenants must pay rent.
It's in compliance because it has a C of O.
Oh, no, no, my scenario is, what if the C of O was revoked? Now what happens?
I don't know if this owner has applied, I mean, obviously, he hasn't applied for an extension. Because he has a
what?
code compliance deadlines. You can apply for an extension of the code
I
compliance.
don't understand. He wasn't subject to the code compliance deadlines. How can he apply for an extension? Isn't this the beginning, that now he has to apply for the very first time under the narrative statement, et cetera, et cetera?
And during that interim, if I don't want, I hate to answer, but I believe the fact is, the CFO gets revoked. He then has to do a process during that interim period, because he will not be in compliance. During that interim period, the tenants, well, I'm not sure specifically in this case, because there has been a rent amount that was delineated, but I think that would go away as well, and tenants will not pay rent until the loft board finds that the landlord is substantially complying with their goals as to what to repair and what to do. Is that an accurate statement?
Well, it's accurate to the extent that I don't know that this owner would be granted an extension. It would be an application that the owner would have to file.
What is he extending? Don't you have to have something already that says you have a
He
deadline?
is under the jurisdiction of the New York City Loft Board, and
To do what?
to legalize. So if
But
the
it's legal right now.
There's a-
It would be,
Can I-
it would be
Yeah,
not
yeah, go
legal.
ahead.
I just want to, there seems to be a couple, I'm not the lawyer here, but just as a planner, I'm seeing contradiction in the statements that are being made. And the contradiction is, you said that just because it has a CO doesn't remove it from IMD, and you want to make sure any and all work will not adversely impact it, right? But you're saying the building is in compliance because it has a CO, therefore you are not able to do, you cannot,
compel.
you cannot compel.
Yes.
That's a contradiction in my simple plannerly mind. And then you're saying it already has a CO, but it needs to be in the loft board. Again, another contradiction. I really need to understand the regulation. The reason I'm saying this is my biggest concern is in the process of so many agencies' hands in this, the tenants are going to be evicted using some ground for it. And that is not what I personally want to see, and I don't think any of the agencies should be involved in that. We need to figure out a way to make sure these tenants stay there in the most safe, healthy, habitable condition that we all New Yorkers deserve to live in.
And I would say, in response to that the only way to ensure that it's safe is by revoking the CFO and bringing these tenants and this owner into the narrative statement process so that they can review and debate and discuss the legalization plan for this building in its entirety.
Can you explain to me what the narrative statement process is? Because I've never dealt with loft board.
Sure. It's in, the owner files an alteration type 1 application with the New York City Department of Buildings to begin the conversion from manufacturing or commercial use to residential use. 15 days after the filing, he's supposed to file with the New York City Loft Board a narrative statement, which is the description of the work being proposed in the legalization plan, the alteration type 1 application. And he's supposed to serve the tenants with the narrative statement. After the filing is complete, meaning that we have the affidavit of service, that we have all of the information, the tenants have acknowledged that they've received this narrative statement, then the Loft Board will bring the parties in to discuss the plan to legalize the building.
Parties meaning the owners and the tenants.
Meaning the owner, the tenants, the lawyers, the architects, anyone who wants to come.
And all the tenants or majority of the tenants?
All of the tenants are invited.
So all the tenants have to agree to the narrative statement without which it cannot proceed?
The tenants do not have to all agree. What happens is after several conferences, the issues are whittled down to one or two, usually. Okay? If the tenants of that particular unit do not agree, the Loft Board will initiate what we call the 45-day clock. And sometimes it's 40 days, depending on whether it's an amendment. Now, the 45-day clock gives the tenants an opportunity to file with the Loft Board an explanation about why the proposed issues, why the plan unreasonably interferes or diminishes services to them. The Loft Board reviews that. The Loft Board finds that the tenant has not raised sufficient claim. The Loft Board's executive director will issue an administrative determination finding that the issues raised by the tenants do not unduly diminish services to them, nor do they unreasonably interfere with the use of their unit. And that's the end of that. The tenants will have an opportunity to appeal to the board there is an administrative appeal, but there is no hearing.
And how long does this entire narrative process take from the start to the end to
Yeah.
work, for the work to occur?
It depends on the size of the building.
For
you
this
know,
size, we have like, what, 28 units or something? How many units?
it's,
27 units, so how
Hard.
long do you think, approximately, based on years of experience, how long do you think?
I
it will
don't
take?
do the narrative statements, so it's hard for me to estimate.
I don't want to spend too much time working on this process, but I think that the issue is that that at the moment, DOB and the law board seem to be a little bit confused about jurisdiction once you have a C of O in place, and that there isn't any work to be done because the C of O is in place, right?
I also think that.
Yeah.
I think that the belief between the DOB and the law board is that there was a wrinkle in time where an error happened, and this property should have been through the loft board before getting a C of O, so
Right,
it can
but-
correct these issues.
But, yeah, I agree that they think is a wrinkle in time, but the wrinkle in time produced a C of O, which is that thing that cannot be removed except by the Board of Standards and Appeals or a court.
And if they would-
So there it is, right?
And if they would give us, if you can, I think that'd be great to now speak about the incurable errors, and that would be a basis to revoke a C of O.
But we should hear also from the property owner and from others before we do that, right? Thank you very much.
Thank you.
Could I wrap up briefly?
Yeah.
I wanted to quickly turn to the questions of safety, which yesterday's hearing, several board members expressed that was their paramount concern, and which you've reiterated today. So DOB agrees that safety should be first and foremost in the board's considerations. We also believe that revocation of this CO will help ensure tenant safety, because in the event that the board grants the application to revoke the CO, all the work that the owners need to perform in order to legalize and obtain a corrected CO will go through Law Board's narrative statement, as was just discussed. This process allows the tenants to object to plans that owners file on 3 bases: safety, diminution of services, and unreasonable interference with tenants' use of their units. If, on the other hand, the board denies the application to revoke the CO, there is nothing to compel the owners to complete the legalization process. While the board has noted that the owners have filed to retrofit the sprinklers and to remove the illegal uses at the cellar and first floor, if the board denies this application, the owner could withdraw these jobs and would face no repercussions other than the continued violations that, as the board has noted at the previous hearing, have not compelled the owners to perform the necessary corrective work up to this point.
Because you didn't issue any criminal violations against them. And by the way, we mentioned this yesterday, that we see very fast response from property owners when there's a criminal violation. We had recently a case on the Upper East Side for simply not, I mean, the fire department will not think of it as simple, but simply not having an alarm on the sprinkler system. And they received a criminal violation.
Disconnecting.
They had it, but it was disconnected, right? Disconnected, so it didn't operate. And they rushed in here to try to get us to waive that requirement, which we wouldn't do because fire department explained why there was a safety issue. And so that sent an owner right to the BSA, as it might send an owner who's threatened with criminal violations right to do the work, right?
I understand, but I want to note that in the last 9 months, since DOB filed the application with BSA, the owner has filed more applications than they have in the previous 15 years.
I really think it's best if you just focus on the errors that cannot be corrected.
It's the sprinkler, it's, as you mentioned, the rear wall, it's the first floor and cellar uses.
Okay, so it's the real wall is probably
Yes.
That's the one
that's the one that
I
just
understand.
can't be corrected, okay?
Right,
I don't think
easily
I don't think there's much more
to go on with this. I think the reason that the board is asking all these questions is because of actual fear for the tenants. And let's hear from the owner, though.
Thank you.
Thank you.
Thank you.
Good morning, Madam Chair, Commissioners, Marvin Mitzner for the owner. Let me first say that notwithstanding all the comments made about criminal court actions and seeking to get the owner to comply, at this point in time, the owner is committed to compliance, committed to doing the work. He's filed 3 alteration applications. He's waiting for approval for the heating system to be installed, right? And for the sprinklers to be installed, right? So as far as that is concerned, there's a firm commitment on the owner's part to move forward. I would suggest that far better to keep the C of O in place and perhaps adjourn these proceedings from time to time to prove to you that the owner is moving forward. Right now, the heating system can be corrected and installed if, in fact, the loft board could schedule a narrative conference with tenants so that we can move on and then get a permit.
But you would need to get your CFO revoked to get that narrative
No,
statement
not at
started.
all. Under the current, that's the mistake. Right now, the loft board has required us to go through the narrative statement process and the narrative conference for any applications we now file with DOB. So the current application for the heating system is now in the narrative process. The all 2 applications that we file, we believe, will then have to go through a narrative process where the tenants have a say. And then at the end of that, we'll do the work. But revoking the CFO doesn't accomplish anything.
I think what the concern, at least my concern is that while you are now, you're voluntarily going through the narrative statement with the loft board, because if you don't have a CFO, then you have to.
No, that's not the case either.
No, you know what, they're voluntarily doing it, let them, DOB seems to think they have jurisdiction, Law Board seems to think they have jurisdiction, I can't find a piece of legislation that says they have jurisdiction, never mind, all 3 of them want to have jurisdiction with the Law Board, you know.
It's our
that's
understanding,
thrilling.
plain and simple. It's our understanding, okay? We are currently in a process where we are mandated to take any application we file with DOB and take that through the narrative process. That's what we've done.
Okay.
We're just trying to encourage the loft board to move that process quickly so we can get the heat in before the winter.
So understood about the heat, but the issue, so the question before us, if we want to just be really cold-hearted about this, is there a reason to revoke the C of O? Was the building built pursuant, and from my perspective was the building constructed pursuant to the approved plans that led to the C of O? Simple enough, you look at the drawings, there's no rear yard setback, basta, right? I don't
No.
look at the sprinkler drawings because the sprinkler drawings, there aren't any, right? So your argument is that you don't need a rear yard setback, but the architect who filed the drawings didn't happen to agree and cited to section 277 of the multiple dwelling law that requires a 5-foot setback. So what about the 5-foot setback?
Okay, that's not quite accurate.
Oh.
The plans that were filed that the DOB has relied upon are 1999 plans that were part of document number 2 of the job on the Alt 1. There's also documents 3 and 4 that were submitted, for which the DOB does not have the plans. They failed to keep the plans. And I dare say those plans could very well show, and likely do show, no setbacks.
Why like the
Because,
show?
because between 2000 and 2013 is a passage of time. I believe that the rear setbacks are not required under the end.
In 2000, in that passage of time.
I presume that the architect or somebody realized that they didn't require setbacks at the rear.
Based on what section and which code?
I can brief the issue for you, but very simply
not
put.
the brief it.
Let me
Wait,
say,
section
very
which
simply,
code?
very simply put, this building was converted pursuant to 5231 of the zoning resolution,
Right?
which doesn't require any compliance with setbacks, rear yards, courts, or anything else under the sun.
Is this a multiple dwelling?
This is a multiple dwelling.
So the multiple dwelling applies to multiple dwellings, just
No,
does.
it depends what kind of multiple dwelling it is.
This kind of multiple dwelling,
This is
a manufacturing building converted to residential use, section 277-7.
No, 277 doesn't apply. 277 is something that under Article 1, Chapter 5 you refer to.
Yes,
It's
but-
not, it also applies in Article 7B buildings,
Yes.
right? This is a manufacturing building that is fireproof, right? Under Section 9 of the MDL, we're entitled to look at like-kind regulations under the MDL. And if you look under Article 4, which is the provision that's applicable to fireproof buildings, there is no requirement for light and air. The only requirement
For light and air to do what? To be a manufacturing building? Once it's a
No,
residential building?
that applies to converted buildings. If you look at Section 9 applies to converted buildings. You go from manufacturing to other uses. If you look at the sections, so Article 4, which is applicable to a fireproof building, does not contain any light and air provisions. If you go into the general provisions of the MDL under Article 3, right, every provision, particularly Section 26, every provision that talks about setbacks and rear yards and all that open space issues, it's all qualified by saying except as otherwise provided for in the zoning resolution. And the zoning resolution provides otherwise.
No, it doesn't.
It does.
No, zoning resolution doesn't apply to buildings in this community district.
That's Article 1, Chapter 5. I'm talking about MDL 26.
Nothing in the zoning resolution applies to the conversion of residential buildings in, outside of the community districts mentioned in Article 1, Chapter 5. Otherwise, it has to comply with Article 2, right, which is residence district regulations. And, arguably, then you need to cut back 30 feet from the building, or 20, depending on where we are in the district. So what you're arguing makes zero sense, because there are buildings that are designed for storage that have only windows in the staircases. And according to what you're saying, you could convert a storage building with no windows whatsoever to residential use.
Not the case. I would suggest that if you find those buildings, you'll find them in districts that are covered by Article 1, Chapter 5, but you certainly wouldn't find them in residential zones under 5231. And 5231 is the provision of the zoning resolution that is applicable when you look at the exception in MDL 26.
Long Island City, lots and lots of manufacturing buildings in Long Island City.
Absolutely.
With no windows.
Right. What zones are they in now?
Eventually, they will be in residence district zones,
Oh.
right? And so,
No?
and maybe some of
I
them
can't-
are already.
That's a supposition. First of all, and from a practical perspective, no developer is going to convert a storage building with no windows to residential because he can't market them. So it's not really a
This
practical.
building, it doesn't have legal light and air.
It has, if you've been in there, it's got plenty of light and air.
Those are lot line windows. Those are illegal
That's
light
correct.
and air.
And
They're
there's
lot
nothing in
line.
the MDL that prohibits lot line windows in this case.
I
So,
believe
I
you're
can-
incorrect. The
Well,
Department of Buildings
I
believes
can
you're
provide you,
incorrect.
I
So-
can provide
so
you with a
this-
legal memorandum to indicate that.
Right, well,
But
you
in any
had a
event,
chance to do this before, and you only gave us a paragraph that said it doesn't apply, and that was the end. So I don't know why we would be delaying a decision on this, but I think that here's the big problem. So what I'm hearing is that the owner will not be making the correction to the rear,
no,
right?
I'm suggesting,
Right?
Yeah.
That's what I hear.
Because the owner is going to argue with buildings department until the end of time that the rear yard need not be set back, which is the basis on which we would revoke the C of O, right? And so I'd like to know what buildings department and the law board plans to do about it. And by the way, a lot of this is because for all the tenants who live at the rear, it's not funny what's going on. It means cutting the rear of the building back by 5 feet, which means very likely you wouldn't be able to occupy your units, which means an easy excuse for the landlord to evict the tenants.
excuse me, let me correct it, it doesn't mean that. It
Well,
doesn't mean
then-
that.
Say something on the record that will persuade us that the
We
tenants will
don't have an
be...
interpretive appeal before us.
Right. No, we don't. MDL, we don't need to do an interpretive,
Right. No, I
If-
think,
right?
right.
But if you could speak to the.
I can speak to that, okay. In the decision of 223-15 Street Corp. versus Bassi, this issue came up, and the court determined that to satisfy that the MDL provision for the 5 foot, you don't need to shave off the building. You can take the windows and just set them back 5 feet to satisfy the light and air requirement. That was one of the options available.
Okay.
Okay, and it's also the option available in this case.
a window set back in air,
Right.
right? There's a wall around.
So if you're
it.
going
It
to set
has to-
back, you're almost like creating a terrace. That's
Yeah.
really
That's
what
correct,
you're
you're creating a
doing.
terrace.
But then that would still mean that building wall, that has to be a fireproof, new construction building wall, that has to set back 5 feet with windows. This is not just like
That have to
putting an
bear on
interior
something.
wall. It's a major construction. So I just want to make sure everybody here who are staying in those apartments is fully aware what it will intake. Yeah, they will have beautiful balconies.
But a lot of damage to the
Yeah.
units and
smaller
Right.
units.
Right.
and smaller units.
Yes, that is one option. The second option is to obtain an easement for the lot line windows. So there are options available to comply. If this board makes a determination that NDL is applicable, I say I can brief that point for you to show that it's not, and it hasn't been. But if the board is insistent upon that, we will explore those opportunities and offer a resolution.
Separate.
Excuse me.
Yes,
I'm
sir.
David Brody. I've been assisting the landlord at the law board. One of the questions that you have asked is concerning, assuming that we have to shave some of the back of the building off, what will happen to those tenants? This would not be the first circumstance on which tenants had to vacate during legalization for a portion of the legalization. And what happens if that occurs is that the tenants would have to vacate for a period of time, and upon the completion of the work, would be entitled to resume occupancy of their units.
And where would they be vacated to? Within the building and at the expense of the owner?
There is limited case law on that. The only case on record is from the Appellate Division, First Department in the mid-'80s, and there the court said that where a tenant must vacate for purposes of legalization, it is at the tenant's cost. The owner's obligation is to pay the cost of legalization, and if the tenant's vacating is a part of what is required in order to enable it, then the tenant has to vacate. As a practical matter, over the years, different owners have approached the matter differently, some taking the attitude simply that the tenant must vacate, others taking an attitude that relocating tenants within the building on a temporary basis is a resolution, and in some instances where it's going to be a short-term process, paying for the tenant to stay in a hotel in the neighborhood. But again, under the law, there is no particular obligation. The landlord is required to perform the work. The tenant is required to enable the landlord to perform the work.
Thank you. Okay, let's hear from speakers. Are there any other legal representatives? Yeah.
Good morning. Michael Kozak. I submitted a submission on behalf of a couple of units that I represent in the building. I'll just speak directly, to the, I think the central point here is the Byrne case established a standard for determining whether or not the C of O should be revoked, substantial compliance at the time the C of O was issued. The facts there, obviously the C of O ended up getting revoked. I think the issues that ended up in revocation in that case were actually much more minor by comparison to what we have here. What we have here is undisputed fact that this building was not set back. I don't see how it can be contended by the owner that there was substantial compliance at the time that the C of O was issued, and the Appellate Division, First Department having established that standard, I think it's controlling here with respect to that issue. So, the owner says that, well, maybe there was docs 3 and 4 were filed, and that's accurate. There were docs 3 and 4 filed in connection with the all-1. Those were filed in connection with an audit objections that was filed by the Department of Buildings. It's not clear, to me at least, that those were addressing, the rear setback and why they would, in any event, and the owner certainly hasn't provided any proof.
So nobody's
that-
seen these docs, so how are we talking about
Yeah,
what the
there's
docs
nothing
are?
to suggest anything about those documents. Is that accurate?
There is absolutely no proof that that was to address
Okay.
the rear setback.
And if,
Or anything else, you don't know what it's about.
I don't know what it's about.
do you remember what the, in the Bird case, what the noncompliance was?
There was issues with respect to installation of kitchen fixtures. I think it was smoke and carbon monoxide. I mean, some other, I would say, relatively minor, issues with respect to the building out of these particular units.
And how would you compare them to the noncompliance in this case?
Well, I mean, I think, I'm a lawyer, but, so I think, you look at it from an architectural perspective, I think, that these are, the conditions that resulted in the C of O revocation in Byrne, probably the kinds of things that would result in more, less onerous violations, for example. Class 2, Class 3 violations. Here, we have a rear setback. Lack of light and air is obviously a very significant issue for the Department of Buildings and architecturally with respect, to various issues affecting occupancy. So I think, it's a very significant issue. I don't think that anybody would argue that you could have obtained a C of O without legal light and air for these units, simply put. So,
Thank you.
the issues about, the law court and what will happen after, the C of O gets revoked, if that happens. I understand, the concerns of the board, about that. I don't really see them as necessary to the outcome. I do think, because again, I think the Byrne case controls about substantial compliance, but I do think that they are, at least if to ameliorate your concerns about what's going to happen if the C of O gets revoked, these units are going to have to be legalized through a proper process. And the law court is going to have the jurisdiction to make sure that that happens. The enforcement mechanisms may not be perfect, may not be satisfactory, and they may not even be as effective as criminal proceedings might be, but there are enforcement mechanisms there. The law court has enforcement mechanisms. The tenants have enforcement mechanisms. The law specifically provides that tenants can bring applications at the law court to impose fines. The law court can issue orders directing the landlord to do certain things if the landlord is found out of compliance. The tenants can bring an action in court for specific performance to perform, certain work in these units to make them legal. And frankly, the entire process of the law and the law court's jurisdiction is meant to move the process forward. And I understand that the concern that there are a lot of buildings that have gone years without compliance, but I don't think it's accurate to point the finger at tenants for that.
No, I'm not pointing the finger at tenants. It was both landlords and tenants.
That's exactly right. And in many cases, it's because the landlords simply don't want to invest, in taking care of those issues. And so, the buildings sit in limbo for many years. But I think, we actually do see here that the tenants want to take care of these issues. The landlord has, albeit belatedly, made some efforts to try to legalize, deal with some of the legalization issues that have come up. But I think, and this is what I raised the last time we were here, is, one of the things that happens during the narrative statement process is the tenants get to have a say in how their spaces are going to be legalized. And here we know, right, some of these mezzanines are going to have to come out, right? You're going to have terraces that may have to be built. You've noted that there's going to be significant impacts on these spaces. The tenants will have the ability to say, well, let's talk about how that's going to be done in a way that, minimally impacts my space. And the law specifically recognizes that the tenants have a right to do that.
With respect to that, so I don't know if you saw the last submission by the property owner we asked to see about the sprinklers, right? So there was an initial submission of sprinkler drawings that were based on the idea that the initial submission on all of those mezzanines. And so there was a lot of modification to the sprinkler system in order to accommodate the sprinklers, which have to therefore have sprinklers below the mezzanine and above the mezzanine, right? And then we inspected, that's what I was referring to yesterday. So commissioners, all the different government agencies, plus the owners, went into many units, right? And it was obvious from those visits that there are a lot of non-complying conditions, as in not code-complying conditions, right? And upon, I don't know if that was coincident with that inspection or a result of that inspection, but shortly thereafter, we get another drawing for sprinklers submitted to us where the landlord states, the improvements within the units being illegal, we've amended the sprinkler drawings, and now we're not showing any of the partitions and mezzanines in the units, and so the sprinklers are that more simple kind of sprinkler just at the ceiling, right? So I look at that and I see effectively the owner arguing for ultimately demolition of the interiors of many of these units. And I don't know whether your clients are aware of that risk to their units. And it doesn't mean that they'll get what they want in the end, other than a completely, like a plain vanilla box with a kitchen and a toilet and a bathroom.
Okay, yeah, I can speak to all of that. Those, obviously, the tenants are aware. I was present at the inspection as well. The tenants are aware of those issues. There is a process available at the law court to deal with how those issues are going to be dealt with in a way that minimally impacts on the tenants. If there are ways to modify the mezzanines, for example, rather than removing them in their entirety, that may be something that's possible based upon the tenant's comments. This is something that happens frequently during the narrative statement process, is the tenants sit at the table with the landlord and their architects and their lawyers, and they work through these issues to come up with an agreeable plan between them as to how these spaces are going to be legalized. So, the law board process is going to, I think, address some of the concerns that this board has about those issues.
Okay. I have a question, and I don't know whether you have the answer or if you do, Mr. I'm sorry. Sorry, Mr. Brody. How many of the units are vacant right now? 10 are vacant. 10. And, okay, so there are 11 units that are vacant. So it is possible to checkerboard those units while you're renovating the apartments in the rear to allow for the balcony uses. I'm just thinking of the process that would ensure that the tenants would not have to find another temporary location, because this construction can go on more than just 2 months. It can be much longer. And since you have vacant units, it's possible temporarily to relocate the tenants to these vacant units while the work is being done in the building.
It is certainly an available.
Mr. Brody, I'm sorry.
Yeah, you must speak at the mic.
It is certainly an available discussion to be had.
Okay.
In the process of developing plans to deal with the issues that have to be dealt with, that's frequently a discussion that occurs, and it finds a way to resolve it. Having just been presented with the question, I don't know what the ultimate answer will be, but certainly, in dealing with the narrative process at the law board, we will have to confront it and we'll have to deal with it, and that will include, what happens with the plans, what is the Department of Buildings willing to allow us to do, and once we have permission to do work in the building, how we sequence it and how we set it up.
I know when I was at HPD, checkerboarding was a term that we used to use. It was a very standard procedure we used to do whenever we had to address any of the violations on any of the units. Tenants would be moved to another portion of the building while the work was going on. So, and I'm sure there could be temporary measures that could be, I'm just throwing these words out there. I hope whatever outcome happens, DOB, loft board, tenants, owners, you're all aware of the most possibilities that makes it easy for everybody and livable. Easy-ish and livable, and with least amount of disturbances to everybody.
Understood. Never heard the use of the term checkerboarding before.
It's just an
but
HPD lingo.
It's something that I've been involved with in a number of buildings.
So,
It's an available discussion.
Okay, thank you. Okay, I think we go to speakers now, unless, Mr. Mistner, you wanted to add something?
Sure. So following up on that, as you know, we filed an all-2 application for removal of the mezzanines and the space below. That will, with the C of O in place, that will go through a narrative process. And as part of the narrative process, there will be those discussions with the tenants as to which of these, if any of these mezzanines can be made to comply, if there's enough height. One of the reasons why we filed the modified sprinkler plans was following the inspection that you attended. There was also DOB inspectors who took measurements of all those mezzanines, and was discovered that most of the mezzanines are neither below 5 feet to qualify as storage space, nor above 7 feet to comply with living space.
Yes.
So to the extent that those mezzanines may be modified, that's a discussion that would be had with the tenants as part of the current process with the C of O in place. My point has been, there really is no reason to revoke the C of O. In fact, keeping the C of O in place is simply a check mechanism, as this board has used in the past. I'll refer once again to East 11th Street, where there was a 2-year period where DOB refrained from following through on its revocation to allow the owner to correct whatever infirmities existed at that point. So there's certainly precedent in that case, as well as other cases, for this board to maintain its jurisdiction while we take it through the corrective process. And that includes all the corrective processes.
Okay, thank you very much. Any other speakers from the public who are not council, please? Also, are there any elected official representatives here? Okay. Please.
State your name for the record. And sign in afterwards.
You want me to sign now, or?
Sign in
After you speak.
My name is Stephen Poole, and I own Mad Art Studios, which are the art studios on the ground floor and the basement. And my project, the art studio, which I could try and make a case is the reason we're all here in the first place, because we built that neighborhood. It's been pretty easily discarded in all of this as something that was not worthy of discussion, and it was closed immediately after the last hearing. I was the first tenant in this building in 2000. I had a contractor's license. I also have a permit, a license from the fire department. I went and studied fire safety in Brooklyn, and then got that permit to maintain the compressor for the fire sprinkler system. I acted as the super for the building for the first few years by default, and sort of oversaw the new super that I recommended take over 4 years later in 2004. I've had those art studios there since 2003. They've been there throughout. They have never, as was put on my door a month ago, to close me, as one of the reasons. The violation states that I demolished 2 apartments and then built these art studios. That's written on my door. I have a picture of it on my phone if you'd like to see it.
That's what it says on the violation.
Yes.
That was,
The first violation states that I removed these 2 apartments and built my art studios. I think the implication is, I'm not sure which part of that was illegal. I believe it was the demolition of the 2 apartments.
it sounds like.
So you can understand maybe a little how unjust this all seems to me.
Yes.
I have people in that building that I care about.
I'm sorry, do you remember there being 2 apartments downstairs?
There were never 2 apartments.
There were never 2 apartments downstairs.
I have photographs of the front of my space, which I built, and before our first opening in 2004, I hand-painted like a fingerprint. Mad Arts on an interior wall set 8 feet back from the front windows. The front windows that I installed with my mother that I had taken off a project I did for Chloe in 57th Street in Manhattan. In the dead of winter, under a drop cloth in a snowstorm, my poor mother was helping me hand the windows. The plants that are growing there, like a clock on these photographs, were taken off the street in 2004 and afterwards, and there's been a garden in the front of that place behind the windows since 2004. There were never any plans, and
Thank you.
I certainly did not dismantle it. There are issues with my project, certainly nothing based on my awareness of fire safety and construction. There are issues with Mad Arts that I've gone through with the fire department and the DOB at various times over the last 18 years, last 15 years, although I've been going through that building for 18 years since I moved in there. I mean, the fire department used to do rappelling exercises off our building. We were very, very much good friends of the fire department and the Department of Buildings. But there are issues, certainly, things that could be corrected quite reasonably and fairly quickly. And we could keep open this project that is very, very important to this community and a lot of other communities. This is not just an art project. I've got letters from a mayor in the south of France where I've started an arts festival that brings together artists from all over the world for 3 weeks to work, and then exhibit for 4 days at the end of that festival. And that's open to my Mad Arts artists. 15 of those artists have come over for the last 2 years. And there are classes for children, amazing classes, that affect everybody in our community. There's this incredible woman who's taken over the kids program. I used to have days for inner city kids working with the Hispanic Chamber of Commerce, where I would work with these kids during the day and make art. Then we'd prepare the art, and then I would have the kids design a poster. We'd go print the poster up, put it around the neighborhood, and have an exhibition at the end of the day. It was a one-day program for these kids. I mean, this is the kind of place this is. There are something called Hebrew art classes that are run by Zippy Green in Mad Arts. I don't even know what that is, but it seems like a very, very popular thing. We've just had I delivered a letter from this mayor in France to the mayor of New York yesterday. He should be getting it tomorrow. It's a project that has got a huge amount of support. I've got hundreds of letters from different people, and we have a fundraising campaign to pay for legal fees to fight this. I'm not even sure where we fight it.
So I just want to kind of cut to the chase
Yeah,
about this.
yeah.
I really think that you're a victim of the circumstance
Yeah,
here,
yeah.
because you've been there for a very long time, but it's the tenants and the landlords, the residential tenants and the landlords fighting this out. And once almost every imaginable government agency came to inspect the building, anything that was a violation of code got noted, right? And so I'm just looking at the certificate of occupancy right now, and if you've been there since prior to the certificate of occupancy, then it's confusing why the C of O didn't include your use,
For
right?
10 years.
Because
Sorry.
it says use group 16, ordinary use and non-combustible storage, that wouldn't be you. It says 2 loading berths, that wouldn't be you. It says trucking, shipping, and receiving, storage, and 2 dwelling units. The 2 dwelling units obviously I think that was an error, and a clerical error, but trying to understand why, if you were an existing tenant who the landlord wanted to keep, because of course there's all sorts of tricks about how you get a tenant out, right? That the C of O should have been amended to reflect your use. So DOB is listening. I do think DOB should note that it's not believable, frankly, that this tenant tore down 2 existing units. If you went to the site, it's not believable that there were units ever in the site. So that certainly should be removed from the violation. And that to the extent that there's any kind of leniency, but at the same time, there's a lot of illegal construction down there. You know, it's a completely home-built environment that probably has lots of fire hazards in it that makes the fire department very nervous. That's, I know, the nature of sort of artist studio land, but there you are swept up into this maelstrom that's really involving others, right?
Well, there's so much to respond to, and I've gone way over my time already.
Yeah.
Combustible materials, I think there are more combustible materials in households than there are in my...
Right, but nonetheless, the fire department comes in to inspect, and the
Yeah.
DOB inspector comes in, and
Yeah.
if they see wires all over the place, and they see partitions that are not really built the way they're supposed to be built, that's what ends up happening. So I I don't exactly know how you do this work. You need to work with the landlord to agree on amending the Schedule A, really, to amend the C of O to reflect your use. And you need to work with DOB to make sure that your installation meets code, right?
Right.
So that's
Yeah.
unfortunately.
Yeah. The only other thing is, in 2003, this was the frontier. As I'm sure the DOB is
Understood.
dealing with a lot of, I don't know even how you go from that transition to people investing themselves in these frontier towns, which was kind of our deal in 2000, to make everything legal later on. But the partitions were built in 2003, 15 years ago.
Right.
They are metal strips, bottom and top, wooden studs, certainly. But, I mean,
We can't,
Right,
we
yeah.
we can't do anything about that vacate order.
yeah, I
Right.
think as I'm going down, I just wanted to be heard one time with you
No,
guys.
no, but what I would say is it would be good for you to bring in an architect who is not the landlord's architect, who knows about code and can modify your space in a way that meets code without costing you a fortune,
Hopefully
right?
we get done
And I would
soon.
recommend in your case that you reach out to the Department of Cultural Affairs. There are grants for artists, environments and studios and so on, and maybe you would qualify for one.
Okay.
That being said, we did walk through, I can speak for myself, I walked through, and I did enjoy some of the art that you guys had up. And I hope that you resolve this as.
All right, thanks very much.
Thank you.
Come to
Thank
France, because we do a great job.
I'm not sure if I'm,
Okay, other speakers, please? Please.
Moses Carpenter Management and representative of owner. Just want to tell to the board some facts which have been done through the last few years, which this building was registered through the loft board. We have started just to show to the loft, to the BSA, that we are here and ready to do anything and everything to make the tenants happy. We have filed the registration with the loft as volunteers. We didn't have to do so since the building had a C of O. We had the tenants file the diminution of service for heat and elevator. We had stipulations with most of the tenants. Everyone agreed that to the heat that we're gonna put in and to give up the rights for the elevator. We had settlements with most of the tenants, and everyone was happy that we are here and ready to do the work for them. We had dates and even installation in the agreements to do. We had different kind of work that the tenants wanted us to do, even without going through the narrative statement process, just because there was a C of O, there was a loft law, but we have voluntarily agreed with tenants to issues they raised and they want us to correct. And the only issue was, since we need to do that legally, we filed plans with the Department of Building, but then started the narrative statement process. Some issues was we had to get access to the tenants to do asbestos reports, as-built plans, and new plans, so that took a lot of time. But we have started the process of heat in April of 2017, as soon we have signed stipulations with the tenant. And since then, every day, I am on top of this, and we did everything to be able to get the heat and all the work for the tenants. They should be happy as soon as possible. In fact, last hearing, we noticed that councilmen and other officials are involved in this building. We have taken some people and we have sent emails to these officials saying that we would have known that they were involved. They told us they are involved already for 2 years, but never reached out to us to make sure that we can. They tried to help the tenants, but they never reached out to us to see how the tenants can be helped. We are here. The second we know that officials are involved, we reached out to the officials, please help us make the tenant happy. We filed plans for the heat, and we had only 3 months, not even 3 months, to do work since we have stopped various times. Most of the heating units have been installed. Might be some errors which the DOB had approved, ventilations, wrong ventilations, but as soon we have noted of this violation, there is an approved stop work order was issued on July 26. On August 22, there is already an approved plan from the DOB how to move up the ventilations up to the roof. We have acted every efficient way we could to make the tenants happy, to put the heat in before the winter, and to make the tenants happy whatever we can.
I have a couple of questions. What kind of heating system was there before the heating system broke down?
Modine heaters, gas Modine heaters.
And so it was not done through boiler or anything?
No,
Individual gas furnaces.
individual gas Modine heaters, and that's for the
Seal.
tenant. It was efficient. The tenants used it, I believe, for about 15 years, and it worked, but at that time, they asked for new stuff, and we agreed to put in new heaters for them.
Well, it's different because those are commercial heaters and this is a
But that was
residential
another
building.
issue because it's not approved for residential, but that was not the case at that time. We have agreed voluntarily to put in new heaters for all the tenants. And we have gave them various options of heating system, and we have agreed to what they have chosen. Most of the tenants, not all of them, have signed off on a specific heating unit, but most of the tenants signed off on this heating unit. And for less than 3 months that we had to do the work, with all the issues of access, most of the work we could have done was done. And in fact, we even had 8 units. The gas was turned back on. The DOB inspected the gas work and all the work we have done. And they again approved the so-called illegal ventilation. 2 inspections, actual inspections on the site with the DOB, approved the ventilation, and the gas was turned back on to 8 units, which has now been shut off again.
How do they turn the gas on to only 8 units?
Because we explained to DOB that we want to do whatever we can. We want to finish it up as soon as
No,
possible.
what I mean is, don't the gas lines run throughout the building?
Every unit have a separate gas meter.
Separate gas meter,
Yes.
separate gas line that
Correct.
runs, oh.
Correct.
Wow.
So 8 of them have been inspected and turned on, and just this weekend, another tenant, a free market tenant, moved out because they gave us access, and there was one of the first tenants that got the heat back, but they moved out now because the heat was turned back off because the DOB inspected 1 unit, which they found illegal, but shut off 8 of them, which I was at the inspection with the DOB, and specifically showed them at 1 unit, which is apartment 408, to see if everything is correct. He says, yes, everything is correct. So I asked him, why did you shut off all the units? Oh, because we didn't have access, we didn't know what's going on, so we shut off all the 8 units, even they found only 1 in violation. So what I'm trying to say is that we have done everything and anything to make the tenants happy, and we are still here. We have invested a lot of money. We have plans on everything. All our contractors are ready to come in any day, whenever needed, to get the work done. And just another thing, I'm confused as everyone with the loft issue. Emails have been going the last few weeks. We have filed, there is an approved plan on October 4th with the DOB. Again, the August 22 plan was approved, but then the DOB audited the plans. And we have sent everything to the DOB to correct the audit, and the audit was accepted on October 4th, which the DOB stamped the plan, but they can't give us the final approval and let the work go because you need law board approval. I don't know, I don't understand it as everyone, but this is the fact. Anything we needed, we need to go through the law board. We can't do anything. In fact, the permit for this building, the construction permit for this building expired on November 5th. So we just filed a renewal application, and we told the loft, please give us the permit that in case we get a date tomorrow from the loft or the building department that you can do the work, let us save another day and have the permit ready so we can do the work right away. And they told us no. They didn't give us the approval even just to renew the permit. So we can't do anything. We are tied hands. And on our ability, we did everything to make everyone happy. And this is just another fact that someone mentioned, I believe it was the DOB, that there is no cooking. I just looked it up. There is a cooking inspection back in, I believe it was in May of 2000, there was an inspection by the DOB authorized for gas cooking in all apartments.
Right, okay, thank you.
Thank you.
Thank you. Are there other speakers? There's a city council member, is that?
Elected official?
As the attorney for the.
Yeah.
Can we hear from the elected official first?
Representative.
Thank you. Buenas tardes, everyone. My name is Carlos Menchaca, City Council Member, District 38. I represent the tenants here and all the people of Red Hook, Sunset Park. I'm a member of the City Council, so I'm here to represent the people that live in the district. And I want to commend all of you on the board for your incredible thoughtfulness, investigation, and thoroughness of this application and this case so far. As you can tell, this is incredibly frustrating. It's frustrating because it's tied up in some Gordian knots that are overlapping in agencies and competing interests, which has produced a characteristic of confusion and frustration for not just the people who live there, but everyone that's associated with this case. I'm here to express that frustration, but also here to support the tenants, because in a few days, a day and a half on Thanksgiving, we're going to be seeing some of the lowest temperatures of the year so far. And that has so many of us concerned. This is not the first winter that these tenants have gone without heat and hot water. And there is a real lack of trust with everyone, including my office. Anyone who's been trying to help has failed. And so we're here really for a resolution. And the tenants at 255 18th Street will and need justice. Will get and need justice. But I believe that the loft board here, the DOB, the landlord, they do want to fix the situation. You just heard testimony that they want to, but the uncertainty about the jurisdiction has led to either inaction, or costly half measures, which have convinced the tenants that revoking the landlord's certificate of occupancy and starting from scratch is the best course of action. I have no opinion about whether that is what needs to happen. It is completely unacceptable that it's gotten this far. The board has a difficult decision to make. And I support your judgment and the process. But regardless of what the board decides, the city agencies and the landlord will have to work quickly to implement it. And I'm here to promise the tenants that I will do whatever is necessary to make sure that the board's decision and the decisions are carried out and that the heat and gas and hot water is restored quickly as possible. Let's not let the jurisdictional question diminish our sense of urgency to restore heat and hot water to these tenants. They deserve to be in this space. These are folks that I know and have done so much for the community as well. We're here to support not just their livelihoods, the kids, there are many kids in this building as well, and who they are as Brooklynites, as people who live in the district, as New Yorkers. Thank you so much for your time, and I will leave it at that.
I have a question for you.
Sure.
If the board did not revoke the C of O, and it stays with the buildings department and whatever its bizarre process is with the law board, will you work with those agencies to move this along, however it is that you're able to do that, understanding that you're not one of the administrative agencies?
And you're very right about that. I am not one of the administrative agencies. I'm here to represent people that have, that you have, and you'll continue to listen to today. I will do everything I can to restore the quality of life for these tenants. And my team is here as well, my staff is here, so I'll do whatever you all decide. I think you're hearing from the tenants what they want. They want removal of the C of O. And I know how complicated this is, and so I'm not the expert here, but I know that we need to restore the quality of life as winter approaches, and that is what I'll continue to do. Whatever decision you make, I'll still be on the side of the tenants to make sure that they get what they need and deserve.
Thank you.
Okay, thank you.
Thank you for coming.
Any other questions?
Thank you.
Thank you so much.
Other speakers? Do you have something to add? Because we want to move to other
Just two
speakers.
things. First of all the tenants has hot water. It's only about the gas. Second of all, the tenants keeps on saying, I don't want heat, I want the CO revoked. I want to give them heat, I want to give them a place to stay and be fine. They don't want heat. I want the CO revoked. In fact, one of the tenants in the letters that they sent to the building departments, they said, no work should be done until there is a decision of the C of O. And this tenant, in fact, has heat. There is one tenant in the building that has heat, but the fact of the matter is, we are here to help, and the commissioner asked before about if there is an issue with the back wall, if it would allow changing with the vacant units. I didn't speak to the owner yet, but as I know them, the new owners, which have took over since last year, they will do everything and anything to make the tenants happy. So I can guarantee that we'll work with the tenants to make sure everything that needs to be done will be done.
Please sign. Please
Any
sign.
other-
Sure.
any
Other speakers?
Yeah. Any
Other
other
speakers, please come up and you can sign in afterwards.
Hello, I'm Jim Glazer. I've been in the building since 2004. I'm in a back corner of the building, and just have a couple of comments, some fact-checking. So, number one is, my understanding is that there's only 9 apartments that are specifically on the back, because a number of us are on the back corner. terms of-
There are lot line windows on both sides.
But if you're on the corner, you don't necessarily have to have the back cut off.
You need to have a legal light and air from one of those sides. So you pick your corner, you pick your back.
Got it. So what I'm saying is that the corner apartments have legal light and air, even if we have to
No.
brick over the back windows?
No. Your lot line windows, so your windows on the side fall right onto the property line. Those are not legal light and air windows.
Okay, well, on my side, apparently, we're on the side that the landlord owns the building next door to us.
Well, if that's the case, then they can give
easement.
themselves an easement, so that could work, yeah.
Yeah, so I'm just thinking that the easement angle is probably more workable. Also, when I first, under the first attorney, after our first tenant association meeting, he came up to the roof with me and just looked over the back, and number one said he doesn't believe any building permit would ever be made in the backyard of within 5 feet, and just the ability to get a construction equipment into those backyards.
That's not what the rule is. The rule is that you have to have a distance from your back lot line to the back wall of your building to provide legal light and air. And unless you have an easement with those neighbors to the rear, you don't solve that issue.
Okay, well, it just sounds to me like the easement might be the fastest way to get this done.
Right, but that's if you have to be willing to sell those neighbors have to be willing to sell, right?
Well, just based on the fact that it'd be almost impossible to get a backhoe in there, I'm sure those landlords would be happy for free money. So anyway,
Maybe.
just pointing a couple of things out here.
Time to reach out right away.
Number two, I've been hearing that, I heard earlier, a 1 minute on a dry sprinkler system. I've been also hearing that it's a lot longer than that, up to 15 minutes. So it's not, it sounds somewhat dangerous, and I'm not the expert, but I just heard a conflict there. But lastly, as a community organizer and an activist and an artist, I just want to stand up for Mad Arts and the fact that this is an amazing building in a really cool and upcoming neighborhood. And if there's any way to get the artists downstairs back into the building, I would be very much in favor of it. It is a cornerstone of the art walks in the neighborhood. Artists make neighborhoods more interesting. They raise property values. And I was just so happy when we became the Mad Arts Building. I still call it the Mad Arts Building. I am proud to live there. And if we can work together, if we have to work separately, I will be the community organizer that I am. I will help build things. I will hump stuff up the stairs. I prefer the elevator. But just know, there was also a comment made earlier that there was an agreement on the elevator. There wasn't a full agreement. I always wanted the elevator back, and most of the people that agreed that the elevator could go away were the first people to bail out and leave the building. So we all know what we're dealing with here. There's a lot of legalese here, but there's a certain breed of landlord. I mean, apparently, some people in the highest end of power in America now are the same type of landlord. They won't do anything until there's a legal threat. So Thank you so much for helping with that and providing the pressure. Like I said, I'll work with anybody to get this done. We are exhausted living without heat and just the stress of hearing that neighbors' electrical has left fire stains on walls. It is just unnerving. And thank you so much for caring about us. It gives us hope that truth and justice might still be alive. Thank you.
Next speaker, please. And you're limited to 3 minutes. When you hear the buzzer, please.
Wrap up.
Yeah.
Good morning, Commissioners. My name's John Peachy, and I'm representing at least one of the tenants in the building, and possibly more. The landlord says he wants to make the tenants happy, but he files an application to remove all their mezzanines. If the building was the subject of narrative statement conferences, there'd be a discussion about what mezzanines could stay and what could be done to make the mezzanines legal. Even in the unit that we visited that was controlled by the landlord, there are substantial mezzanines and platforms. In terms of Article 7B, the plans clearly identify the legalization of this building pursuant to Article 7B, and it quotes section by section the first 10 paragraphs of Article 7B, including two of the paragraphs that say wet sprinkler. They drop the word wet from the notes on the drawings. The Article 7B notes are very abbreviated and stick to the essentials. But if you take those points paragraph by paragraph and go back to Article 7B, you'll see the requirements for the wet sprinkler in the commercial areas, the buildings, and stairs coincidentally serving the residential and commercial. The rear yard issue is part of the 7B notes, the 277.7, which is on the drawings. A lot of the wording on the drawings, on the drawing that I retrieved from the building department is obscured. Some of it's obscured by the approval stamp, but the underlying code is still there. And that establishes the requirement to comply with 277.7 B1 and B2, which require the 5-foot space on the property and 15 feet on the adjoining rear yard. To me, it's a tremendous fraud that the back of the building wasn't altered pursuant to the drawings. The drawings are detailed. It's absolutely clear on every floor, cellar through 4, that those cutouts had to be installed.
Please wrap up, but just before you do that, where does it require the wet pipe sprinkler? What section is that?
It's 277.1A, and I have the drawing here. And 277.4.
No, so I'm actually looking at 1A that says that a wet pipe sprinkler system with spacing of 4 feet must be provided along such walls to protect exposed, unrated columns or beams at the interior of the wall in non-fireproof buildings. Isn't this a fireproof building?
This is a fireproof, this is
So
a fireproof
I didn't
building.
find it in that one. Is there another?
Actually, it's perhaps in 1B. On the drawing, it says building to be sprinklered. And, you know. it's a-
Well, the building is sprinklered. So I'm just,
Yeah.
I just don't know where it requires that you go to wet pipe.
Well, I think he dropped the word wet on
Well.
1B and in the paragraph 4, manufacturing purposes, and then he says to be sprinklered, and he dropped the word wet from that.
Well, we don't know if he dropped it. It just says sprinklers.
Well, if you go to Article 7B and read 277.4, I think you'll see that the word wet is dropped from the
Now, it
notes. because
says, all areas occupied for manufacturing or commercial spaces shall be protected by an approved wet pipe sprinkler system. Such wet pipe sprinkler system shall extend to include hallways. But this isn't manufacturing or commercial.
The cellar and the first floor are commercial.
Well, but that's not what we're talking about. We're talking about the upper.
Well, that was part of the danger.
Well,
that
if
there
we're
was a
just
dry
talking about,
system.
if we're just talking about the wet pipe system for the cellar and the first floor, that's even more easily correctable, right? I thought we were talking about wet pipe for the whole building.
Well, and when they let their permit lapse and and it had to be reinstated, then the building department should have enforced compliance with the requirement to sprinkle the entire building, which came into effect in 2000.
In 2000.
Yeah. A building containing 4 or more apartments should be entirely sprinklered. So I've been caught in these situations where the building department says, comply with the code, comply with the 2014 sprinkler code, just because I'm reinstating. So that was a giveaway to the owners, not to force them to come up to the latest standards of the code. As I go through that building, even though there's no sprinkler filing, the hundreds of heads have been replaced without a permit.
Okay, so that's a different subject. We're just focusing on wet.
I'd like to just address the 2 apartments that weren't there. When those 2 apartments not being there has an implication on ADA requirements, which state that that primary access should be provided to the lowest residential level. So that would be the second floor if the apartments never existed. And then in a building over 10,000 square feet, and that's the building, not the floor, a LULA or limited use, limited access elevator serving 1 floor is not possible, and you have to go back to the elevator.
And there's no elevator.
The plans state there's an elevator toward the end of the alteration of the building, just for the C of O, the elevator was dismantled. However, when you look into the elevator machine room, the motor's there, so it looks like a partial dismantle for this elevator.
But was the elevator required to be operating for this project?
Yes, without those apartments on the first floor.
Just without the apartments, otherwise?
Putting an apartment on the first floor is a
No, I understand, but my question
technique.
was the elevator required as part of the project independent of those apartments, those 2 apartments?
Yes.
It was required.
For local law 58 of 87.
If those two apartments had not been built, would you still, let's say, if those two apartments had been built, would you still have needed the elevator?
No.
Okay.
I think that was, the only way that elevator would have been required if it was a diminution of use and the tenants filed the case with the law
That's a
board.
different thing. I'm talking about building code.
Yeah, and I'm totally supportive of a revocation of the C of O so that the law board takes control of the legalization process, and it would give the tenants the right to withhold rent if the building is not in compliance. And that is a major incentive for a landlord to quickly complete the legalization process.
Thank you very much. Thank you. Next speaker, please.
Hi, I'm a little nervous just because there's so much information.
You know us all
flying at
already.
Yes.
You
And I'm just trying to make the points that haven't been made.
State your name for the record.
It's Kimberly Mongello. I'm in Unit 309. The reason we formed this group as we are now is because we continued to pay rent and live in a building. And one day, we were served papers that said they demanded an 18% increase, which came with their certificate of occupancy. However, they did none of that work. So I dealt with an ice wall in my apartment. I wrote them 3 certified letters trying to get them fixed. They came into my apartment during this time. Nothing was done. We did reach a settlement with them. Nothing has been done from that settlement. They said that we are happy and that they have done everything that they can, and it's just not true. If we get the C of O revoked and we are put into the law board jurisdiction and have the narrative statement to sit with them, they can do the work and we will be a part of that. That was never granted, but we were expected to pay for it this entire time, the 18%. Does that make sense? The services were taken away when the C of O was actually put into place. The trash room diminished. They changed the trash room. We had no super. We were still with commercial heaters. And the C of O was this piece of paper that said all of those things were actually done. And then everything went away. Before the C of O, we could talk through things and make things happen, but they were granted a piece of paper that told them that they already were in existence. And then we got stuck in a black hole of the bureaucracy going in circles trying to make it work. So it's really upsetting to hear that they are doing everything now. We've been fighting for 5 years. I'm literally shaking because it has been so hard to educate ourselves in the right, because all we want to do is live there and be safe. And we took a risk for challenging the C of O because we know, as you saw, I have a mezzanine. I am very full aware that that could go away, that I am also in the back, I'm in the corner. I am very aware of this. But if we were to exit the law board jurisdiction into the rent stabilization out of law board, that means all of those issues don't exist. It means that those were all approved as well. So now we have to go into housing court, go into HPD, go into all these avenues and fight again and say, well, why is it like that? Why do you have commercial heaters? Why don't you have heating that's correct? Why don't you have light and air? Why don't you have ventilation? Why don't you have these things? And we thought, and through our representation with our architects and with our lawyers, that this was the right avenue because it gets us back into being able to negotiate with both parties. We would like to sit in a room with the landlords and with our lawyers and with architects and actually live in this building legally. That's all I got.
Thank you, guys.
Thank you. Perfect. Please sign.
Next speaker, please.
Hi, Dr. Christopher Brown, Apartment 206. Good afternoon, Chairperson and esteemed members of the board. I spoke last time. First I want to start by saying Pam and I, my wife Pam and I, have been in this building for 13 years. And I stand here in absolute, committed, and emotional support of Mad Arts Forever. because I'll tell you just a quick story. The day we moved in, which was almost exactly 13 years ago, December 2nd, there was actually a studio opening that night. And so when Pam and I moved in, our bell rang, and there was Stephen and Peter inviting us downstairs to meet the wonderful artists and all the other tenants in the building. So I met almost everyone in here as a tenant. Most everyone here I met that night, the first night we moved in. I mean, that made such a big difference to our being in that building to this day, 13 years later. So I do want to thank Stephen for bringing that to the community, and I really support the vacate order being dropped as soon as possible, safely, but as soon as possible. So I just have I sort of pressed on an issue last time I spoke, and I want to press on it again, but it has to do with the enforceability and enforcement of these issues to the landlord. They haven't, and even if they bought it a year and a half ago, in that year and a half, they haven't done anything. And if they did any due diligence in buying this building, they would have known what was going on and the violations attached. If criminal actions can't be taken, which would be a lot of teeth, you would think that $130,000+ worth of violations would be enough. One of them being $25,000, a Class 1 violation aggravated, that is very recent, probably within the last year and a half, as a matter of fact. You would think that that might have something to do, or you might think that that might compel. I get a $65 parking ticket, and I'm afraid my car is going to get towed, and I get anxious and I lose sleep. These guys have $130,000 worth of violations at the DOB, and they're going around saying how much they love us and want to help us. Time and time again, they haven't. And and Pam and I happen to have the apartment with the wonderful heat. They're glorified space heaters. We went down to Home Depot and got 3 baseboards. 2 of them were given to us as gifts. That's our heating, and that's very expensive heating. So that's the heating that because we didn't want them drilling through our walls. That is a beautiful building. Mad Arts is a beautiful building. Macaulay Building is a beautiful building, 1905, and they're destroying it by drilling through front walls, drilling through elevator shafts that should be working elevators. They're destroying this beautiful building time and time again. So Pam and I decided not to let them in our apartment to drill through our walls and apply this cheap heating system. That's why we now pay $1,000 a month to have baseboard heating. Thank you. Okay? Thank you. And there's a boiler in the basement. That whole building needs to be heated. The hallways are freezing as we speak. You could actually use the hallways as a refrigerator right now. You could, literally, use the hallways as a refrigerator. So apartments are one thing, hallways another thing, and a wet system is absolutely essential. We're looking for safety. We're not looking for what Marvin mentioned last time, some type of financial gain here. We've been there 13 years. We love that building. We want to be there. It's our home. You saw our apartment. You toured our apartment, 206. It's beautiful, but only because we did that. And the only reason this building is even standing today is because Steve and Paul and Peter, who's not here unfortunately, and a bunch of us actually got together. Every time there was a flood, we did it. The landlords were vacant. There were floods. There were things we had to go with towels and buckets, all right, to keep that building standing.
And just answer a question.
Okay.
If, as part of the narrative statement process, there's a requirement that the landlord enter into your apartment to do work, otherwise it's going to hold up the signing off of the narrative statement, will you allow them to come into your apartment to do work?
Absolutely. We need to have a justified reason for that.
What
we've always done.
What if it's work you don't like?
Well,
What if the tenants agree to a narrative statement, you don't like what they're going to drill a hole through
Then
your
we'll
front?
negotiate that narrative statement. That's the purpose for it, isn't it?
Sure, but it's not everyone, not every single tenant is going to agree to it.
I can't speak for every tenant, but I know them pretty well, and I believe that we have a pretty good consensus. I can't speak 100% consensus.
No, but let's just say the
but pretty large.
proposal is to do something that you're not so happy with in your apartment.
Then we would go back to the negotiating table and negotiate.
So you
that.
wouldn't do it?
No, we would do it.
Eventually.
Well, we would do, okay, we would do it if it made sense. I mean, if someone came in and said they wanted to plug a hole through the back
So,
wall,
all right.
I'd say no.
So you're one of the rear units, right?
Yes.
You're not a corner unit. In order to create the required light and air for your apartment, it's
Yeah.
going to require
There-
some significant
Yeah.
demolition. Will you allow that to occur in your
Absolutely, and I
apartment?
love the thing. I actually wanted to get up here to make that recommendation that there are plenty of vacant units in that building. We could move right
No,
across the hall.
but my question is, they're going to
yes.
damage your unit?
Yes,
Okay.
absolutely. we would, because
It's
that would
gonna
make
make
it
it
safer.
smaller.
Excuse me?
It's also going to make it smaller. You're going to lose.
It's going to make it about 5 feet smaller, yeah.
Well,
But it's a pretty big apartment
by
already.
the width of your window smaller.
Yeah.
We're okay with that. We love the neighborhood, the apartment, and so on and so forth.
Okay.
And just to say that the last time we were requested access, we went to our attorney to get advice, and I think she gave us good advice, was to get a rationalization for this entry, and they never gave us a good rationalization to that entry. And then when they did submit the plans, they were bogus according to the architects and such in terms of the heating, so we said, nah, we'll continue to pay our $1,000 a month until this is resolved. But yes, we would allow for any work that was safe, made sense, strategical, was written out in a narrative that we had an opportunity to sit down with.
Okay, thank you.
Thank you.
Are there other speakers?
Good afternoon. My name is Ruben Kalish, and I'm a code and zoning consultant for the landlords. And I would just like to explain a couple of issues of items that were filed at the Department of Buildings. Here's what happened. I came on board over here to advise them for the last month, no, more than that. When I reviewed the sprinkler comments that were issued with the Department of Buildings, which is right now in disapproved status, the Department of Buildings wanted two things, mainly. One is for the law board to give the sign-off on it in order to go ahead to proceed with the narrative statement, which starts during the approval process. Number two, the Department of Buildings has requested proof of a lot of items that are in there that are not listed on the CFO, for example, mezzanines, and etc. I went down to the building at one inspection with them, and I advised the architect of record for the owner that there are a lot of issues that I see that do not meet with code and zoning requirements, mainly about the mezzanines not having proper clearances, being built of combustible material, which is not allowed, not having sufficient sprinkler coverage, not having sufficient light and air, not having minimum legal dimensions. As such, we went to file ahead with the Department of Buildings 3 separate applications, which are basically, from the way we look at it, what the code will require for that to be removed. Of course, that does not mean that that is what is actually going to happen, because the Department of Buildings is going to send us back to the law board. That's when they start the narrative process, and that's when they would come to a conclusion of what needs to be done, what does not need to be done. So right now, we filed an application to remove the mezzanines because we deem that it does not have sufficient legal standing to remain. If the tenants will come up with an amended narrative to say that we want to keep it, but it will be legal, then that is going to be amended. The same thing will happen with the sprinkler system. They went in there are mezzanines in there. They require coverage. But the Department of Buildings is asking us proof of existing conditions, which is not on the Schedule A, which is not on the CFO. So automatically, they're intertwined all together, one with another. In addition to that, there are also some handicap issues, which Mr. Peachy has noted about the elevator. Right now, there's no elevator in the building because it was dismantled. There's no elevator requirement in the building at all because it's only a 4-story building. The only issue is for primary handicap access. There are right now 2 dwelling units legal to the first floor, which they have to reconstruct. And that would,
Reconstruct?
the 2 dwelling units are the first floor. Once they
Use the word reconstruct?
or constructed traditionally.
let's
Okay,
just
let's
say
use that. Okay,
construct.
to
Let's
construct
be
those 2
honest
dwelling
here,
units,
please.
that will serve
Okay.
the purpose of providing a full handicap access unit. In addition to that, if they will not going to be able to construct that, they will be able also to provide the Lula elevator because they are allowed for all code buildings as per BC 1109.6 for prior code buildings. So I don't see that as the main issue. The main issue, what I see is that the law board, in addition to having compliance methods for code requirements, they also have additional issues, which are diminution of services or other stuff, which has nothing to do with the general building code requirements, and that is why the biggest problem is here, because the law board has enforcement mechanisms in addition to what the general building code will require.
Thank you very much. Thank you.
That's it.
Other speakers?
Calling once, calling twice.
One other speaker?
Hello, Madam Chair and board members. Jessica Ranville, 402. I just wanted to quickly address something that I heard you all talking about at the review session yesterday, which was your concern for the tenants, which I truly appreciate and am heartened by. You had been concerned that if you revoke the CO, that we may all be evicted, but I don't know how clear it was made when we were speaking about the loft board that the loft board covers tenants in regards to eviction, from what I understand. And I really, I'm not an expert, but I would love to defer to anyone in the room who is more of an expert on that law, because I feel like that's a very important point that has not been addressed in terms of your concerns.
Okay, thank you very much. Okay, I just have a question for Mr. Mitzner. Mr. Mitzner. Okay. So you mentioned getting an easement for light and air from one side and from the rear. Have you looked into that at all?
I don't know if the owner has, but we certainly will look into that.
You haven't done, my question was, have you done it so far?
Not to my knowledge.
Okay, all right. Any other questions, comments from the board?
I do have one question from the law.
Speak up.
I have one question for the law board.
Could Deputy Counsel?
My question is as a follow-up to the question that was asked with regards to if it's revoked, what is the assurance law code gives with regards to tenants continuing to stay in the building while the work is going on? I said in the building, not in the unit. What authority law code has to ensure that they're not evicted or they're not asked to move at their own expense and for the work to happen? How does law code ensure that?
The loft board, in the loft board's rules, there's nothing in the loft board rules that says that the owner must pay or anything like that. But there, as Mr. Brody testified, it is true that the loft board is active and engaged in trying to reach an agreement, and we've done so numerous times. One of which that I know the owner paid a significant amount of the rent where the person was staying, paid for moving. I mean, there was, and the loft board was instrumental in coming to that agreement.
So you may not have it in their requirement, but you do, based on your cases?
We do encourage the parties to negotiate, yes.
Okay, thank you.
Okay, any other questions, comments from the board? Okay, I'd like to make a motion to close this.
Chair Promoter?
Aye.
Sorry,
Oh, sorry, the DOB want to speak? Sorry,
I'm
maybe
sorry.
not. Close.
So I'd just like to wrap up quickly, and I believe that Loft Board, although they just spoke, would also like to read a brief statement into the record. But first, I'd like to say, the owner and their representatives have said here that they want to do this work, and whatever legalization work is necessary. The Department of Buildings thinks it makes more sense to do this legalization work under an Alt 1 application that would allow the work to happen in one cohesive application. Secondly, a board member mentioned earlier today that revocation turned on incurable errors. I'd like to just clarify that revocation of a CO doesn't come down to incurable errors. That's not the standard. As announced in Byrne, the question is whether there was substantial compliance at the time of issuance. Third and finally, before I wrap up, if the board denies the department's application here, it will amount to a rubber stamp on an erroneously issued CO. It will allow the owners to take advantage of the CO despite their delinquency and legalizing unlawful conditions at the building. This is the same owner, I want to add, to whom the chair referred as a scofflaw at the October 10th executive session. It would be bewildering to me if, after repeatedly expressing mistrust in the owner's intentions, the board allowed the CO to remain intact and placed its faith in the idea that the owner will carry out the necessary work of its own accord. Thank you.
Thank you. Oh, did you want to speak too?
He represents the
Okay,
the owner.
yeah.
I'm sorry.
Who are you representing?
I represent the owner, Stuart Klein, Slowick. We'll do it now, or?
No, you can sign in later. Just go ahead. We don't have to swear.
Both Mr. Brody and Mr. Minster are superb attorneys, so I did not see the need to speak today. However, I'm a bit disturbed with regard to what appears to me to be a rather schizophrenic approach to the application of law here by the Buildings Department. The fact of the matter is, they have the obligation to keep the plans. When these plans were filed in 1999, as of 1995, 2 copies had to be made. One was kept by microfiche in the borough, one was kept in Queens. I don't know if they ever looked in Queens to find the subsequent plans, but they have the obligation to keep those plans in perpetuity, both under the administrative code and the city charter, number one. Number two, the law was changed decriminalizing the building code and allowing most of the violations to go over the ECB in 1987. The purpose of that was to have the criminal court reserved for the more important violations. In fact, criminal court is used to enforce local law 11 violations and local law 5 violations. And the sole purpose of having cases go over the criminal court is to make sure you get compliance, because under the sentencing process that goes on in criminal court, you get a conditional discharge, and unless you cure or correct the condition before the expiration of the conditional discharge term, then you're subject to penal sanctions. So yes, you're correct, it is the proper approach to take. And the final one is, there are at least two buildings that I'm aware of off the top of my head. One is 38 Delancey Street, which has structural issues dating back to 2007, real structural issues that required it to be joined with the building next door through C channels, and Musler Rutledge pump in additional grouting into the foundation in order to keep both buildings erect. Yet the buildings department has issued, despite that ongoing violation, 31 consecutive temporary certificates of occupancy for that building, which is a 16-story building with over 100 apartments. There's another building over at 89 Barry, which is a 21-story hotel with over 300 rooms that also has serious, very, very serious structural issues that's been given approximately 30 consecutive TCOs while those violations have been outstanding. So the issue about the C of O here has to be revoked based on their policy is completely untrue. And with regard to Mr. Radusky's filing back in 1999, at the time you were allowed to file art studios with 3 fixtures. That was subsequently changed by a memo that came out of the Brooklyn Borough Superintendent's Office that reduced it to 2 fixtures. However, it's been the policy of the building department and by most architects and engineers in the city, when you're going to change the use, to do the work under an alteration type 2, and then subsequently put in an alteration type 1 for change of use. This is before the board in every single physical culture establishment permit. The work is always done either under a Use Group 7 application or a Use Group 6 application for Rehabilitation Center. A Alt 1 is then put in for no work change of use. There's nothing unusual about that, and there's nothing unusual about that in this particular case. Thank you.
Okay, we're done.
There is one of,
Oh, okay. Law Court, sorry. Ms. Cruz, I'm sorry.
I'm here to inform you that the New York City Law Board supports DOB's application for revocation. On November 15th of 2018, the members of the New York City Law Board voted unanimously to support DOB's application. Section 282 of the Multiple Dwelling Law established the Law Board and charged it with overseeing the conversion of interim multiple dwellings from commercial and manufacturing use to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B. To achieve this goal, the Law Board adjudicates and mediates disputes between owners and tenants in the narrative statement process, tracks the progress of each of the buildings undergoing legalization, and prosecutes parties who violate the law and the Law Board's rules. Now turning to the specifics of 255. In February of 2014, after the DOB issued the residential C of O, several tenants applied for law coverage. In January of 2015, the previous owner filed a registration with the Law Board listing 25 IMD units. Pursuant to Section 208 of the Law Board's rules, the Law Board accepted the registration. This rule provides that the building does not have a C of that does not have a C of O on the effective date of the relevant law, the building can still be registered with the Law Board. Based on the owner's registration, the tenant's applicants withdrew their coverage application, and the Law Board subsequently accepted the tenant's withdrawal of the application. In December of 2015, the building owner filed for removal from the Law Board's jurisdiction based on the residential C of O at issue today. This removal application is still pending before the Law Board. On January 4th of 2017, several
before you go on with the rest of that, the tenants applied to remove the application from the Law Board.
No.
You accepted it.
No. the owner filed a registration application to register the building with the loft board.
Yes.
And the owner subsequently filed a removal
No,
application.
I'm talking about the tenants. You said the tenants filed to
A non,
withdraw their application.
their coverage application based on the owner's registration.
So in other words, by the owner filing, the tenant's filing wasn't necessary.
Exactly.
Right, because you then become covered.
On January 4th of 2017, several tenants filed an application with the loft board seeking a finding of non-compliance with the legalization deadlines in the loft law. However, because the building had a residential C of O at the time that the tenants filed the non-compliance application, the loft board staff rejected the application. In its correspondence to the applicants, the loft board staff explained that pursuant to Section 645 of the New York City Charter, the C of O is conclusive on the issue of code compliance. The C of O is binding on the loft board, and the loft board lacks the authority to consider any code compliance issues. Should the BSA grant DOB's application and revoke the C of O, the tenants would have meaningful input in all of the work necessary to obtain a new certificate of occupancy. The work filed in the alteration type 1 application that could be reviewed by DOB plan examiner and the tenants. To the extent that there's concern about the length of the narrative statement process, it is not accurate that the process will be endless, nor that it will take decades. As I described earlier, if the consensus is not reached on the legalization plan, the loft board can and will initiate an alternate plan process detailed in the loft board rules. The tenants will have an opportunity to present how the owner's plan would unreasonably interfere with their use of the unit or diminish their services. If tenants do not raise factual issues, then the hearing is not necessary, and the loft board staff can issue an administrative determination to resolve the tenants' claims. If the tenants do present factual issues, the case will be transferred to the Office of Administrative Trials and Hearings for an expedited hearing. After the oath hearing, the ALJ will issue a report and recommendation, which the loft board would also consider on an expedited basis. If the BSA denies DOB's application or otherwise leaves the C of O in place, that action would drastically limit the loft board's authority over the building, including compelling the owner to legalize. The loft board's enforcement power will not be available. The loft board's rules require that an owner of an inter or multiple dwelling take all reasonable and necessary action to obtain a certificate of occupancy for the residential portions of the building. If the CO is permitted to remain in effect, the loft board may not bring an action for failure to legalize. Moreover, if the certificate of occupancy is allowed to remain in effect, there's nothing further prohibiting the removal of the building from the loft board's jurisdiction. There's already an application pending. The loft board's only responsibility would be to set the initial legal regulated rents of the units that are still subject to rent regulation and remove the building from the loft board's jurisdiction. Thank you for the opportunity to come before you today. I reiterate that the loft board supports the revocation of the CFO so that the tenants would have a full opportunity to be heard on about how their units will be legalized and how their lives will be affected by the work, without restricting the loft board's authority over the building owner and the building. Thank you.
You said something new that we didn't hear before.
Okay.
You said that if the board doesn't revoke the C of O, the loft board will have no alternative but to issue a closing letter or whatever it is. A what?
The term is a final rent order.
A final rent order, and then then the loft board has no further jurisdiction. I don't understand that. So then you're saying if we don't revoke the C of O, your hands are tied, you can no longer pursue this narrative statement process?
What I'm saying is that if the board leaves the C of O in place,
yes,
and the owner withdraws all of the applications right now that it has before the Department of Buildings, there's nothing that the loft board can do. The C of O is...
please don't speak while she's giving testimony.
The C of O is in place and it has full force and effect.
So what you're saying is if the landlords withdraw their alteration application?
Yes.
But as long as you have alteration applications, the loft board can review those things?
Yes, while the building is still covered.
But they can't do anything with it.
Right, there's no enforcement. There's nothing if the owner voluntarily goes through the process, then the loft board has jurisdiction. If the owner does not, there's nothing that the loft board can do to force the owner to legalize.
Thank you.
All right, thank you, yes.
Yeah. If this CFO was temporary CFO, would the situation be the same, or would that change?
If this were a temporary C of O?
Yeah.
It would be a different situation.
How different?
How different? Because the loft board would have, the loft law requires that the owner take all reasonable and necessary action to obtain a residential C of O. They haven't achieved that goal if they only have a temporary C of O.
So that means loft board will still have enforcement mechanism to correct all the violations and issues?
Yes.
If there's a TCO.
If it's a TCO.
If it's a TCO.
You would, it would basically like, I guess, if it's a TCO or no CO, loft board has the same set of enforcement power.
I would say yes.
Yeah, but hypothetically, because there's also, if, on a temporary C of O, at that point, the loft board would consider that the tenants are in compliance. The tenants would most likely not have to, in a temporary C of O, the tenants would be having to pay rent. And one of the things that makes compliance happen, makes changes happen a lot more quickly is the incentive a landlord has to receive rent. I'm not sure if I made that clear.
No, it's good enough. It's fine. Okay.
Thank you.
Thank you.
All right, thank you. Okay, did you want to add something? Then we're gonna.
I disagree with Ms. Cruz's statements concerning the process of the law court's jurisdiction. This is a significant part of my practice. I'm both a litigator as well as dealing with the law board. If I believe that the law board did not have jurisdiction once the CO issued, I would have brought an Article 78 in the nature of mandamus some time ago. The law board told me, and both the prior director and the current executive director, very simply that until the problems are solved, the law board has jurisdiction and a final rent order allowing us to go to rent stabilization will not occur. We have acted in accordance with a belief that that is a proper instruction. MDL 280, which is the first piece of Article 7C, doesn't just talk to the obtaining of a certificate of occupancy as being the sole direction. It also talks to the need for there to be safe housing. And within that context, the law board's regulations don't merely provide for legalization. It also provides for minimum housing standards along the lines of what the HPD regulations provide, also provides for a mechanism of findings of harassment, and there are enforcement mechanisms with all of that. Now, if the certificate of occupancy is revoked, then it goes back to step one. A full set of plans needs to be filed with respect to this building. Now, if the law board is going to stand here and say how fast the process is, it isn't. I've been doing this for 38 years. I have one building that managed to go through an entire narrative process within a year, and that's with the landlord basically beating on his lawyers, beating on his architects, and beating on the loft board on a daily basis. And that's it. You know, generally, buildings take 2, 3, 4 years from the time plans are filed until the times that they are certified, such that a landlord can pull permits and start doing the work. So, revoking the certificate of occupancy, I do not see that as being particularly helpful to the process. We have a number of applications are pending, and we are committed to them continuing through that application process. So with respect to the heat, we filed a separate narrative statement for that. If the law board is suggesting that the C of O be revoked, is it going to also suggest that there has to be within the narrative statement process that included so that the tenants are standing without proper heat for a period of years? I don't think so. What we have done is a practical approach to a series of problems. Right now, there's a narrative statement pending for the heat. The law board has actually said to the tenants, you know, here are 3 dates. Can you do any of these 3 dates? And they had problems with those 3 dates. Admittedly, one of them was supposed to be for today, so it's an obvious problem. And then they came back to the tenants, and they said, do you have other dates that would be good for you? And I see a series of emails going back and forth about it. And the only tenant who suggested, I'm available anytime, was Mr. Glazer. We're ready to sit down and work out the heating system right now. But there has to be a forum. And yes, the tenants do have a say in all of this. With respect to the mezzanines and the sprinkler system, we've got to file a narrative statement with respect to that. And that will have to be dealt with. With respect to what happens to these studios, yes, that may not be a narrative statement issue. That may be, a working out of what has to happen with that space in order for it to come in again. Because the loft board may or may not require a narrative statement for that. They may go by a letter of no objection approach, which is a somewhat less formal approach. But at the end of the day, with a certificate of occupancy, we are committed to doing, well, we're going to have to do it regardless, but with the certificate of occupancy in place, we are doing narrative statements that deal with individual issues, rather than a whole narrative statement that deals with every available issue. And without regard to how fast we want to go, we'll drag on for a period of years. Thank you. If you have questions concerning that?
I do have a question for the loft board representative. If we were to revoke the C of O, and this would go fully into your jurisdiction again, how long until, is there an expedited resolution with regard to the heating? Is there something, because it is already very cold, so is there something that can be done? How long would it take for the heating issue to be resolved?
I can't give you an exact time.
I'm not asking for,
Well, all I'm saying.
I'm not going to hold you to it, I
Right.
need.
All I can say is that right now, the loft board, what we're contemplating is that right now, what's before the loft board is an amended application. It's possible that the loft board will issue a 40-day clock.
A 40-day clock?
40-day clock.
Well into winter, well,
Well into winter, yes. If we're not able to get a date by when parties can come together, we can then issue a 40-day clock for the tenants to submit comments, and then possibly at that point, maybe come together. I mean, the problem is that we're under extreme pressure with a relatively large building.
And given that this whole process has been going on, application was filed last year, is there a way to truncate that whole time period? And since you have not been able to schedule any meetings with them, to just go straight to a 45-day and ask the tenants to provide comments?
Well, before we issue a 40-day clock letter, we would have to make sure from the Department of Buildings that the plan that's before them is actually code compliant.
Which it seems it is, it's just not been issued because loft board does not technically have the authority.
I know that the owner representative has represented that it is, but it's not clear that it is.
So I don't want to get into this
Yeah.
anymore. It's very clear to me it's going to take ages, so get ready with your blankets,
but
right?
the other side is if we don't revoke, it's still going to take ages.
Yeah, no matter which way, it's going to take ages.
I'm not sure which
So
one's
I just
faster.
want to close this, and I'd like, we've heard enough testimony.
No, he's.
Oh, okay.
Oh, sorry.
Can you please introduce the record, your position?
I'm an assistant general counsel for the law board. I have conducted numerous narrative statement conferences, and I've participated and watched for about 5 years now. There is a way to speed this up, and it is to get the parties into the room as quickly as possible so that we can discuss whatever issues there are that the tenants do not like. If the plan is approved by the DOB, we need to get the tenants in so that they can communicate what they do not like with the owner's heating plan. So far, we have not heard anything from the tenant's side. We are available. We are available to meet today. We are available to meet tomorrow. We need to see from both sides that the eagerness to get the heat back on. The loft board will not be used as a pawn to get the C of O revoked. We will not accept that. We want the heat on today. We have tried to arrange that today.
Sorry, but you are being used as a pawn.
Well, yes, and no, and that's not, to be frank, that's not because of us. We are being used, not by choice. It's funny, but you know something, it's not funny.
No, it's not funny because we're in the
With all due
same
respect, we have
place.
tenants in the building who don't have heat, and they
Yes.
haven't had heat in 3 weeks. We have tried to communicate a time to get everyone together. We are still here today without dates set.
Right.
A 40-day clock? Who wants a 40-day clock? We're talking about the new year.
Right.
If we get everyone in today, tomorrow, We can discuss the issues. There's a plan in place. If the tenants have something wrong with it, if they want something extra, let's get them to the table.
One second. Counsel
Okay,
for the tenants?
we're not the
Yeah.
law board, we're not the law board, we're not DOB, we're done, we've heard everything.
I just want to respond to Commissioner Chibetta for one item.
I'm sorry.
Just to answer your question, okay, we are well along, as Mr. Bobick said. We have the plans, they're approved for the heating. The fastest way to get the heating on is for the tenants to come in and sit down with us. We sent in a schedule to the board
Okay, we've
of
heard
getting
all
the
of
heat
this.
on,
I
and it's a
don't
matter
wanna
of days
prolong
of getting the
this
heat
anymore.
on. If you revoke the C of O, all bets are off, because we got to start from scratch.
Okay, so the thing is, again, I'm going to close this, and then we're going to have a discussion amongst ourselves, right? So I want to just do it like that, okay? So I'd like to make a motion to close the hearing, and then we'll have a discussion among the commissioners, okay?
Okay. You want to close?
Yes.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Okay, the simple question before us is, was the building in substantial compliance with the drawings, with substantial completion pursuant to the drawings at the time that the C of O was issued? The court in Byrne BBSA allowed for correctable error, which would be something, however you review it, you consider it as correctable error. The issues of how the DOB and how the law board and how the owners and all of that work this out are actually not before us. The reason that we wanted to hear this is because, as we have in other C of O revocation cases, had enormous concern for the safety of the tenants, right? So, but at the same time, all the different parties are arguing their different sides. Each one thinks that they have an argument for their various sides, but the simple question before us is, was the building in substantial compliance with the drawings at the time of the C of O's issuance? In terms of the rear yard setback, the building doesn't have a rear yard setback. In terms of whether that's correctable error, it's either you provide the rear yard setback or you provide an easement over the properties. There was plenty of time for this property owner to provide easements. Now we learn for the first time they actually own the building next door. They could have provided an easement to satisfy at least some of the units on the side. They didn't do it. They didn't go to the neighbors at the rear and ask to buy an easement, which might have been a nice windfall for the neighbor at the rear. So from my perspective, there has been no effort on the part of the property owner to cure the building that obviously didn't comply with the drawings. So that's my position. And then the chips fall where they may, like we're not DOB, we're not the law board, we're not HPD, we're not the fire department.
I just want to add that in the case in Byrne, while it does allow for correctable error, the material change was much less than what we have here. They weren't as, there was smoke detectors, it wasn't as substantial of a deviation from the.
But the difference in Byrne, right, the facts are very different. In that case, there was a narrative statement, and the landlord had performed zero amount of work on the narrative statement. Had the court seen that the landlord had done everything except something, it would have allowed that to be considered as correctable error. I think it was a little bit of dicta when the court said, you know, they performed nothing on the narrative statement, but it's not to say that if some kind of minor thing that the landlord is willing to do remains, that it wouldn't have been something that the BSA could consider. And we have considered it on 11th Street or 6th Street? 6th Street, where we said that on 6th Street, the correctable error, hence we decided not to revoke the C of O as to the residential portion of the building.
that's 11th.
That's
That was 11th Street. That's what I thought.
Yeah.
11th Street, where we decided not to revoke the C of O as to the residential portion of the building, even though there were defects in the egress system, but that could have been corrected. In the interest of keeping the tenants in place and not risking them. There was no other defects in the building, in that part of the building. So, other comments?
I think, as you pointed out, we need to evaluate from that point of view, but it was helpful to get the ideas from, here are the tenants, here are the law board, and it seems in reality what's going to pan out. Everybody seems to be aware of it, of the issues. My biggest concern is tenants not being evicted, and they remain in place somehow or the other during all the work that's going on, whatever outcome comes out of it.
Right.
But I agree with you. I think we need to evaluate it from that point of view.
Other comments?
I think that DOB actually articulated the standard that the plans were not in compliance at the time of issuance, and that in that case, that makes it invalid. It isn't that it was in compliance and at some point somebody made a change after the fact. It wasn't in compliance at the time of the issuance of the C of O, and so therefore the C of O is invalid. So I think I look at it through a very narrow channel.
Other comments, anyone else? No. Okay. So I'd like to bring this to a vote, and I don't know if there's, conditions are sort of not our realm here, except for the hope that the tenants are not removed from their units.
We cannot make that a condition.
There isn't such a thing really in this situation, right? So, okay, so I'd like to make then a motion. No, sorry, we're closed. There's no additional comments.
It's closed.
That's closed. We're in executive session. Okay, so I'd like to make a motion to grant the DOB's request. Application to revoke.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Application has been granted.
You won?
It's a big financial war.
Application has been granted.
We have, should we have a recess for 5 minutes? We're going to recess for 5 minutes and get back on the, yes.
Okay,
Thank you.
5-minute recess.
I was trying to. Microphone's on? Okay, ladies and gentlemen, we're back on the record. Board of Standards and Appeals public hearing for November 20th. We're going to skip to one case, where are you, 190-15BZ, item number 15, 5157 Carmine Street, Manhattan. Mr. Angelino?
Good afternoon.
You wanted to withdraw this case, right?
Yes.
So for a motion to withdraw?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Thank you.
Application has been
Thank you for
withdrawn.
coming.
Item number, continued hearings. Item number 5, 28001BZ, 6663, 673 Second Avenue, Manhattan. You're signing the wrong thing. 1 second. Okay, no? Yeah, get up. Okay, now you have to raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Okay. Right there.
This is just 280 by itself, not in tandem with the other one, right?
Right, because the other one wants to be...
Right, I just want to make sure because we have questions.
Yeah.
Good afternoon, Frank St. Jacques, Ackerman LLP for the applicant. We made a motion. We submitted a letter to withdraw this application. We attended yesterday's review session, and Commissioner Otley Brown raised the issue of the effect of the withdrawal of the extension of time to complete construction, and lapse of the variance on the pending variance case, which is 2016-4273-BZ. Which is for the sign, the variance for the sign based on a good faith reliance doctrine. Our position is that these matters are separate. While there's an overlap of facts that do relate to the same property, there's otherwise no linkage that would affect the sign variance. So I can speak further to that.
Yeah.
The good faith reliance, which is the subject of the variance, was established in 2008 when DOB issued its determination and permits to erect the sign on another portion of the property. That reliance was the direct effect and was created by that DOB determination in 2008. The variance for the construction and new development of the building was issued in 2002, and that was based on hardship and resulted in waivers of commercial floor area location, the commercial rear yard equivalent, tower on a base provisions, street wall transparency, and accessory parking and curb cut regulations. Again, issued in 2002. There's no mention in the BSA resolution or on the BSA approved plans of the sign or of the sign issue. I can just quickly run through the timeline because I think it helps establish that these are separate matters. So the sign was erected sometime in the 80s. It was affixed to the building on lot 28. And at the time it was erected, the area was zoned C64. In 1983, December 1983, a zoning map amendment established a C19, creating a non-compliance with respect to the advertising sign. However, it was permitted to remain subject to discontinuance provisions. In 2002, the variance was issued. In 2004, the building on lot 25 was demolished. That's just to the west of the site. In 2008, the buildings on lot 27 and lot 28 were demolished. The building on lot 28 and on lot 27 were demolished based on a DOB order, and that was to satisfy safety concerns relating to those buildings. In 2008, in June, so the buildings were demolished in April of 2008. In June of 2008, the application was made by the applicant for the relocation of the sign on a structure further south from lot 28 on lots 27 and 26. DOB issued the objection in August of 2008, which had three objections: that the sign was two-sided rather than one-sided, that the sign was not in the same position as the original sign, and that there is a difference in elevation between the proposed sign and the original sign, which was affixed to the building on lot 28. In October of 2008, the DOB Manhattan Borough Commissioner issued a sign-off on the pre-consideration reconsideration. And then in December 2008, DOB issued permits to erect the sign and the structure holding the sign in its new location. Our position is that the good faith reliance was created based on the DOB issuance of the reconsideration and ultimately the permits, which led to the installation of the sign in the new location. The applicant installed the sign by the end of 2008 and incurred approximately $188,000 in costs in erecting the sign and $288,000 in maintenance costs over the number of years that the sign was erected. And then in 2011, DOB issued the intent to revoke, so approximately 2 years and 1 month after the good faith reliance was created. So again, our position is that these matters are not related, and I'm happy to answer questions or.
Yeah. But wasn't the recon based on the fact that there was this variance project that was going to take place, that was going to be built exactly where the former building was that had the sign? And so the sign had to be relocated or would face a discontinuance or would run up against the not being, because you're legally non-conforming, not being able to be moved or changed or increased in your degree of non-conformity?
That's not my understanding of the reconsideration, that it's.
Well, why else seek a reconsideration, if not for the fact that you were building a new building on the site where the sign was, and that the building was not going to be completed in time to stop the clock on the discontinuance?
And didn't the recon actually make specific reference to the BSA application?
There is a reference in the reconsideration to the BSA variance application.
So it does sound like, at the very least, the commissioner was taking into account the BSA approval for the building and then trying to assist the owner with the location of the sign to facilitate development of the building, or at least facilitate retention of the sign during that sort of lapse period?
So I think what we can do is review the record, and because we're adjourning the sign case, the good faith reliance case, if the board is amenable to this, we'll, I'm not sure procedurally how this would work, hold over the withdrawal request
Yes.
until such time that we meet back
Yeah.
with respect to the good faith reliance case.
Okay. Okay. So how much, you requested an adjournment, how much time do you need? What are you adjourning? You're looking at other options, or what is it that you're doing?
That's correct. My office is working with the applicant and sort of reconsidering development options at this site. And it's, that aspect of the case is intertwined with the good faith reliance. If we were,
January, so it's not very much time that you're asking for.
just, I think a brief extension would be sufficient, maybe the end of January.
Do we have time?
January 29th, we have 28.
No, because it's a lot to review once we are. So put it on there, we have, they still, what do we have on them?
February 5th is 16th.
February 5th? I'm just looking at.
That's fine, thank you.
Yeah, and
And-
what's the submission date? She wrote that?
January 16th.
January 16th submission date for February 5th hearing. Okay. What is it?
No, I was just looking at the DOB determination, and in that, there is a paragraph that says, however, the location and the size as approved per job number 110179912 does not conform to the BSA letter and the BSA approved plans attached thereto. The BC-1 reconsideration form signed by former Borough Commissioner Santulli is unclear in that the application did not specify on the form that the sign would be relocated from the corner of 2nd Avenue and 37th Street. Nonetheless, to the extent that the such BC-1 form proposed to authorize the relocation of the sign is contrary to the size and location approved by BSA. Such determination was issued in error and hereby rescinded. That was in the, so it did rely on BSA approved plan of a sign that was, so if you're going back to Commissioner Otley Brown's point, that if you are withdrawing that, then all of the determination that was made by DOB, then
You're relying on the very determination that you're trying to remove, basically.
We'll look into that further.
Okay, because once you withdraw it, we act as if it's not there anymore.
There's no going back.
Yeah.
Thank you.
Okay.
Item number 6, 2016-4273BZ, 669 2nd Avenue, Manhattan. Mr. Leland? Oh, I'm sorry, you finished?
We just,
We gave you a date, I'm sorry.
yeah, we gave the date already. We treated
No,
them
that's-
as if we read them together, but we didn't read them together.
Oh, I didn't call that one, though.
I'm standing up for this one as well, so
Are
I'm
you
happy
gonna
I
stand
can
for
make
that
an
one?
appearance.
Okay, so what date are you giving that one to?
The same.
February 5th? Okay,
Great,
Thank you.
thank you.
sorry, Frank. Item number 7, excuse me, 41850BZ, 7369 217th Street, 7336 Springfield Boulevard, and 21902 74th Avenue, 7310 220th Street, Queens. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your statement, testimony before the board, and to respond honestly to board member questions? We sign them. Thank you. Excuse me.
Good afternoon, Chair, Commissioners. Thank you. My name is Eric Goydell. I'm with the firm of Bora Goldstein, Alshua Nanes, and Goydell PC. Compared to case number 3, 18th Street, this is like trying to sublime to the ridiculous, I would think. But I'm here to just report, this is a compliance hearing, here to report on some of the progress that was made by WOTC Tenants Cooperative Apartment Corporation in Bayside, consisting of 897 garden apartment units. I had been in touch with Ms. Monroe on several occasions, and apparently there was some difficulty in terms of pictures which were sent back to comply with the 2 weeks ago. They were shown as received, but somehow were corrupted. So I was asked to bring copies today. So I brought a few sets.
To us.
Yeah, sure. I'm sorry. I apologize.
We could share.
So if we go in two pages behind my letter, what we did was we took the Oasis map and we identified the pictures, which are 14 pictures, starting 2 pages behind that, as to the locations on the Oasis map. And then on the page immediately behind the Oasis map, we identified the location in the buffer zone. The buffer zone basically runs from 75th to Springfield Boulevard, and the homeowners whose houses are affected are on 77th Avenue. So if you look at the Oasis map, you'll see almost a rectangle on the Oasis map. That corresponds roughly to the buffer zone. The southern portion at the bottom of the page is closest to the homes on 77th. The top of that rectangle is the northern portion, which is which is the apartment corporation's property, where there's predominantly a driveway in that location and some garages. So if we look at the pictures, and this is what we were hoping for to some extent, although not to a complete extent. If we look at the pictures, you'll see that trees have grown in, vegetation has grown in, and when we were here last in the spring, this was not the case. We have not placed any more trees on the property. The apartment corporation over the past 2 years has had a complete change in the board of directors, a nine-member board. I have Barbara Amkraut here, who's a new member of the board, who actually call it the government in exile. She was actually on the board many years ago, and now is back. But the new board is committed to doing some additional work on this property. I know Ms. Skolnick is here from the homeowners. I think she is going to perhaps say, I don't want to put words in her mouth, that some progress has been made. More progress has to be made. But the apartment corporation, this board, is willing to have a dialogue with the homeowners on 77th, unlike perhaps some members on the past boards of directors to talk about this issue. But again, if we look at the pictures, yes, there are some sparse areas, but also there has been some significant growth.
But you're just talking about the growth, sort of underbrush has been growing. It's not like there's actual planted new vegetation.
Correct. So there have been no plantings. We received two bids, one from Will Rizzo Landscaping, which was annexed to my May, I believe to my May letter. Actually, to my November 5th letter. It's behind the drawings. And also, we had previously turned in, I believe, a proposal from Green Turf Care.
So I'm a little confused about this. Our last hearing was in June.
Right.
And in June, you apologized for late submissions and requested more time for planting, waiting on a proposal from a landscaper. These two proposals, one's from May, actually, May 24th, so you already had that one. And then there was another proposal, I think, from July. So I don't understand why none of the work was done. That was actually why we gave you this much time this much of a window.
Right.
It wasn't just our schedule, it was that we wanted to allow you all the time during planting season.
Correct. And what happened in the meantime, Chair Perlmutter, was and I'm not excusing what was committed to back in June, but there was a wholesale change in the board of directors of the apartment corporation. And as a result, this new board had to get up to speed on the process. Not one member of the board that existed back in June, well, I won't say that. A few members of the board that existed back in June are here, but not one member of the board that was on the board at the time that this initial application for surrender of the variance was filed remains on the board. I mean, perhaps Ms. Amcrow could address the issue of the board's plans with regard to the work.
Okay.
I'll stop.
So, and this is a new board?
Yeah, new board member, yes.
So could I just
Yeah,
say,
please.
without a landscaping plan that translates these contracts, it's hard for us to tell which one would be more appropriate.
Right. So, well, we can't, but I'm kind of looking at them and saying, okay, put them all in. I mean.
Right, put
But
the one
not
with the
now.
most trees,
With the
use
most-
that
right.
one, since we can't see.
I understand, Commissioner Brown, but I think what the issue is really is coordinating with the 70s, because we do have limited funds. Okay, we could probably spend hundreds of thousands of dollars repopulating that buffer zone. I think communications with the homeowners association, which this new board is prepared to do, would go a long way toward locating the trees perhaps closer to the southern, to the southernmost property line, to the southernmost portion of the buffer zone, which will give the homeowners, more comfort, and at the same time, not bust the budget for the apartment corporation.
Well, all right, let's hear from the board member, and let's take it from there, because you're 6 months late.
And planting seasons, it's
Yeah,
it's
and
just
we have to
passed.
wait until April now.
And that probably is going to cost some more money because
Barbara
you're going to be
Amcroft.
here longer.
I'm sorry, Commissioner.
No, carry on. You can continue.
I am the Vice President of the new Board of Directors, and as of November 1st...
Sorry, state your name again.
Barbara Amcroft. I've been here like numerous times as well. I mean, even though I wasn't on the board, we finally broke through and got a whole new board as of November 1st. So we really have not had a whole lot of time to see what has gone on, except hearsay. We haven't seen the contracts or the bids that have gone on. We haven't gotten a hold of the finances yet because we were supposed to have all this money for that clubhouse. Seems to have disappeared. So we're trying to get a handle on what's going on in the co-op as of now. Okay. There has been no dumping on the green space at all anymore. We cleaned up, everything was cleaned out there. And that's how come all those weeds and whatever you want to call them grew, because everything was cleaned out. The landscaping trucks that were on the green space are no longer there either. We accomplished that much. And we're looking for a place to put the recyclables, which were a problem at one time too. So the new board is trying to make inroads, but it's going to take a little bit of time till we get up to speed. And since it isn't planting season right now, and we want to get more bids, because we don't know if the bids were correct or honest or whatever, we just try to get up to speed and do everything we can possibly to make it right now. But we are committed to making this right. And I am personally working with the Green Belt Alliance, and I have been for a couple of years now since this whole project began. And I think we can sit down, come to a determination, we will work together, and I think we can solve everything that we need to, but we just need more time. So I am respectfully requesting time to get up to date and the information needed to move forward and make wise decisions on this whole fiasco.
So what we did the last hearing and the one before was we said we're not landscaping this place. It was just supposed to be a green space. And it was supposed to have natural vegetation, and it wasn't supposed to be filled with garbage, and it was supposed to be maintained and all of that. So our direction was just put the trees back in, make it dense forestation so that the neighbors have the shielding, the buffering they expected. So we're not designing the landscaping, right? So I think that's really it. So if they say this many trees and this many things, it's a very large area. I have no idea whether that's a few trees or...
I never saw that, honestly, until today.
Okay.
So I don't even know what they proposed.
Right.
That's why I'm saying we need to start from scratch and start all over and get a new landscaping company for certain.
Do you have all the records now? You said you're still,
No.
It just started November 1.
Right.
so when will you get all that information?
Well, I'm dealing with the property manager who is supposed to give us all the contracts that were and are about to be enforced. And we're going to go over every single thing and see what, not only with the green space, but with everything.
Everything
around
else
the
that's
park.
going on.
Yeah.
So here's the thing, because we know that, I know, when you do a transition, it takes a little while, but in the end, you have all the information, and we don't want this to be holding this up any further, right? So planting season starts in April, it runs till about mid-June, and so I would say that's it. We don't want to get involved in how many petunias there are. We just want to know that it's been replanted and is back to normal. And we had asked for fencing. I saw there was a request to not have fencing. We had asked for fencing because we don't want to be policing this site. And up until this time, the property association or whoever management was using the site for dumping and truck parking and all kinds of things like that. And the only way to prevent that, for sure, is to have a fence. So the request to not have a fence, but still prevent that, there's no way to do that really, unless, so that's why we gave the instruction, install a fence, which was supposed to be up with the original approval anyway. And so that needs to, and I know there was a...
But that, to me, is a problem only because if in fact there is a fire, or anything like that, like stuff that's happening in California, the fire department will not be able to get in easily. Because the fence that they were proposing...
There are fences everywhere in the city and the fire department finds its way, right? It'll break down a fence.
But also,
whatever.
if you came to the property...
The parks have fences, right?
I live across the street from Alley Pond Park, and no, there is no fence on the borders, on the outskirts, or anything like that. And that's what this land is supposed to be, basically.
Right.
So, a fence...
Right, but we really need going forward to have the security and knowledge that that space will not be abused in the way that it was in the past. And the most practical way to do that is to have a fence, and how you execute that, whether your concern for fire department access leads you to put doors or gates in various places, that's entirely up to you. But the board feels best proceeding with the fence in place so that this way we don't have to send our compliance officer out every few months to take photos or to actually examine photos that are submitted to us showing that somebody threw recycling in the back, or somebody parked a landscaping truck for 5 years, or somebody abandoned a car in the back.
That will never happen again, because we are policing everything. I just told you, the trucks are gone, because as of November 1st, they have not been there, and they will not be there ever again. The fence is a deterrent, I understand that, but it's also not going to make the land pretty, and it's going to be a blockage of the...
There's lots of different kinds of fences. You can put up a very lovely metal picket fence. It's done in many of the city parks have metal picket fences. It goes perfectly with the idea of landscaping, and it keeps trucks out, keeps garbage out. So, because otherwise, we're not, we could put a condition on the resolution, don't come back to the BSA asking for help anymore, because this was the way that we wanted to control abuse of the interior. And so it seems to me that the fence is the solution, and there's lots of pretty fences. It doesn't have to be a chain link fence. So, and it doesn't have to be a really high fence. It has to be a fence that prevents people from going in with a truck and parking their trucks and putting the dumpster there and all of the things. They used it as a dumping ground.
They used it as a dumping ground, but they never took their trucks in there.
No, we were told there were trucks. You just told us the landscaping trucks were removed.
They parked them on the side. There is a space that they blocked off for themselves, so to speak, to use as parking.
Right.
which is not there anymore.
Okay, but so?
But there is
We
also...
can't be policing this place. So the only way to know that it's going to stay as a buffer area is with a fence. So I don't want to discuss it anymore. We talked about this many, many times at prior hearings. And so that just has to be part of the deal, right? So I think, are there speakers on this? Yes, please.
Good afternoon, Chair Perlmutter and members. I'm Eleanor Skolnick, representing the Green Belt Neighborhood Alliance. I reside at 7619 220th Street. I submitted a four-page statement to you on the 15th of November, and I just want to highlight some of the issues that we think are still remaining. From 2015 to 2017, in anticipation of their approval of their application to amend the variance, WOTC bulldozed with purpose and intent large areas between 222nd Street and 220th Street where construction was planned. These actions negatively affected water retention of the land, fostering increased water runoff onto some of the private properties south of the Greenbelt, and causing basement flooding in at least one property where no flooding had existed before. Drainage issues which now exist may require areas in the Greenbelt to be regraded. There has not been any planting within the Greenbelt. There are areas throughout the Greenbelt with shoulder-high weeds, as well as other areas along its northern border with no vegetation. It should not be overlooked that the absence of a large number of trees and the need to bring the Greenbelt back to its former vibrant, tree-rich condition resulted from WOTC's willful and destructive acts, as well as an ongoing failure to maintain the land in good condition. Trees are essential for water retention, reduction of air and noise pollution, oxygenation, and act as a visual screen and physical buffer. The only landscaping proposal that we were aware of is the one that was just being referred to. I believe Green Turf was the company that did the cleanup. I don't think it was the landscaping. And I have a copy of the one from Will Rizzo. It lists only low-lying shrubs and bushes, not trees to be planted. Indigenous trees which were destroyed need to be included in the proposed planting. The map submitted does not indicate where the plantings will be placed, as you stated before. And there's no clear representation of where the northern boundary of the Greenbelt is. As of today, WOTC still is restoring the recyclables, which Barbara addressed. And I know they're working to address these issues. Still a number of cement slabs that lie within the Greenbelt remain. Unless removed and restored with plantings, these cemented areas may, as they have in the past, been used for storage and parking. And there needs to be a survey to determine the northern boundary of the Greenbelt. The variants state that that the area shall be planted to a depth of 100 feet from the southerly lot line, and an additional 50 feet shall be planted and maintained, except where residential buildings, garages, and parking areas are shown on the 1950 plans. Thus, the northern boundary of the Greenbelt, which is where you want the new fence put, meanders from less than 100 feet to 100 feet to 150 feet. Once an accurate survey of the Greenbelt has been made, proposed plantings can be clearly mapped out.
Okay, so, all right, thank you. We're not going to get involved in a landscaping plan for this because this was a wild area, right? The fact that it's been removed of its wildness during the cleaning process because it was abused means that it needs to be brought back to that wild area look, but we're not going to get involved like the Parks Department does on making sure that every red oak goes in the right place, right? We have no way of knowing. This proposal shows 50 red oaks, 50 Canadian red cherry, 25 junipers,
That's
and
what was
25
removed.
privet hedges. No, this is to install.
I haven't seen that at all.
That's a proposal.
That's a proposal to install.
We haven't seen that.
So that's a lot of trees. I
Yes.
have no idea whether that's an adequate number of trees to accomplish
It's only
this
really
task.
within the two-block area. The other parts of the Greenbelt are okay.
Okay,
They were cleaned
so-
out, and they
okay.
were okay. It's just the
So-
area where they bulldozed, which is bad.
Right, okay, so we don't have any way of knowing whether it's an adequate amount. We're not going to get involved in that. It's just that it needs to be brought into a place where it creating the satisfactory screening that there was before there was all of that bulldozing. Okay? Okay, thank you.
Chairman, what we are doing is having a meeting with the Greenbelt Alliance to try
Please
and...
go to the mic.
I'm sorry. So what we are committed to doing, the new board, is to having a meeting with the Greenbelt Alliance, and again, within reason, replanting areas to, to their satisfaction. Again, so long as it doesn't, how do I say, break the bank of the apartment corporation. As to the comment about the recyclables, that is unfortunately a sanitation, Department of Sanitation issue which is ongoing and trying to find a suitable alternate location for this. We understand your directive, the BSA's directive, but but for now, we are being met with resistance from the sanitation department more than from us. So we would respectfully request one last adjournment for compliance and to see perhaps in the spring what plantings can be done, as you said, during this planting season, and then maybe come back after that with some better pictures.
Okay, so not to see what plantings can be done, you're going to plant.
We're gonna plant, correct.
Right? So to be clear, when you come back in June, let's say late June, we see photographs of the area planted, we don't want to hear about this anymore, and of the fencing, and the recyclables relocated to someplace outside of the Greenbelt. Greenbelt is not to be used for any other purpose except green growing things, right? Okay. All right then, so we can put this on for June 25th with a submission of, actually maybe we do it in July so we have a submission date. So we say July 16 with a submission date of June 26. Okay, so that gives you the entire window and then some of planting.
Thank you very much. Happy Thanksgiving.
You too.
Item number 8, 17092BZ, 23204 Northern Boulevard, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Thank you.
Good afternoon. Sandy Anagnostou, representing the applicant. I attended the review session yesterday and heard the board's comments. One of the conditions of the board under the original grant was that 85%, there'd be an 85% recycling process to be used for the auto wash water, and I'd like to clarify that. We submitted a letter on October 31st, which provided a plan and specifications regarding the existing reclamation system, and I also will submit this letter that I passed out, that I distributed, we'll submit that today as well, clarifying the percentages and volume of water and how it's directed. So Wonder Bar, which is this company, has manufactured and installed these recycling and filtration systems since 1986. They installed and designed the system that's in the subject premises in 1993. The system reclaims 85% of the water that's utilized to wash the cars. It's designed so that the wash water is directed into the multi-tank system, and we provided a drawing of that system. So sand and heavy materials settle to the bottom, and other materials float to the top. It's maintained, and the schedule of maintenance was included in the October 31st letter. Whatever solids settle to the bottom are removed by a private carting company, and also the soap and products that are used here are biodegradable, environmentally friendly, and they're not oil-based products. And there are no oil changes occurring here. All the washing of the automobiles occur within the enclosed building. So 85% of this water that goes through this cyclone machine is, after it's been filtered, it's recycled and reused. 15% of this water is discharged to the existing 18-inch sanitary sewer, which is in Northern Boulevard. From there, it flows to a 24-inch combined sewer, and from there, the wastewater is directed to the Tallman Sewage Treatment Plant, where it's treated. There's no water that's ever discharged into anything into the nearby Alley Pond Park or Little Neck Bay or any other body of water. There are also trench drains on the site, which we submitted photographs showing that. Any storm water would flow into the existing 54-inch storm sewer in Northern Boulevard. I don't know if there are any questions, but I hope that this clarifies.
Yes. So, but you didn't send that to submit yet?
No, I did not, but I can submit it now.
Okay, I think that would be good. Do we have any other questions? Are there any speakers on this one? So I'd like to close this, but if you could submit this now.
I'll do it
submit
now.
And we put it on second call.
Yes.
Okay? All right, so a motion to close?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Eckley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Thank you. So second call.
Second call is? Okay. New cases, item number 9, 539-66BZ, 6119 Fresh Meadow Lane, Queens.
Hello, Eric Platnick. Happy Thanksgiving, even though it doesn't feel like it yet.
You want to be sworn in, Mr.?
Oh,
Yeah, be sworn in.
I'm sworn in now.
Go be sworn in.
Yes. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? I do. Okay. What happened?
The chair won't.
Oh, gosh. Everything's falling apart in this place.
Chair Walter. Hi, Eric Platnick. We attended your review session yesterday, and with us is Frank Vociato, whose name I never pronounced correctly, of Stonefield Engineering, as well as Larry O'Brien of High Point Engineering. Most of your comments pertain to them. Specifically, you had comments relating to traffic and the curb cuts, and you had comments related to the landscaping. The traffic is probably the more difficult concept or items to address, although we think it's relatively simple. We're willing to work with the board to address whatever concerns you have, and the landscaping as well. The tone that we're coming with you out today is we're happy to do a lot of what you're requesting. So Mr. O'Brien is here, and he has a landscaping plan that he's going to talk to you about. But before we do that, why don't we speak with Frank, and he can go through the curb cuts. Frank, we'll go right to your issue.
Good afternoon, Madam Chair, board members. For the record, Frank Vociato with Stonefield Engineering. And like Eric said, we viewed the review session yesterday, and just want to get in front of the board and discuss some of the traffic concerns that you had, see if I can address them. Since the time you made your comments yesterday, we put in a request with DOT for accident data related to this intersection. And they're actually very, very responsive group over there, and they got us back this morning the accident data for the intersection. And we can summarize it for the board if you'd like, but what we found just very quickly is that over the course of 3 years, from 2014 through 2016, there were only 2 accidents that occurred at the intersection of Fresh Meadow Lane and Horace Harding Expressway, which is the south service road of the LIE. We can certainly provide more information if you'd like. One of the reasons why, it looks a little bit more complex than it is when you're looking at an aerial, but when you think about this intersection, it's really just 2 one-way roads intersecting. Horace Harding Expressway is a one-way service road going eastbound, and Fresh Meadow Lane is essentially 1 lane of traffic that is merging into it and making a right turn with a stop sign controlling it. there's no other conflicting turning movement at that location. So the intersection data, accident data was maybe a little surprising to me, but when I thought through it a little bit, the low incidence of accidents, I think, makes sense at this location.
What about the approach to Horace Harding from Fresh Meadow at 64th?
64th is one way.
64th is one way. Which
It is a
way?
one-way roadway away from Fresh
Away.
Meadow
It's
Lane.
eastbound.
Right,
Horace
no, I
Harding-
know that, but I'm wondering, I know. But I'm saying from Fresh Meadow, so what's happening in your maneuverability diagram, you're crossing 64th to get to Horace Harding. You're showing that. So that's one crossover that way. Plus, you have people coming from Fresh Meadow who are approaching 64th and also either going on 64th or going to Horace Harding. Then you have the people coming on Horace Harding. Then you have people who made a mistake, I guess, who got off of Horace Harding and didn't mean to, so they go left and then they, right? But, so there's a lot of people, the proposal is a lot of crossover on 64th.
So one of the things that this plan that you have in front of you doesn't really tell is that back about a year ago, and this project predates that, there were some striping and traffic calming measures done at this location. And if I may just sort of draw it for the board, but this triangle here,
Can you orient us as?
yes, so north is to the left. So Horace Harding Expressway is traveling in this direction, eastbound, so north is that way. So what I'm referring to is this existing hardscape island here exists, and on the plans, what's not shown is that DOT came in here about a year ago, it appears, and put striping that does this. So it is not our intent to have any traffic do that maneuver
Oh,
at all.
but you show it on your maneuverability drawing.
So, and again, this is something that we caught once we heard your comments, and we're willing to make that change and work with the board. We do understand that that is of a concern too, especially with that striping there. If you go on Street View, you'll see it. It's not shown on this plan. The survey predates, I believe, when DOT did that.
Well, actually, what you show on your maneuverability is somebody pulling forward of that. They're coming from the bottom curb cut, the one closest to Fresh Meadow,
Right.
that's still on 64th, and then they're coming on to Horace Harding.
Right.
So that doesn't bypass, that doesn't miss that point that you just drew.
So another thing that we're doing, and I haven't gotten to it yet, but we are proposing to eliminate that curb cut altogether. That's the one.
That will resolve the issue.
Yeah.
So at this point, what we're seeking to do is have this driveway be an in only. There's no other conflict with a right turn in. This would be in and out, so in case you miss this driveway, you have another opportunity to make a right in. The right out would occur here, and again, you're facing this hardscape, so there's no way to, unless you're really out of your mind, to go across that. What you can do is you can go down 64th, where it intersects with Utopia, make a left and come back up to the traffic light, get on the expressway. We are maintaining a driveway at this location. Why is that important? Well, if you're coming off of Horace Harding Expressway, you can use this kind of does that, if you will. You can use that and come directly into the site that way and not have to pass in front of the store. And then there's a curb cut closer to the store, really to serve anyone who's coming from the south, as well as those parking spaces there. So I think the elimination of that and the orientation of this as an in only, and we'll put the requisite signs and markings. It's narrow to begin with, given the hydrant, there's a light pole on the other side of it, I believe.
And it's just because it's at the bend, you're not able to see the traffic that is coming from Fresh Meadow, so it does make it more of a collision point. So that was one of the locations for my
How
concern.
do you limit something to be in only? How does that work?
You can
Striping and
have
signage.
Let him say.
Striping and signage, so one way, do not enters, markings on the ground.
Can you also put those kind of, there are these treads that go in the direction of the traffic? If you have if a vehicle is trying to come out from that, then it would kind of be abrasive to the wheels. Isn't there one?
But how would that resolve it once the car's on it?
Yeah.
No, it's in the direction of the only in.
Right, I know, but let's say I'm going out that way, I'm not looking, I don't care, and my car hits the bumps, but I'm in the curb cut already.
Before you hit the curb cut, your tires are going to burst.
Yeah, that's.
Oh, you mean like those metal things?
Yeah.
Oh, well, you can't do that.
That seems
People are
excessive.
Oh, you can't
crossing-
do that?
People are gonna be crossing on the
That's-
sidewalk and stuff like that.
Okay. Or maybe bumps of some sort, so to kind of,
Well, what I've seen at other sites is you have basically two big do not enter signs on either side of the driveway facing you directly. So if you're at the pumps and you're looking out, you know, you're seeing do not enter. And we could even add signage that directs people to do this. Again, signage and striping doesn't prevent 100% of drivers. There's always going to be that person who doesn't care, but the intent is to capture the far-reaching majority.
Does that answer everybody's questions? That was mine. And then the crash data, you'll give us more. But when you looked at crash data, that's what I wanted to know. Is it for all of the intersections? So you have the Fresh Meadow to Horace Harding, that lower one. Then you have another intersection up there where everybody's doing that. That's the one that I was concerned about. Where's your data?
We requested, I believe, from 164th Street, which is the next signal to the west, I believe. Let me just check my notes. Yeah, 164th is the next signal to the west. So we requested from there all the way to Utopia, I believe. For this meeting, I just zoomed in on this location, that's where the two came from, but we can summarize it for you.
Okay. Just to make sure all of the potential crash source locations.
No problem.
Okay.
Thank you.
Thank you.
Good afternoon, Board. If I could direct you to Larry O'Brien with High Point Engineering. If I could direct you to our drawing Z009, the landscape plan. What we'd like to do is keep the proposal as it's shown today. And I want to commingle a few concepts. As we go toward the building, we do have an area of single-row arborvitae, and we also, on the building, have a light fixture, and I think that was one of your concerns as well. We would like to, if it's amenable to the board, remove that light fixture on the short portion of the building and leave the landscaping as is, along with the PVC fencing, and I think that might alleviate some of your concerns.
Sorry. You have a drawing you could point to where this is?
Okay.
Yeah,
Sure.
but where's the lighting?
There's
And why is the lighting relevant to the conversation about landscaping? Right.
two things at the same time.
Okay. So we have the existing landscaping.
Right.
We'd like to leave as is, as proposed, and we would like to also keep the PVC fencing along the common lot line.
Yeah.
So with that existing landscaping, let me just go back to the other portion of the property. We have two rows of arborvitae, and it's staggered, so it creates that buffer. As we get to the building, we have the single row of arborvitae. There is an exit door. If I could just talk about that. There's an exit door of the building that would require the pedestrian path along that part of the building. There is a light fixture on that building as well at that point, and we would like to remove that light fixture because that was, as we understand, it was under the concern of the board about light spilling
Yeah,
over.
but let's stay with landscaping. Stop talking about the lighting,
Okay, so the
okay?
landscaping, we'd like to leave as shown.
But how are you responding to our concerns about the landscaping?
What we have is the two rows of arborvitae staggered. Sure.
Yeah.
I think what Larry is trying to say is he heard your comments yesterday, and when we told him that the landscaping, you had comments on the landscaping from the residential with buffer, Larry was of the opinion that what's the concern, I put a lot of landscaping in there. So I think the disconnect in this conversation right now is Larry's not necessarily clear on what your concerns are with the landscaping. He's of the belief that he did a pretty good job of landscaping it. Not that he's so, content, so high on himself that he won't take criticism, so.
Right, okay, so let's start over.
Sure,
okay?
sure.
You're up against residential property, right?
That's
And
correct.
so, all the way along that area.
Yeah.
And for whatever unknown reason, you've decided to give the least buffering from noise, pollution, visuals to the area where the building is. That doesn't make any sense to me. The building isn't built, right? So you could obviously change the dimension of the building somewhat to allow for a dense buffer like what you're planting maybe along the other perimeter. The other thing you're doing is you have the trash storage right up against residential property. So you're giving them your trash, basically, right? There's no buffer between the trash and the property, and the residential property owner. How would you feel living next door to something like this, where you go out onto your back deck and you can smell that lovely wafting of rotting trash as it's waiting for pickup, not to mention the fact of the noise of the pickup, et cetera? That's the whole idea of landscaping, right? So the landscaping is inadequate, to cut to the chase. So if that means reconfiguring the building to provide more landscaping and putting the trash in some other location or moving it forward, et cetera, you should do that.
Yes, we will look at the location of the trash enclosure. However, the building itself, we would like to look at adding landscaping at that portion if it's amenable to the board, but also to allow just the exit of the building to remain.
So the thing is, in order to allow exit of a building, you need a minimum of 3 feet, right?
Correct.
In order to also get your landscaping in there, you're going to need a minimum of, I don't know what the depth is for 2 depths, but the 2 rows of trees, that the typical is 4'6" or 5 feet. I'm just taking a wild guess. You don't have that in what you've drawn. So to instruct one more time,
8 feet, yeah.
this isn't an option, okay? You're changing the size of the dimensions of the building to accommodate more buffering planting adjacent to the building, okay?
Yeah,
So we don't have a
understood.
negotiation, we're not doing that anymore, right?
Correct, yes. So we will address that, we'll look at that and take it into account and make the necessary means as possible to increase this, and we will look at the portion of the building that perhaps can be remodeled.
There you go.
We have a lot of space there now. We have 8 feet as it is, so, and I'm sure that either they can make a decision on the doorway or to add more landscaping or to make the building smaller. But your goal is not necessarily just to make the building smaller, your goal is to provide landscaping.
Yeah.
That's your goal,
What
so
you do with the building, that's.
if they
your-
decide to
Right.
jettison on the door and go with the landscaping, you're okay with that, I'm assuming.
Right, because you've also pulled the building away from the property line in the rear, where I believe that's commercial use. So-
Yeah, it is. Would you like us to go, I mean,
No,
I don't-
no, it's simply that if you're looking for a particular square footage for your.
You've got the room in the
building,
back.
You have room to play in the back.
Yeah, they do, and I don't know why they pulled it off. Usually, we don't like to keep an opening in the back. we'll find out
Well,
why
it's
they
good
put
to
it
have
off.
access in the rear so you can maintain your building. Most of the
Yes.
time, you can't maintain it.
That's 0.8, okay.
Yeah.
All right, and, just so you know, as I said at the beginning, the spirit of our request here is the owner is in a business deal, so we'd like to move fast. So what your comments are, we're happy to agree to everything you've said so far and to amend the plans quickly to address them.
Okay. Does anybody have other comments about the landscaping or anything? So lumen spread, whatever you do, it doesn't matter how it's done, 0.
That light is what was doing it. That's why Larry went right to the light, because the light over that service door on that back corner was throwing the lumens in that corner way up. So we'll get rid of the light over there. I think that'll address what you were seeing with the high count near the property line.
Right, you can have lights.
You could have LED, you could have money, yeah. You could have low-down lights.
Yeah, right. It's
Plenty
not
of
the
different lighting. Yeah, there's no
sidewalk.
security issue in that corner necessarily.
Yeah.
Are we satisfied on the parking?
Well, that's a question for you to respond to, for example. What do you think?
I'd like a little more explanation as to the justification as why you need less parking. Why?
Less parking?
But a waiver of parking spaces.
You're asking for a waiver of 5 spaces.
Well, it's an SOC application to begin with, so not asking specifically for a waiver of parking, there's no requirement on the parking.
So there was, so if you do the math on the project, which is what was done and provided in the drawings, it shows that there's 5 spaces required that are not being provided. I think, what is it?
9, we have 9 spaces, and what's the requirement? Excuse me, Larry?
9 provided, 5 required.
9 provided, 5 required, that's what I thought. I thought we're not under
No,
park.
I understood there was a waiver being asked of the parking.
No, I think
Can
we're
you
over.
check your-
I'm sorry,
check
that's
that?
why, can you tell me right now? I'll look at the plans right now, but that's why you caught me off guard there.
Yeah,
Right, but how many are required?
5 required.
5 are,
No, but that's the point, 1 per 300 square feet, and you've got 4,000 square foot store. So what's the math on that?
12.5?
how did you get to 5 required? I'll find the calculations real quick, hold on.
That's 13 spaces.
Oh. I understand, okay.
I get 13 when I divide 4,000 by 9.
I see now. In Stonefield's paperwork, Stonefield did an analogy of what it would be if 1 per 300 square feet in a C2 zone if the full 4,000 square foot convenience store was counted. Now I'm understanding. There is no particular parking count in this case because we're an amendment application, so we didn't provide you with a parking calculation. I don't know where Larry came with the 5 spaces. Going to the number of spaces, the 9 spaces, is more than adequate for a facility like this for a couple of different reasons. The first reason is it's not a 4,000 square foot store. It's a 4,000 square foot store in its entirety. But a lot of that space is sales area, a lot of space is coolers, a lot of that space is where the attendants are behind the counter space. So the actual sales area, which I could have Larry break down for you at a later point, breaks down to much less. In addition, most people, if you think about it yourself, don't go to a C store to hang out. They go in, you get your goods, and you leave. This is actually, the reason why I look shocked is because 9 spaces is actually a very generous amount of parking spaces for a facility like this. In addition to the fact that you've got fueling positions at the pump, and if you're lazy like I am, when you fill up, you don't move your car from the pump when you go into the store. You leave your car at the pump and then you go to the store. So the pumps actually end up being another almost 10 spaces in this case. So parking, I think we're well.
The selling area is about 2,000 square.
Yeah. So I hope that addressed it, and I'm sorry for the confusion.
with that.
Okay. I just want to see if there were any other things. No, so it was really the traffic studies, and I think we still had an open, right? Tracy, you
It was never
said,
sent to DOT because it was the SOC, so all the information requested was for the board's purposes.
Right.
But perhaps we could amend the traffic study to update what we talked about.
right. But I would like DOT to look at the impact in the traffic system. So they'll submit their materials and as soon as possible, and then we send it to DOT. Okay? Just because otherwise we're the ones doing DOT type review. Okay. And then we also wanted you to break the signage out by frontage.
Yes, we,
Okay. And, yeah, I think that's it. Oh, and also for the drawings about the landscaping, the planting beds need to be dimensioned, and we need details on them to understand what it is we're getting. Okay, so, and I expect that they are a minimum of 4'6" to 5 feet deep, otherwise they don't support 2 rows of trees the way you're showing.
okay.
Okay. Are there any speakers on this? No? Okay. So, what do we have?
In January, there's the 25th space available on the 15th. Is that too soon?
Probably, because we need a turnaround.
We could, I'm hearing you speak, I don't think it'll be too long because the team is ready to respond to all your comments immediately. Stonefield will have the paperwork into DOT probably before the holiday, I'd imagine, before even Thanksgiving, you could submit everything the next day,
That's,
next week.
February,
yeah.
with the January 16th submission.
February what date? Yeah, that's great, thank you.
Good. So as soon as you have your DOT information, your traffic study information submitted, don't wait for the submit date so that we can forward it to you. Okay.
Thank you.
Thank you. Happy Thanksgiving.
Thank you.
Item number, I'm sorry.
I just want to check with everybody. Yeah, I just want to check how everyone's feeling. Good? Okay.
Item number 8, second call, 17092BZ, 23204 Northern Boulevard, Queens. Please remind you that you're still under oath.
Yes, Sandy Anagnostu.
Okay, and so you submitted that one piece of paper?
Yeah, I
that's all.
forwarded to all the commissioners.
And everybody, somebody saw that it was submitted, right?
Yes, I
Okay,
saw it
good.
was submitted, it's submitted to submit, and I sent it to all the commissioners.
Okay, so then I already closed this, so I'd like to make a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
And sorry, just a notation, all the same conditions apply that applied previously.
Okay. Keep going?
Yeah.
Okay. Appeals calendar, item number 10, 2016 4330 and 4331A. Item number 11, 2017 30A. This is 16 and 19 Tuttle Street, Staten Island. And item number 12, 2017 226A, 18 Tuttle Street, Staten Island.
Good afternoon, Elise Fullader from American Platinum PC. I updated, and I hope L'Oreal and Tony got it, L'Oreal's not here now, the draft restrictive deck.
I saw it, yeah.
I put in the new language from the HOA.
Yes, understood. That's fine. Okay, thank you. So the only thing that has to, is a question is fire department, unfortunately. So,
Yeah, it's not an issue come up with the fire department, sorry.
I didn't expect that.
Sorry.
Good afternoon, John Daly, Fire Department. We had received the revised plans yesterday, which I forwarded to operations, so we'll need them approximately 1 month to review. If I get it sooner, I'll submit it right away to the board. I apologize for the delay.
okay, thank you very much. Sorry about that, but thank you. So, but we can put this on, we can close and we can put it on for we can just put it in whatever month. When you say a month, when?
No sooner than that. Can we do December for her? Can we
Yeah.
squeeze it in?
The last hearing in December, would
December 11th.
December 11th work? Would we have it by then?
Before then?
No? That's only 2 weeks.
I agree with that pace.
Yeah, but if we, so you won't have it by December 11th. All right, the first week of January then?
January.
Have 20.
That doesn't matter. All we need is fire department.
I will literally just say my name, hopefully.
Yes, you'll say your name. You don't have anything to do, so, okay, thank you. Are there any speakers on this? So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And just a note that if the fire department has comments that cause it to be reopened, then we reopen, okay? But if it
I'm just
doesn't-
putting other FDNY here.
Right, okay. Okay, thank you.
Item number 13, 2017 59A, 3857 Ocean View Avenue, Brooklyn.
Good afternoon, Elise Fullader from Eric Palatnik PC. I spoke with the architect last night, and he says that the building is supposed to comply with Appendix G, so he will update the plan on Z003 I saw it was on accordingly to show that it will comply with Appendix G. That's what he said on the phone. I will make sure he does a clear indication on the plan.
Yeah, because this was in the Hurricane Sandy area, wasn't it?
Yes.
Yeah,
And you guys you weren't part of the program because you had the commercial or something, or it was too late, if I remember correctly? Something. if I
yeah.
You're
remember.
talking about build it back.
Build it back, sorry.
Yeah, because this has a
Thank you.
community facility
Right, but-
in it.
Yeah.
No, what the architect had said was that Appendix G didn't apply in this case because it's not a substantial improvement. I was a
He
little
told me on the-
confused.
Yeah, so I will unconfuse you
Okay.
in the next submission.
Because the fact is, there's occupancy below the flood elevation, so you have to comply with Appendix G, whether or not it's substantial improvement. Okay.
He says it's supposed to.
then we're still waiting for the house connection with DEP?
Yeah, he says he is having some trouble with that because of the GCL situation. I guess he hasn't done with this, getting the site certification. And I gave him the contact person from the DEP's information, and hopefully that provides some.
Yeah, Bashkar has left, so it's a little behind.
The what?
Bashkar has left, Mr. Bashkar has left.
Oh,
So.
So if there's anybody else you
Yeah.
think would be helpful,
Yeah.
I'll send him that information. So
Yeah, you can call Polina and them typically.
So that's someone at DEP that...
Right, they're the ones who look at all of this, and unfortunately, one of the top people have left that we coordinated with on all of these, and it's sort of slowing it down.
Okay.
They're trying to,
Okay, and then I just want to draw your attention to something that will be a condition, just because that's what DEP wrote. DEP said it requires the applicant to submit a site house connection proposal application showing the method of disposing sanitary and storm discharge from the proposed enlargement. It says, it is anticipated that the proposed sanitary and storm connections and available water connection will be maintained by the owners and will not be maintained by the city of New York. That's the condition that we would include. And actually,
I think you corrected that, the deck yesterday, right?
what?
The restricted deck?
Yeah, she did that, but I just wanted,
Oh, this is a different case.
Oh, I'm sorry, that was Tuttle.
Yeah.
yeah, that was Tuttle, sorry. So what did we do on this? So maybe we could put that on the drawing.
Okay, I'll ask for a note.
So the note is
What's on
sanitary and storm connections and available water connection will be maintained by the owners and will not be maintained by the city.
Thank you.
Is this is a single-family home, so the restrictive deck is just, it doesn't make sense. It's just to put the owner on notice, or like that. I wonder if we could have something like that. It's not really a restrictive deck, it's more like notifying the owner that you're responsible.
Right, so
I don't
the
know what
language from the language from the DEP letter is what you want.
Yeah,
On
on the
that
drawings, and it will be in our resolution, but I don't know what else to do to put the owner on notice about this.
Do you want any, like, restriction before permitting or C of O or anything like
No,
that?
but it's not a restriction, it's just letting the owner know that, by the way, this is your responsibility, and we don't have an HOA.
Okay.
Well, I'll let the owner and the architect know that it's going on the plan.
Yes,
So everybody's on the same.
We'll think of something.
Okay, what,
For that. Okay, date?
Yeah.
Oh, date. Well, a lot of it is you. Storm, that connection permit?
Still struggling with that, so I guess a month or two. I mean, I don't know how long.
February, sometime in late February?
So sometime in February, since you're giving people February 10th.
Okay. February 12th or 26th?
Okay. February 12th?
Okay.
February 12th, and what's the?
With a submission date of January 23rd.
January.
Zoning calendar, item number 14, sorry, yikes. 26814 BC, 23106 Northern Boulevard, Queens.
Tara? Get one of your fireballs. Thank you.
No, this one. This one. This is for me.
These things are cool. I love these things. These things are cool.
That's where you in.
I'm gonna give you that sugar. Fantastic. Thank you.
Okay, raise your right hands. Do you affirm to, sorry, the whole, to tell the whole truth, the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? Okay, proceed.
Good afternoon. Josh Rhinesmith of Ackerman LLP, appearing on behalf of the applicant this afternoon. I'm also joined here by several members of the applicant's consultant team, including Peter Duran of Equity Environmental, the project's environmental engineer, Miwa Ng of Sherwood Design Engineers, the project's civil, and Barbara Cohen, the project's financial consultant. I'd like to take this opportunity to address some housekeeping items. There's some of the items that were raised yesterday that I can specifically deal with, and then I'll introduce the consultants to speak about the specific matters that pertain to their expertise. At the review session yesterday, more substantive landscaping plans were requested. We have landscaping plan, but then we also have some details in the materials provided by Sherwood. I think we need to combine those two to provide more detail both on a section basis as well as the different types of plans. So we'll work with Sherwood and the project architect to marry those two plans and provide additional detail on what is going where and then the depths of soil for each of those plantings. We'll also provide a lighting diagram in our next submission. And I've asked the project architect to take a look at the concern the chair had raised about the entrance and the ramp and then the elevator in the main entrance on the new portion of the building. So we'll either revise to address that or provide with an adequate explanation for why it needs to be that way. Also, we have a ZRD and CCD1 that we're still working through with the building department. We should, without a doubt, have that approval by the next submission. And VHB is the project traffic consultant. They've taken new counts of trips entering the existing restaurant, as well as occupancy figures. Those were taken in mid-October, and they're currently putting together their final survey, which would be then submitted to the Department of Transportation through the board for DOT to sign off on their survey methodology, at which point they can complete their analysis, and then we'll submit that into the board. And some of the items that were asked at the last hearing we'll be able to address once we have that updated traffic report, and that has to do with the traffic, the trip generation, parking demand analysis, and demonstrating how all the parking demand will be met on site. Then there was a comment yesterday raised about the size of the floor area being requested with respect to what can be built as of right. I think the comment was mentioned about 9,000 square feet is shown as of right under the R1-2 zoning, and we're proposing 15,000 additional. So there are two issues that I just wanted to clarify and put some context to. First, this R1-2 zoning, I think we can all admit that it's severely outdated. This was always a stretch of commercial uses at the time of the 1961 zoning resolution. And so we provided an analysis demonstrating what could be built in a C1-2 district, which is the closest commercial district to the subject site. There's some C1-2 mapped closer to the intersection of Northern Boulevard and Douglaston Parkway to the north. And in that analysis, we are significantly under what it would be permitted in the C1-2. The other thing that I just wanted to point out is the 9,000 of as of right residential was an analysis of what could be built on just the gas station parcel. If you recall, this site involves a gas station parcel and an existing restaurant parcel. Our proposal is on a merged zoning lot of both. And so the permitted floor area, if you just did a residential FAR calculation, would be 34,000, because the entire zoning lot has 68,000 square feet of lot area. 0.5 FAR would be 34,000. What we're proposing is 22,900, which is a 0.33 FAR. So I just want.
That is based on the R district.
That's based on an R12. Obviously, it's not necessarily equivalent. There's not a commercial FAR regulation for a residential zoning district, but just in terms of the size of what we're proposing as it relates both to an FAR regulation in the R residential district, as well as our comparison that's contained in the statement of facts with respect to a C12.
And this is based on measured lots, right?
Correct.
So, sorry, 34,000 square feet under the R12 would be permitted on the entire
On
lot?
the entire zoning lot, correct.
And the proposed entire is 22?
22,910. Okay, so it's a .33 FAR. So it's under that R12, but it's even more significantly under what would be permitted in a C12, which would be a 1.0 FAR. Then there was some questions at the last hearing. The contract rider was asked. So as we've disclosed in our prior submissions and at the hearing testimony, the prior seller is responsible for some of the, or for remediation costs. And specifically with respect to the removal of the tanks, the removal of contaminated soil, and there's some question about whether some of these additional costs that we're notating as hardship costs for the applicant should be covered. I think the question is whether that should be covered by the seller. So the contract, and it's a little bit murky with respect to the extent of the remediation cost, the actual removal, and who's responsible. Clearly, the initial soil removal, tank removal was was the responsibility of the seller. Questions about additional removal have gotten a little murky. I think the applicant has actually been paying some of those costs just to get the work done. That being said, we haven't included any removal or remediation costs in our hardship. What we've included is the mitigation for future development. So we've included costs associated with essentially creating a box that would prevent future migration of contaminants, and we have Equity Environmental here to talk about that and explain exactly what that system entails, as well as costs associated with a vapor barrier and vapor depressurization system for the new building. So the seller was certainly responsible for costs with soil removal, but for us to develop the site and ultimately close the spill number, we're responsible for implementing certain forward-looking mitigation measures. And again, that's going to be preventing migration of groundwater contamination and the subslab depressurization system. So those are the only hardship costs that we've included in our analysis.
If the seller was responsible for the cleanup of the site, and I'm looking at the rider, and I see that it's kind of protecting the purchaser from past and present contaminants. And as far as I understand, there is no other such activity that caused any contamination to the site beyond the gas station use. So the seller is responsible for removing all contaminations.
Correct.
Where from can any further contamination arise?
So I think part of the issue is that some of the contamination is found to have migrated under Northern Boulevard. And so that contamination cannot be, the soil cannot be excavated there without impacting the structural integrity of Northern Boulevard. And so with groundwater flow, I'm told some of that continues to be present in the groundwater on our property. And so now for us to build on the property, we need to essentially create this box that prevents future groundwater contamination from migrating towards the wetlands. And that mitigation is what, those mitigation efforts are what we're including in our variance application.
Wait, so you're saying contamination is coming from Northern or going to
Going towards.
Northern?
I think it's coming from under Northern. So there's some.
Let me just make sure that we got this right. because
Yeah.
What I got is kind of confusing. So you're saying in the past, it was contamination on the side. The seller came in and he cleaned up the side. But previously, some contaminants, some way, got transported to adjacent areas, like northern.
That we believe.
And the concern now is this contamination is gonna come back to the site, so you wanna contain your site to make sure that.
So what we believe has happened is the seller removed the tanks, they removed the soil. Additional soil was actually removed after additional testing. And then we waited a little bit to see what impacts that would have on the groundwater.
Can we say that the seller cleaned up this site to the satisfaction of the government agencies that have jurisdiction of this site?
I would need to, before I say definitively that it's been cleaned up to any agency, I want to confirm with the company that's doing the testing and has been monitoring this. However, what I will say is, once all of that soil was removed.
Cleanup is not just.
Wait, can we
Can I please-
let him finish his sentence because I want to hear what
Cleanup is
happened.
both soil and groundwater.
Understood. Okay. So once it was removed, we believe that there's some type of residual contamination somewhere. The thought is it's coming from somewhat under Northern Boulevard, and that can't be removed. We can't remove that soil. And so there is some low level in terms, the levels of contaminants in the groundwater have gone down significantly. But there is still residual contamination in the groundwater that can't be removed. And through discussions with DEC, believe the best way to address this is in constructing essentially, we'll utilize the meadow mat below. Okay. Okay. Then put the steel around the edge to prevent horizontal migration, and then have the top of the site capped. That way, we're not at risk of having any of that contaminated groundwater on our site moving off-site. And that is the system that we've designed to allow us to develop the site.
But, so if I go back to the rider, and the rider says, if the water samples, and I guess that's what you're doing, right? Water samples now, show higher contamination levels than the testing of June 15th, 2012, and show levels where the appropriate governmental agency requires remediation or monitoring in order to obtain a closure letter, then the seller shall comply with said remediation. So if contamination migrated to Northern Boulevard, and now it's somehow or other flowing back onto the site, how is that not finding levels where the appropriate governmental agency can't submit a closure letter, issue a closure letter?
And the way I would read that, and what I anticipate DEC is going to acknowledge, is there's nothing that can be done to take that soil out of under Northern Boulevard. So the only option is not one of remediation, but containment. And the containment that would be what we're proposing in terms of the development. So we're mitigating the risk of this underwater contamination, or I'm sorry, groundwater contamination by stopping its flow, both from the surface and water coming through the ground, as well as horizontally and below, so that it cannot migrate toward the wetlands. There's nothing, from my understanding, there's nothing else that can be done
Right.
remediate in terms of taking out the soil or cleaning.
So your interpretation of the rider is as soon as it stops being, quote, remediation, it's no longer the seller's responsibility, even though they're responsible for monitoring?
Monitoring, yeah, I would say that would be my interpretation, and I would be confident that it's an interpretation that probably would be.
Well, so that's, okay, so because you're not an environmental lawyer, and I'm thinking that the property owner, of course, doesn't want to pay this money, right? So normally, there's an environmental lawyer who would sort of duke this out with the environmental lawyer who wrote this rider, and to try to get more money from the seller on expensive, whatever you want to call it, containment, otherwise known as remediation. Ultimately, aren't you remediating the site by preventing further contaminants from leaving the site and contaminating a wetland or a public park or
Well,
whatever?
it would be contaminating its own site, because if you don't have that containment measure in place, then the contaminant's going to leach right back onto your property, which ultimately, wouldn't that fall under the responsibility of the seller to constantly be cleaning this out through time?
Look, I don't want, what I'm going to do is I'll review this with an environmental attorney in our office. But I'm not certain that everybody who drafted this, it was an environmental attorney and is hinging on the specific language or knew what it intended. All I know is the seller is not paying for anything. The purchaser has been paying for some of this remedial activity. We haven't included that in any of our analysis. It's all been so we paid for some cleanup, as well as all of the current monitoring that's going on. And we are proposing the installation of this system that will prevent it from migrating offsite.
So is your client represented by other types of counsel?
Yes.
So it would really need to be an affirmation from that counsel that they have pursued all the legal remedies. I mean, if I purchased a piece of property and I thought it's going to be delivered to me clean, and I paid a significant amount of money for cleanup, and then I find out that I have to spend another whatever it is that's huge, and that was not what I understood, I'd call my lawyer to call his lawyer, and they would duke it out, right? So if you're saying that negotiations have stalled and it's been taken as far as it can be taken, and they even pursued litigation or something, but you're not the counsel who handled that, right? We would need something from that counsel.
I will provide an update on that, as well as review this with Rick Leland in my office, and we'll come back with a response that addresses this issue.
Just very quickly, number one, the containment is some sort of remediation. So it's not something that is isolated from the initial remediation that's done by the city.
I'm sorry.
This is my understanding. The containment is some kind of remediation for your site. So it's not something that is isolated from the remediation that's previously done. This is number one. Number two, what I'm getting is the contaminants transported to somewhere. I'm not going to name the area. And then the fear is it's going to come back. I can't think of like naturally occurring reason to impose condition like this. Never, unless you reach.
Impose which condition?
I cannot think of a reason to impose a condition like making the contaminant move from your site out to an adjacent area and then come back. I never heard of that.
They didn't do it intentionally, I guess.
Unless you do some sort of recharge somewhere adjacent to the site. You raise the groundwater table so it flows to the adjacent areas. I see the you're the environmental engineer again.
Yeah, maybe we should be speaking to the environmental engineer about this, please, so.
If there is a condition like this, groundwater start moving towards your site, and then your fear is legit. And let's put all this aside. The containment, if it's considered necessary, I believe it should be paid off by somebody else if you have this kind of agreement?
Well, I do want to make clear that the rider originally contemplates just, I mean, there's language in here that talks about just the removal of soil in the tank.
No, it doesn't. Where is it? We don't have it if it does.
Yes, it does. In 6, I mean, it talks about what they're agreeing to do would be to remove the contaminated soil where required, surrounding and below the tanks, only in compliance with government codes, okay? So what I've been, and look, I think we need it, and Mr. Duran can talk about some of this.
Right.
He's engineered the system that would do the containing. We have another consultant that's actually has been doing the monitoring and the actual removal, who's not here. But also in connection with the environmental review of this application, we've submitted to a new round of phase 2 testing, which the results just came back in, I believe on Friday, that they're being analyzed. So we may get a clearer picture on this after doing the additional, and I'll have to have Mr. Stewart of Advanced Cleanup Technologies come and explain exactly what has happened. So I don't know if you want, there are some other things I wanted to speak about before.
So I don't want you to confuse the issues. One issue is absolutely we want the site cleaned up. We don't want to pollute the adjoining park, all of that stuff. That's not the question. The question before us, because it's a variance application, is what part of the claimed costs are really your costs? When I read that rider, the rider says we'll remove the soil and the tanks. But it also says if after removing that stuff, the remediation doesn't meet the requirements of the governmental agency, we'll remove other stuff, right? So, and it doesn't specifically say remove, it says remediate. So then, because we often unfortunately see sales contracts that are very unclear, written by lawyers and shouldn't be so unclear, but nonetheless, then that gets duked out either in court, with settlements prior to it going to court, et cetera. So that's the question that we have. Has this been taken? Because we don't want, the BSA's job is not to resolve contractual problems, right?
No.
So to the extent that the contract allowed for compensation, we should be, let's say, aware of the level of compensation so that the only thing we're talking about is kind of what's left, right?
Okay. I fully understand the
Which
point
kind
you're
of makes this premature.
Right.
trying to make. But what I want to do is put together a timeline of everything that's been done and by what party, and then where we are. I mean, we're speculating as to what's going on behind the scenes. We'll try to get a clear picture, outline that, and then can take up this issue once we all have more information.
Okay.
And actually, in number 10, right before 10A, it talks about contamination. It didn't specify whether this is a soil contamination or groundwater contamination. And it's even given the purchaser like a long-term protection, like a warranty for this side. So it's,
right.
I believe the language in this rider is very good.
I'm not so certain. I need time to review and I'll tell you my exact.
But again, it's, since you're not litigation counsel in that you're not real estate counsel for the deal, like I assume, and you're also not environmental counsel who might have been brought in to negotiate the deal at the time of the contract negotiations and how much was going to be paid by whom. I mean, I've worked on deals where the seller says, too bad. You want it, take it as is, I'm out of here. But this isn't one of them, right?
I understand, again, I understand the point that you're making and what needs to be addressed. I think the rider needs to be read in its entirety and not necessarily picking pieces out at once. I want the opportunity to review that with our environmental counsel, as well as the transactional, and that in connection with all of the history that it's a voluminous record that we've already sort of outlined of what's going on at the site. We'll distill that down to address this specific issue.
Should we continue discussing the environmental issue with the environmental engineer today?
Yeah,
Because Tom, if we gotta continue considering this, if it's possible. I have significant comments on the quantity of the sheeting and the environmental.
Yeah, well, I think we should get that out there, right? Because assuming that, just for argument's sake, that they've reached the end of the seller's responsibility and it's been duped out in court or something, then the next step would be part of that step.
Yeah, and certainly I just want to make sure that I've gone over everything else before I introduce Mr. Duran. I unfortunately have a flight that I have to catch, so I have to leave by 3. I have Frank St. Jacques from my office who has been working on this as well. But we're pretty close to the point where Mr. Duran can come up and speak, and then we'll have the Sherwood design engineers come up and speak about the stormwater management. The only, I think, other main thing that, two items I wanted to address, and I think I can do this quickly. The comment that the board had about the noise analysis, proximity to the path in the park. We're going to work with both, we did an analysis that showed it would be screened out. What we'll do is we'll work with the project architect as well as equity to either provide some type of buffering to make the board comfortable with any noise on the rooftop, or provide you with some type of advanced analysis that would show what the anticipated noise generation would be compared to the ambient sound that's generated by traffic on Northern Boulevard as well as traffic from the nearby Cross Island Parkway. So we'll go either one of those routes, but we'll address that comment. And then the only other comment I wanted to mention before introducing Mr. Duran is we understand that right at the time we were submitting on this item, the board released a new format or template for providing construction cost estimates. We're going to have our cost estimates converted to that form and address it. And I think both that as well as Commissioner Shetta's comment about having it in the new format, as well as hopefully this will help address a comment that Commissioner Utley Brown had made regarding the price per square foot and trying to compare apples to apples on the proposed restaurant enlargement versus the retail.
It was reconciling what the construction cost actually applied to. Was it just the new space or the new and old space? Because it's not clear when you try and back out of those numbers.
And I can answer that question. It is definitely just the new space.
Because it's coming up with 29,900 square feet, which is way more than just the new space.
I think it's gross, and this is why I want to have Mr. McQuilkin put it all into the new template to show exactly where these numbers are coming from. But I know I've had this conversation with him that it does not include the existing restaurant. It includes the entire proposal.
Right, but when you do look at the same equation with the as-of-right retail, it works out perfectly to the 8,811 square feet. So that's where my concern was rising from.
Understood, and we'll address that. I think that the difference in terms of at least the price per square foot calculation with the restaurant where we have a defined user that has a build-out space is going to be different than a vanilla box retail, just in terms of cost.
Right, no, I wasn't questioning that. I'm questioning the square feet, given the total, because you had a total base construction cost, and then you had the base cost per square foot. So then I'm taking the total construction cost, dividing it by the cost per square foot, and coming out with 29,900 square feet.
Okay.
When I do the same with the retail, take the base construction cost divided by the cost per square foot, I get exactly 8,811, which is what you said that building is. So that's where...
Understood, and I think Ms. Cohen can actually speak to some of that. I think the number that you're referencing may be a calculation she did that was more simplified. It was just square footage versus construction cost. But regardless, we're going to have Mr. McQuilkin update his analysis to reflect the current template and then address that issue once that's all laid out. So hopefully in the next submission, it's much clearer.
Okay.
Okay, so those,
And just for all of these submissions, so that we don't have to figure out where you're answering a question, please, in the cover letter, be very specific what questions you're answering, and tell us where the answers are, right?
Yep.
Okay.
Okay, so.
And also, just to add to this, we talk about what we talk about in this hearing, but you also need to listen to the review session and make sure you picked up all the comments, right?
Understood. So at this point, I'd like to introduce Mr. Duran, who can talk about the system that's been designed and its purpose, and then answer some of the questions that you have regarding the sheeting, et cetera.
Good afternoon. I'm Peter Duran, professional engineer in the state of New York, and I'm with Equity Environmental Engineering. So, your question about where you would get this type of a situation, the location of this property is very close to a saltwater body where we do have some tidally influenced water. So you could get groundwater levels going up and coming down. So you could get a situation where you had contaminations moving one direction and the other direction.
Because of that adjacent wetland?
Yeah.
Okay.
All right, so that would be, my thought on that. When I took a look back at the cost estimate that was prepared by Advanced Cleanup Technologies, in their summary, they talk about concentrations of BTEX in off-site monitoring well MW1, an order of magnitude higher than the 3 on-site wells. And they say that this could indicate that there's a source coming onto the property from off-site. And if that source, and they talk about a site with an open spill number, 350 feet to the east, if that was the site and that was the case, you could have contamination migrating onto the property.
Yeah.
Okay?
So a question about that. I'm just guessing because you're an expert, you've been asked to testify as an expert in court cases. Have you ever?
I have.
So, so in a situation like that, where there was a rider sort of like this one, where the new property owner says, you seller said you were going to cover all the contamination, and you're not doing it, and would the seller's expert therefore say, no, but actually that came from spill number down the street? Or could have done?
It's a good question. I would, kind of be stepping outside of my expertise to answer it.
It'd be very,
I think it could be handled in any one of many different ways.
Okay.
But my understanding is that the remediation that was already done on the property was excavation of contaminated soil in 2 different instances.
Do you recall how deep was that excavation?
They do have some indication as to how deep that was. I don't recall off the top of my head. Let me take a look.
It would be a little
But I
bit
do know
unlikely.
that, they got to the point where they got into groundwater and they stopped excavating at that point, which is very common.
So they just dug 6 feet?
Their initial excavation consisted of 309 tons of petroleum impacted soil. And then they came back again and took out another 50 tons of contaminated soil.
Yeah, but this is not going to give you like any, it's just tonnage.
You're right.
So we don't know, are there other documents that might reveal the depth of excavation?
Yeah, I believe that there are. Once again, I don't recall it off the top of my head.
Okay.
Yeah, just to point it out to the board, I think we've submitted at least 3 different reports from Advanced Cleanup Technologies. I know probably the depth of excavation is included in some of those reports, so we will basically restate where that can be found and what that information is, how deep that excavation.
Yeah, it looks like they excavated down to the water table at 6 feet, but that's just based on what I read.
It was an initial, I saw it last submission, it was an initial evaluation of the cleanup cost, the additional, I mean, I would say the containment cost of about 700 plus. And then this submission, it went up to 1.6 million. I saw like a table.
I need to verify exactly, but I know Equity Environmental's estimate has been in the record since at least 2016. So, and it's been the same 1.59 million.
I'm not
So
saying-
I just want to make sure, what table you're referring to and what that actually entailed. So I can properly answer. But I know at least the 1.6 million has been the hardship cost for quite some time.
Please continue.
Go ahead.
Regarding the cost estimate for the cleanup of the containment,
Damn it.
you're the one who prepared this?
I did it.
Okay. Are you familiar with the subsurface conditions of the site?
I am.
So I did read through the PR form that's submitted, and my understanding is we have 15 feet of fill, and then you have this clay material that could be considered as impervious material.
So what I saw in the reporting that I read indicated that there was fill that sat on top of a peat layer or meadow mat on top of clay.
Yes. And the fill thickness was about maximum 15 feet.
Yeah,
Right.
and I would say it's probably in the range of 11 to 15 feet because this property does slope towards the wetlands.
I'm going to assume that I'm going to buy the idea of the containment is needed.
Right.
So I'm going to presume that we're going to move forward.
Okay.
The site perimeter, when I say the site, I'm talking about the gas station parcel.
Right.
The perimeter for this is about 550 feet, based on the drawings that's submitted.
Okay.
If you want to contain this site, you don't need more than a carrefour that's penetrating into this meadow mat / clay material, couple of feet, to make sure that groundwater is not going to go out or infiltrate out. 550 times 15 feet plus, let's say, 2 feet or 3 feet. When I get to this quantity and I compare it to the quantity that is given in the estimate, if I take the quantity in the estimate, I divide it by the perimeter, it gives me 35 feet, meaning that the sheet pile tank is 35 feet in length. While when I look at the subsurface is just 15 feet of fill.
Right.
All what you need to do is to just insert a piece of whatever, 15 feet plus 2, which is 17. Let's say 17 and a half as compared to, actually the number was 39. If I go 39 versus 17 and a half, this is more than double. So what is the
So
explanation?
when I did that calculation, I based it on the perimeter of the site.
Yes.
Okay? And then I based it on a 20-foot depth, not a 35-foot depth, at 50 feet per square foot of sheeting. Those were my basis, my assumptions.
So you consider 5 feet of embed.
Correct.
But 550 times 20 is not the number.
Well, I can certainly go back and look at that, but that was my assumption when I put it together.
So this is one thing I want to take a look at. Okay. The other thing, you just need a cut, right?
Yeah.
If I tell you that I'm going to go with like a magic machine, insert plastic sheeting all around, and this is going to prevent water from going out or going down.
So the
That
problem,
works for you,
the problem that we have with the plastic sheeting is how do you get it in place unless you're going to trench it? And if you're going to trench it, you're going to have to dewater to be able to install it.
You don't need to.
So when we took a look at this, we took a look at, well, what's an economic method of putting some type of...
I'm sorry, maybe you misunderstood.
Sure.
I'm not talking about plastic.
Right.
You're talking
I'm
about
talking
sheet
about
plastic.
vinyl sheet pipe that I drove it 20 feet in really dense material. So it's the machine that drives this
Yep.
is very comparable. It's actually the same machine that drives the regular sheet pipe.
Understand.
The only exception is that the material for the vinyl sheet pipe is much lighter. It's much less expensive.
Right.
And considering the price difference plus the depth difference, which I believe could be cut into half, the 1.6 million could be brought down to probably 20% of that.
Understand.
So
I
take a look
don't
at
know that for a fact, but I can tell you that when I was asked to do the cost estimate, I was asked to use standard materials for doing this cutoff wall. And so, and our standard materials are
If you're
steel sheet.
excavating, I would take it.
Right.
If you're using this as an SOE, because in the wording in your submission says sheet piling / bracing. I don't think it's going to be any bracing there.
No, there's probably not going to be any bracing.
Who record, I'm sorry, can I ask a question? You done with your questioning?
I'm sorry?
You done with your questioning? I just had one question.
Yeah.
Just one question.
Sure.
Who required you to use the
The sheet pile?
piling?
No, the metal.
The metal, yeah, the standard issue.
The steel.
Yeah.
Yeah, that's just normal what we use. That's why I used it. When we do our cost estimates for remediation, we look at steel sheeting.
I thought Commissioner Chumda asked about that. Who asked for the containment?
Well, the containment was actually my idea.
So it's not coming from the DEC?
No, it's not coming from the DC, unless I'm mistaken.
I
want to double check that
Yeah.
with Paul.
Okay.
Because what I hear, if I heard it right, it's, I believe you mentioned that it's coming from the DEC.
I believe the method in addressing, I think DEC wants to ensure that contamination doesn't migrate off-site. I don't believe, and if I did say it, I was mistaken that they were directing us to do a containment. I think we need to deal with the contamination off-site, and this is the best way, or from migrating off-site, and this is the best way to do it, is to cap and prevent.
Is the concern that contamination migrates off-site or on-site?
So we have a concern that there is residual groundwater contamination that's coming from somewhere on our site.
Okay.
Okay? So we need to cap it to prevent water from recharging and pushing migration or water towards the wetland, as well as to, and I believe the idea was to contain it all on our site so that it prevents it from migrating towards the wetland. That is what this system is designed to do, is to essentially stop any groundwater from migrating onto or off-site.
Understood.
We had a similar case, I think in Staten Island, that was a Tim Horton site that was right next to wetland, and I think it was a former gas station, and the recommendation was to contain it in the similar way that you have analyzed. So that's why I was wondering if that's a standard practice DEC requires or would require when you do present it to.
Typically, DEC doesn't require that, but they basically say you need to clean up to the remediation standards. That's kind of and how you do that is up to you. It's not, they're not going to dictate that you use vinyl or steel or, slurry trench is another option we looked at, but that tends to be quite a bit more expensive than the steel.
Okay.
So the way that it works then is they tell you you need to meet the remediation standards, and then you present to them your proposal?
Yes, and then they go ahead and say that looks good, or you need to change it in this fashion, or they don't like it and they want you to come up with some other methodology.
One more thing, you look at it. I did look at the phase one, and I see that the tanks were located at the western, southern portion of the site, at the top, if you're looking at the plan view at the top.
Okay.
Is it possible, I'm not sure where are you monitoring exactly and getting these elevated contaminants in the groundwater?
So
if they are close to that spot, isn't it possible to reduce the scope of the containment so the perimeter goes down dramatically?
I mean, it's a good question, and I would say that the tanks, my understanding, were located closer to the sidewalk towards Northern Boulevard. And when you take a look at the results that they have in the monitoring wells that are in that general area, they all still have contamination in them. And the worst of them is the one in the sidewalk, which is MW1. So the idea was we wanted to make sure that whatever was still on site was going to be contained. Could you reduce it? I'm sure you probably could. It's
If
a matter
they've done the remediation previously and they found nothing wrong with the southern part, with the eastern part of the site, I don't see any need for either soil removal or containment at that section of the site.
Yeah, I don't, this is just, our approach to it. And I wouldn't know about the southern portion because when I look at the data, there's no information in that portion of the property.
So I think what we can do is, as I mentioned before, we have updated phase 2 results that will hopefully provide us with the information to respond to the specific issue, whether it can be contained. And we'd also confer with the engineer who's in the field to doing this work to ensure that we're not designing something that is too much to ensure, but also making sure that we're safely addressing the issue. So if it's possible to reduce the perimeter of this containment, based on the recommendations of the engineer after he's reviewed the most recent lab test results, then we'll go ahead and do so.
And to answer your question, when I did the remedial cost estimate for this, I based it on the information that I had at hand at that point in time.
Mhm.
So that's what it was based on. Okay?
Thank you. Do you have any other questions?
Yeah, well,
I have
the
questions
capping is
about
the final, the capping thing.
The capping?
of the site, yeah. Do we even need like capping of this site since the building is gonna be like on top of this piece of land?
Right. So when we talk about capping, we typically look at it in various ways. You can have an earthen cap, which is basically just clean soil. You can have an asphalt cap, or you can have a concrete cap. And the way that we looked at it, because if you look at my estimate, I don't include any capping at all. What we look at is that the building and its slab, concrete slab, acts as a cap, and the paved area, the asphalt, acts as a cap. And so that's the capping that we're talking about.
And the roofs too.
And the roof.
Yeah. So the cap is there.
And the idea is to prevent precipitation from getting into that area and then driving any contamination out of it.
And since you're the environmental consultant to them, I'm not sure why they are electing to go with permeable pavers if you have contaminants.
I'm going to let them address
No,
that.
that's for the other area, the retention tank.
Yeah, I understand, but if you have contamination on site, you don't want to get the runoff infiltrating down. It's much better
Right.
to divert this runoff from going down and recharging the aquifer,
But-
pushing the contaminants
So,
somewhere else.
actually, I think I can shed, and Miwa, when she comes up, will shed a lot of light on this. So we are only capping, and by capping, just making sure that there's no stormwater penetration of the soil on the gas station portion of the site.
Yeah, that's what I'm talking about.
Exactly. So, and we're not using permeable pavers and on any of the site. We haven't proposed that. Okay? Miwa will talk about the advantages or disadvantages and why we selected this particular drainage system. But the idea is to collect all water from the roof and asphalt as well as even the planting areas on the gas station portion of the site. That all gets funneled to a detention tank. Okay? The remainder of the site, that is pretty much the existing restaurant parking lot, is going to have planting beds, and the asphalt is going to be graded to allow stormwater to go into those planting beds. Those planting beds filtrate the groundwater recharge. And then in the event where we have severe storms, then there's a piping system that will collect overflow and funnel that to the detention tank. So the idea is to prevent any water from penetrating the ground on the gas station portion of the site. The remainder of the site will funnel water into the landscaping beds for it to be filtrated and then recharged. And the overflow in heavy rain events will be collected through piping and run to the detention tank as well. So, Ms. Ning can discuss that in much more detail and answer any questions that you have. And I apologize, I need to run.
Okay.
But Mr. St. Jacques will take over and, answer any questions that you have. Thank you for your time.
Thank you. Happy Thanksgiving.
Thank you.
Yeah, could we, unless
Do
you
you have any
have
other
more.
questions for me?
I don't think so, right? No?
Thank
I would like to hear about the detention tanks.
You okay?
Hi, Miwa with Sherwood Design Engineers, civil engineer.
Yeah, so I guess we had a lot of questions. So could you explain again why you don't use permeable surfaces on the site?
Forest paving. Yeah, so the DEC, who's the jurisdiction for the site and regulates the stormwater management, has several different sort of best management practices in order to treat and mitigate runoff on site. And so one of their number one best management practices are bioretention areas, which he was referring to as like the planting beds. And so the planting beds, have like the best capability of filtering out pollutants that come from driveways, parking lots, roof areas, filtering out like phosphorus, nitrogens, metals, and other like sort of total suspended solids. And with the planting beds, you have like easier maintenance with these, because say after like 5 years or so, when you see that, the soil isn't filtering as well, you can just remove that soil, remove the drain rock, and reinstall, that. Versus the porous paving, which does provide some treatment, but is more susceptible to clogging. And once that, that's been sort of severely taxed, then you would have to rip up the pavement and then take out the drain rock that's underneath it and re-pave that system. So it's a little more maintenance intensive and expensive compared to bioretention.
Well, aren't you talking about sort of the artificial paving stones as opposed to the ones that allow grass to grow through where it's planted in soil, where there's a separation between the pavers?
Right, so you can have two different systems, or several different systems. So there's like porous asphalt, porous concrete, which are sort of like kind of look like popcorn type system. Then you could have pavers, sort of like interlocking pavers that are more, that are better for like higher retract loadings, which we would probably need in this parking lot, versus the ones that are sort of like the grass pave that allow plants and things to grow out of that. It's also a little more difficult because those don't always work for vehicle loadings, or like higher vehicle loadings or trucks or something. And it's a similar system where you would also have to, dig up and remove those for maintenance.
Okay. Okay, I guess, what are our questions about this? Did you have questions about the detention?
Yeah, regarding the system that's used, is it possible that you consider impervious surfaces in addition to a good size detention tank and try to manage some outflow to the existing 18-inch pipe?
We're not allowed to connect to the storm drain system in Northern Boulevard, so that's why we have to contain everything on site, and then we get a permit from the DEC that would regulate the stormwater system, so it's not a DEP regulated system.
I'm not talking about the new side connection, I'm talking about the existing connection at the adjacent parcel.
I've been told that adjacent connection wouldn't be able to handle the increase in the impervious surface.
Did you check it?
This is what has been told to me from previous documents.
You could run the numbers, right?
I don't think we're allowed to add any additional flow to that storm drain pipe per the DEP. So we wouldn't be able to connect anything from the new site into that system.
Did you present the idea to the DOD? The DEP, I'm sorry.
The DEP, yeah, I think that was just a regulation based upon like the sewer index maps, that we weren't able to increase capacity for those pipes.
My thinking, let's say the old site, the existing restaurant is tight. And instead of the guy who designed this sewer initially needed 10-inch sewer, but he used 18-inch one. So now we have extra 8-inch that we could use for the adjacent parcel. And in the meantime, if this 8-inch extra is not going to be able to handle the excess flow, the extra flow from the gas station parcel, you could use a detention tank to retain some of the flow, some of the runoff, and then discharge them later, or even send them somewhere, like infiltrate them.
Right, so if we were allowed to connect to that storm drain system, we would still want to do, the best that we could in like treating that runoff that leaves the site. We wouldn't want to, not.
Do you have a document from the DEP that says you cannot connect to the existing? It's not a physical connection, I'm sorry. It's not a physical connection. What I'm talking about is some management of the site, the finished site drains. So instead of the water goes east, it goes west. So some of the water would flow into this existing 18-inch pipe, and you could manage how much of the site you can throw there, and then the rest of the site goes to a detention tank.
So Frank Sajak, Ackerman. I just want to make the point that None of the stormwater system costs are incorporated into our hardship costs. So questions about design, obviously they're relevant here. We can provide some more information about the DEP's decision relating to connection into the existing pipes. Some of that information is in the record. I don't recall offhand exactly where that is, but we can present that for the board's attention in a later submission.
If it's not included in the construction cost, you don't have to do that.
But the problem is it's included in the construction cost.
In the base cost.
Yes,
It's
in the
not
base
in the
cost.
premium
It's-
cost.
Exactly. So once it's in the base costs, then we have to look at it because it's what's in, potentially inflating the cost
To be clear,
aspect.
it's not incorporated into any of the costs in our, we haven't provided a cost estimate for the stormwater management system.
You haven't?
It's not, no.
That's confusing.
Yeah, it seems if I saw something, a number was like 80 grand or something like that.
There was, so previously in, it's been a couple submissions, there was a stormwater management system that was isolated to the gas station parcel. So I believe there's three different, at the time, there's three different scenarios, two as of rights, or a residential, a commercial, and the proposed development. Based on discussion at I believe the previous hearing, we removed the stormwater system costs and discussion of stormwater systems that would be isolated to the gas station parcel itself. Those costs have been removed from all of our materials. So the new stormwater system that Sherwood has designed is not, there isn't a cost yet that's even been estimated.
So then I don't understand why there's so much talk about the detention system.
That's really my point. I don't think we're running into concerns about over-design with the stormwater system because it's simply not incorporated in any of the cost here. It's a function that we understand we have to develop and it has to be developed. And there's certainly a number of approvals that are contingent on it, and obviously for neighborhood character, but it's not a cost issue.
It's not.
I don't get it, but, so that's good. If you could please verify that 14 times so that we're not, okay. So then the question is really about aesthetics and the management of the site, right? And from my perspective, we did have problems with Alley Pond Park being flooded, right? So their neighbors spoke quite a lot about ponding, more than ponding, laking on this site. So what I'm trying to understand is the landscaping areas that are proposed in the parking lot are exactly the same as the current landscaping proposal. So, and that was the site that was suffering from all of that ponding. So I understand, if I understand this correctly, you're going to be digging up the entire site to install this detention system. Is that correct? That's correct. So, but then if you say that the majority of the water runs into these planting systems and is absorbed, and the detention is sort of a backup for when there's extensive overflow, is that correct?
In much larger storms, correct.
In much larger storms. But currently, that amount of planting isn't adequate to handle the demand, right? So I'm curious why there isn't more planting that's proposed on the site than what's currently there.
I can't speak to what is currently there, but with the plantings that we are proposing, the soils are designed to drain like 5 inches per hour. So, and they're sized per the DEC's calculations. So for the contributing area to those filter beds. So the water should flow into there, and then 5 inch per hour is the minimum that the soil has to drain at. So that water would drain through, and then it could be in the capped areas collected through an underdrain system that then is then sent to the detention tank. And anything that could potentially pond on top of those filter beds would then be discharged into overflow structures, which sit about 6 inches above the surface of those filter beds. And then the water from there is collected and sent to the detention.
So, and when the new covering of the parking area is done, some of the ponding may have been because of how the site was sloped.
Right.
So is there also a design of sloping to encourage the flow of water to the planting beds?
Correct.
Okay, so is this all figured out using calculations so that you know this many square feet or a planting bed at 5 inches per hour and so on equals this estimate based on the surface area of the parking lots? Okay, so, but the planting beds sit on curbs.
There's curb cuts to allow for water to.
Oh, I see. Okay.
So you're just allowing infiltration down to the aquifer at the planting beds? The
ones that
other
are-
areas would be like
Yeah, so
no downflow?
the downspouts from the roof areas, we're gonna put first flush diverter, or first flush pretreatment on the downspouts. So that removes sediment, trash, hydrocarbons, other metals from the water. And then you can just take the filters out, dispose of them properly. And then water from the roof then goes into the detention chambers.
It's kind of, you're using your planting beds as like some sort of like dry wells, right?
They're not exactly dry wells because,
Yeah.
they support, plant life and they have soils. But I guess you could potentially say that they're like a dry well.
Did you check the permeability of the material down there?
We're waiting for the geotech reports.
Oh, you're talking about the mat? Metal mat?
The existing fill.
Oh, existing fill.
Even if we were to get back the geotech report and they say, okay, certain terrible soils below the planting beds, the planting beds are still designed to treat that stormwater.
I'm not talking about treatment, I'm talking, the concern of the chair is the ponding, and I'm talking about the ponding, not the treatment.
And then that's why.
If the subsurface material is not permeable enough to give you the design permeation, the 5 inch per hour or whatever, your planting beds will be just swimming pools.
So the filter soils, the soils in the planting beds have to have a minimum of 5 inch per hour. But the soils beneath, per the DEC, have to have a minimum of 0.5 inch per hour for infiltration. So say we get the geotech report back and it says, okay, we have poor soils, it's not, completely suitable for infiltration. That's why the detention chamber is oversized to allow, water to be accepted, treated water to be accepted from the filter beds into the detention chamber. And then even if you have below 0.5 inch per hour infiltration rate within your soils, it'll still infiltrate over time. So that's why the tank.
Yeah, but you're gonna have ponding.
No, well, it'll be inside the detention tank, which is oversized beyond the DEC's.
If it doesn't infiltrate, you're gonna have accumulation
Yeah,
and
how's that
accumulation,
work?
and then it's gonna flood.
I think it'd be
And-
shot into the detention.
And you
center.
know what? Before I forget, I did ask for the geotech, and I didn't get it, and I've been told that we just have the TR forms. The TR form is usually prepared based on a geotech. A geotech guy goes to the site, drill borings, draw logs, and then based on these logs, he prepared the TR form, sign and seal, and send it to the DOB. So if we have TR4s, we should have a geotech. You're talking about somebody who's preparing geotech right now. If this is the case, I'm okay with it. But if you can please have the geotech run some sort of testing to make sure that the infiltration rate you're designing for is there. Otherwise, you're gonna design for something, you get something else, and you're gonna see the mess after the construction is finished.
Right. It's just, to your question, or your comment about ponding or pooling, the detention tank is oversized. So in these larger storms, it'll be able to handle that water in that tank. And then slowly it can infiltrate back into the groundwater, into the aquifer.
I guess the question is, so the rainwater is going into the planting beds at 5 inches per hour. Let's say it's a 9-inch rain. So what happens as it's completely saturated, the planting bed, the water then runs off the planting beds into drains? Is that into the trench drains or something else?
And then into the detention center.
Into the detention center.
Okay.
It's there's.
You're gonna be designing this system for a specific storm and a specific storm duration, right? you're accounting for 5-inch per hour from whatever material you're gonna put, and 0.5-inch per hour for the existing subsurface, right?
So
If you do not get the 0.5-inch, what's gonna happen is, this detention tank that you believe is oversized throughout the storm duration is gonna be filled, and it's gonna overflow, because you have in and out. If the in is different, is higher than what you account for, or the out is less than what you account for, the conditions you're targeting by designing this system are not gonna be there. You're gonna get flood.
So the soils are designed to infiltrate at 5 inches per hour, but the storm prescribed by the DEC that we're treating is a 1.5-inch storm in a 24-hour period. And that storm size is the storm that contains the most amount of pollutants. It's the storm that happens 90% of the year, 90% of the storm. A 9-inch storm in 24 hours, which is much less than a 5-inch per hour event, is a 100-year storm. So these systems are sized to treat that 90%, that 1.5-inch storm in a 24-hour period. So there's no 5 inches per hour coming into these planters. The planters are just designed at that 5 inches per hour so that it can get a filtration rate so it can clean a lot of water. It's not saying that 5 inches of water coming in there and now.
Or coming out, for that matter.
Right. Thank you very much. Do appreciate this. Thank you. Thank you. Interesting. Okay, so if you could just verify that costs related to this detention tank are not being included in our analysis in any form, that obviously.
If they can give us the geotech,
Yeah.
that would be beautiful.
Nice, okay.
Sure,
All
I
right, thank you very much, appreciate it. So I think the only thing, do you have questions for Ms. Cohen?
Right, one of them was what I had just said about the construction costs. So if you can walk me through your numbers, you could just give it to me in a narrative as to how you got to those numbers.
I just wanted, Barbara Cohen, real estate and planning consultant. The two issues was the site value, which will all get sorted out
when we get
all
the
the other prior
information
stuff,
about
but
who's responsible.
I did try to distinguish that in the report, but it will stay or it will go. As far as, I think you're getting the price per square foot for my table, because
Yeah.
it's not coming from the cost estimators table. And that is my simple, taking the total costs, right, and dividing it by the 20, whatever it was, 20, the building area.
Right, which has to be corrected then, because you're only supposed to be dividing that by the
Right, no, I
actual new
understand. No,
space.
right, I get that, I get
And then I'll
that.
take a look at it, and of course, the price per square foot is going to jump up.
Right, because it's smaller square foot and divided by the number, right. And then the template should indicate the notes of where it confirms it's just the new building, et cetera. Yeah, I just wanted to clarify that you were getting that price per square foot from my calculation, which I always do.
It was from your calculation.
Right, which is, but it's true, I can put another line item in and say the new building is X square feet, and then the price per square foot based on that, versus the whole development square foot, which is what I usually do. Okay, yeah, I'm good.
Any other
That was it.
questions? I just, this isn't for Ms. Cohen.
Can I
Oh, go
just
ahead. Yeah.
say one thing? If you look at McQuilkin's sheet at the end, he's got 29,936 gross exterior square feet. And so if you could somehow just let me know what he's
portion,
getting, what
yeah,
those
yeah, yeah.
costs are coming
Right.
from, because I don't quite know.
No,
how to read
I
this
totally
table,
understand. I went to
basically.
his chart in the back, and he's showing the whole development details. and
Right, it should
yet
only
we're
be
saying
about
it's only a
14,000
portion.
square
Yeah,
feet that
yeah.
he should be constructing.
Right.
Okay, all right, thanks.
But I know we've asked and confirmed, it's just a matter of, clearing it up.
I just have one question for Mr. Sanchak, or maybe for the engineer. Does DEC get involved in the stormwater management plan? Do they review that plan?
Yeah, the DEC will review that plan. We submit it to these usually prior to the construction, as part of like the SWIP and the one process, but we can submit that at any moment.
Could you submit it now?
I would, yeah, I could submit it.
It's ready enough to submit to them?
Yeah, it just is a text document and then the calculations.
Right, because that would be great if we could, whatever it is you would normally submit to DEC, if you could give to us immediately, and then we could forward it to DEP or DEC to review, just because, and the reason that I'm asking is because of the concerns of the neighbors about all the ponding, right? And so I just want to make sure we're responsive to the neighbors' concerns.
So,
Okay.
so just to clarify, the applicant will be sending it to DEC and then also providing us a copy so that we could.
Oh, okay, that can, well, normally they submit to us and then we submit to DEC because maybe we have more clout.
Typically, we submit online to DEC, but
Ah,
I
okay.
don't know if that's.
Okay,
We can coordinate with staff just to make sure that
Right.
we're on the same page with that.
okay. We just want to make sure they get it and take a look at it before the next hearing in case they have comments that might have somehow affect the application, I don't know. Okay, thank you. All right, are there any speakers on this? Okay, so I think we put this on for when we can put this on. What's the February dates look like?
February 12th, 26th, they're fine.
What's the 7221s on? Or what's the day before, February?
February 5th, we're up to 18.
That's better, but how many 7221s?
7221s, 1, 2, 2.
Two. Did you see what kind they are? Does it ring a bell?
Story and 14-story.
Oh, so they're both commercial ones. Not good?
Yeah. No, well, one of them, it's already been like looked at several times, so there isn't that much left to do. And the other one, so this one, you could put this on, because this has also been looked at several times.
Okay. So this one, and what's the submit?
January 16th.
January 16th on this one for February 5th. Okay.
That's
And
great,
then put a close, no more 7221, just make a notation for that. Okay. Thank you.
Thank you.
What?
Probably lunch now.
Yeah, so now we're going to take a break, 30 minutes for lunch, which is late lunch. Okay.
You can have, I'm going
30.
to meet the other two. Thank you.
So,
I have more.
we're hot. We're hot.
Okay, we're back on the record. This is the Board of Standards and Appeals public hearing for November 20th, 2018. We'll continue with the zoning calendar, continued hearing items, item number 16, 2016-4272BZ. Man,
Wait, 52 what?
It's 4275.
15
It's
is
14th Avenue,
withdrawn.
Bush Fitness.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
Bush.
Dan Baton from Shell and Lobel PC for the applicant. We attended yesterday's review session, and I know there was a comment regarding the notification, and I mean, it was common practice with those notices, but we know for future that we should include the submit email address.
Okay. Oops. Sorry, I'm maybe looking at the wrong note. 4275, is that what this was?
4272, the 1432 Second Avenue, Manhattan. 2016-4272BZ, 1432 Second Avenue, Manhattan.
Good, okay.
This is Rip Fitness.
Yeah, I was looking at the wrong one, okay.
Me too.
All right, so that was it.
No, there was the notice, didn't include the update.
No, that's what she just spoke
okay.
about. She said it was standard practice to just put that kind of a notice up, but going forward, the notice will always say people should attend, could write in. Are there any speakers on this one here from the public?
Nope.
Okay, this is 1432 Second Avenue? No? Okay. All right then. So then I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
And a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Item number 17, 2016-4275BZ, 132-15, 14th Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Good afternoon, Sandy Anagnostou representing the applicant. I attended the review session yesterday. We received a letter of no objection from the fire department. Also, we have an issue. I made a submission showing the proposed accessibility and proposed chair lifts. However, there's a problem with one of them, which would service the basement to mezzanine level. There's a problem with the overhead clearance. What's required is 94 inches, but unfortunately, there is an I-beam in that location, so the actual measurement is 87.5 inches, so we have a difference there. We initially went to the Department of Buildings to address this with the plan examiner, then we filed an application with the mayor's office for people with disabilities. That was several weeks ago. They actually contacted us, and although the Commissioner of Buildings said we didn't need an actual objection, the mayor's office requested one. So we prepared an AI-1, which we submitted to buildings. We're waiting for that to be signed and stamped, and we're going to submit that back to the mayor's office.
So the mayor's office said even though you put the application in, you needed an AI-1 from DOB?
Yes, an objection. So this process, we're going through it, but I'm not sure how long it'll take. But we're asking for, not to waive the chairlift, just to waive that differentiation.
From the mayor's office? You're
Yes.
asking for that? Oh, so you, I see. Okay. So are there any speakers on this? So what was outstanding here was, so we have the sign-off from fire department. What was outstanding here was handicapped access. And this was a legalization, right? So the question for the board is, do we assume they're going to do the right thing? Or do we wait for the lift to be installed, which we often do?
Well, we did file an O2 application. That was professionally certified, so we changed it, made it standard, so it has to be reviewed. We're addressing this issue. The owner, he couldn't be here today because he's away, but he's committed to this. He has a contract, which I submitted with the handy lift company. He's committed to doing it. He has to do it. It's just a matter of getting the approval. He doesn't want to go ahead with doing the work when, especially with this issue.
I feel the applicant has made all the right, taken all the right steps in addressing this issue, and I think it's a matter of having it resolved with the mayor's office.
Well, it is that, but the question
Right.
is, do we wait or do we
I think we should make
close
it
and make it a condition?
I think in this case, it would be better to use as a condition because there could be several amount of back and forth that may happen with different alternatives, so it could be best.
Okay, does everybody else agree with that?
It's okay.
Okay? Okay.
Okay.
All right. So then I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition that compliance with fire department sprinklering and fire alarm systems shall be made in public assembly to the extent that that's required, and that the handicap lift shall be installed.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Thank you.
Item number 18, 2016-4472BZ, 24501, 24513 Jamaica Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions? Okay. Sorry.
Amber Khan from Sheldon Lobel PC. For the applicant, we attended yesterday's review session. And I know the outstanding issue was the FDNY review, and I believe a letter was submitted yesterday from the fire department. I don't,
Okay, so we have fire department. Okay.
John Daly with the fire department. Yes, I submitted a letter last night. I apologize for the long delay. Our LPPA unit, license plate, public assembly place, whatever, sorry, has issued a violation order to obtain an operating permit. And currently, the inspector was there last week. He will be enforcing that order because they haven't filed a PA to date. But we'll follow up on this and enforce or take whatever actions that we need to do.
Okay, so it's okay for us to proceed because you've got it.
Yes, we have it, yes.
Okay, great, thanks. All right then, are there any speakers on this? All right, so other than the condition of the ADA compliance, because you've agreed to install that lift, and this is not a legalization unlike the other one, right? It's a continuation of an existing PCE. Okay, so I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta? Aye. Commissioner Shabeta?
Aye.
And a motion to grant on condition that the handicap lift be installed as shown on the drawings.
And the FDNY thing?
Sorry?
You want to condition the FDNY?
Oh, I'm sorry, and in compliance with the fire department's violation order, inspection requirements, and bringing the sprinklers and fire alarm and the public assembly permit up to date.
Chair Promoter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Okay. 1, 2, item number 20, 2017-224, 2-4 Spring Street, Manhattan. Okay, raise your right hand. It's only you two? Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions? Please sign and then proceed.
Hi, good afternoon.
State your name,
Please state your name.
Sorry, Caitlin Graham, on behalf of Tuttle Yick and the applicant. I believe we did watch the review session yesterday. We do have an update in terms of their fire alarm system. I have here, we submitted the response electronically on 10/31, but right after that, we actually got a sealed set of plans from the engineer. I do have a copy here, but we can submit that formally later. And we also have copies of the Alt 2 application and the cost affidavit that were filed with the DOB on, that were filed with the DOB on November 1st.
The Alt 2 is for the sprinklers? For what?
Work type here, it says fire alarm.
Fire alarm, okay. Okay.
It seems that we also included in our response that the noise and vibration issues that we were having with some of the residents have resolved themselves. Tyler and Mr., I can't pronounce his last name, but he was here for our last hearing. They met immediately after and seemed to remedy the situation. I think he submitted a letter stating that he was satisfied as long as we keep the sound and vibration levels at the current level they are, which I feel that that was what you discussed with everyone, so.
Right, okay.
And, go ahead.
Did you hear comments on the sign that you have?
We did, yes. I did bring that up to Tyler this afternoon. We don't have any changes yet, but I did hear, we did review or make note of that they need to be higher, so they could be at eye level. I'm not sure about the actual, where the entrance is on the street, but is it floor level? Yeah, Tyler.
Yeah. State your name, please. State your name for the
Tyler Scott, owner of Bit House. How high should the sign be for the access?
48 inches to
48
the
inches.
bottom of the sign. And it shouldn't say for wheelchair users, because that's actually not who it's directed at.
Handicap access?
It's anyone. So you have used the handicap symbol, and then you say ring for assistance, or call, and then you can give that phone number, right, just in case. And ring for assistance means you're going to install a little electronic doorbell.
It was our understanding that a telephone number.
So
on
what
site-
if my phone, I'm disabled, what if my phone's out of battery, which happens all day long with my phone? Now I can't call you. Now I can't go to the gym because my phone's out of battery.
It's not it isn't expensive. You can find that at Home Depot. It's a bell with an intercom.
I understand. Hang on.
Is there a reason why you're opposed to it?
The fire alarm system we're installing, we're paying for that ourselves. We're a small business. My wife and I- I got it.
Maybe you're missing those doorbells, those little electronic doorbells, they
Right.
cost like $100, not even.
Yeah, but it's running the wiring down to
No, there's
where-
no wiring.
It's
It's
wireless.
electronic.
It's wireless. It's wireless. It really is like a walkie-talkie kind of thing.
Got it.
You press the button and it buzzes. What's the distance between the button and your level?
So it's a ground floor entrance, and we're in the cellar space. So the bell would need to go off down in the cellar, I'm assuming, where we are.
Right.
Aren't
So
you
we
right
need to have-
below grade?
We're right below grade, yes,
Oh.
so it'd have to run, so it'd be wireless, a doorbell.
Right.
A wireless doorbell. Got it.
Have
I didn't know that.
Yeah.
Okay, sorry, I assumed we'd have to run
That's what happens when you hang out in
all the
hardware
way down
stores.
and through, and then speakers all throughout, okay. Understood.
Yeah, you don't need
Apologize.
speakers all the way around, it just really rings to the desk,
I will
right?
do that this weekend.
Okay, so because of this, we really do need to have some kind of handicapped accessibility here. So I would like you to do that and show us the sign is properly mounted.
We have a sign currently there, but currently it's too low.
Now, the sign's written by hand.
Yes.
That's not lasting very long.
You
You need to
correct.
go to one of those
Sorry.
little sign stores, they're all over the place, right?
Yes.
And give them those instructions, ring first.
It wasn't written by hand,
assistance,
it's
or
printed out at Staples, but we can laminate it.
I'm sure Home Depot also has, or one of the house has a handicap sign, and but the ring for assistance, I think, is something you're gonna have to have made at a sign
So,
store.
Home Depot, they actually make the sign. You don't laminate your piece of paper. You actually go to the guys, like the
I'm there 2
key
days a
cutter.
week. Yeah, so
Okay?
I'll find that
Next door to
department.
the key cutter is the sign cutter.
Right.
Okay?
Okay, thank you.
Okay,
The fire alarm, I'll give you an update on, so we're waiting on approval for the plans, but we have gone ahead. Easy Fire Company, who we did subcontract out to install the system. We've done all the wiring and put in the back box and all the conduits, which we can do without a permit. So, and all the actually equipment is on site, waiting to install, just pending approval from the FDNY of the plans and the DOB.
okay. Okay, so what we'd like to see from you is, we'll have fire department speak in a second. I just want to, is a photograph showing the sign installed 48 inches to the bottom, a permanent sign. It can be mounted from the inside so it doesn't weather, right? And a doorbell that rings to the front, to the reception desk. Show us photograph of the doorbell and the bell at the reception desk that is receiving the call.
Great.
Okay? All right, so fire department?
John Daly, Fire Department. Their application for the fire alarm has been reviewed and disapproved. I know we tried to make some arrangements in the past where the fire department would approve the fire alarm system while these cases are pending. I'm having a little trouble for the plan examiners accepting that letter. So we're not going to be able to, they will not be able to get approval of the plan until after this decision is rendered and get a Schedule A from the building department. But afterwards, I can help them. But the fire alarm inspection unit they're trying to work with me, especially with these board cases, and that I would notify them once the board grants a decision, and that they would then will try to expedite the review, and then once it's approved, they will notify me. Then I can verify that the system has been inspected and eventually signed off. And if not, then request a compliance hearing.
Okay, and you would issue a violation? The fire department would issue?
Yes, we can, yes.
Okay. So it's okay for us to give a conditional approval, though we still have a little bit of time on this doorbell?
Yeah, it's fine, yes. Yes.
Okay. Okay, so I think you could do the sign situation quickly, right? What do we have, maybe, what are we up to, like the end of
The 4th has a lot of.
December 4th has a lot of adjournments.
Oh, it does?
But it's
Has
got
8
a lot of
adjournments.
A lot of
December
adjournments.
December 4th, what's it, I'm just checking whether that's enough time for them to do the work. It's the holidays. I don't have the right. Oh, wait.
Do you think you can get this material in by December 4th?
The doorbell and the sign, for sure. The fire alarm system, I don't know. That's obviously.
No,
right,
no,
the
we're just
approvals
talking
and all
about the
that.
doorbell and the
Oh,
sign.
100%,
So
I can have it done.
it means that you need to show us photographs submit to us the photographs by November 30th. So holiday weekend and all that stuff. So
Yeah.
you would need to work on it starting on Monday to get this thing installed.
Be doing it tomorrow.
And submit photographs to us of it installed by the 30th, okay? of November.
Photographs, I'm allowed to take those and send them to you?
Yeah.
Okay, great.
Okay, so, all right, we still have that outstanding issue, so we'll,
Do you want to close it?
Do they need revisions to plans or anything? Just
No, it's
because
just
the
the-
sign
they already-
is going to be located differently?
there's already, the sign indication on the plans just says accessibility sign. It doesn't
Okay.
say more.
Okay.
There isn't actually, though the plans don't say doorbell, so maybe just revise the drawings to show that there's a doorbell call button for alerting the reception, okay? So that's the only change on the drawing. Okay? So that all gets submitted by Friday, understood? Friday the 30th.
Exactly what does it need to say, so I don't mess this up?
So the drawings so the drawings already have a notation that says accessibility sign or something like
Right.
that. Then to add to it, call button for accessible access, I guess, or disabled
This is
access.
from our architect on the
Yes.
DMV plans, okay.
And
And
if-
then the sign that you want it to say, not for handicap, not for.
No, the sign, and so, so
For
because you're
access
not
to the
taking,
lift.
because you're not taking notes, please have your architect listen to this hearing so it gets it right. It says, it's a disabled sign, so it's the sign that has the wheelchair on it, right? And will say, ring for assistance or call your number, whatever your number is.
Got it. We have the sign already up, the wheelchair symbol.
Right.
So you just want the sign next to it, which it is.
Yeah.
No, so the sign next to it is in paper.
Yes, that's what
that
we
out.
want. Yes.
And have made formally a sign that says ring for assistance or call. There you go. Oh, look at that. There's even one ready to go.
You can have this for the cost of $7.99.
But it needs to add a phone number on the bottom, so maybe it would be $9.99.
Oh, that's true. Well, you would have a bell. You would have a bell. He would have the bell. That could,
Yes.
Okay.
So,
Appreciate it.
So, okay, and, right, I think we got that phone number. And it's mounted 48 inches, so both of the signs are mounted 48 inches above grade. The
48
one
inches
that,
from the floor.
from the grade, from the sidewalk level up.
Got it.
Imagine you're sitting in a wheelchair, how are you planning for a person to see that piece of paper down there?
Down on the ground.
are you still requiring that the phone number be up as well, or would the bell be
Yes.
sufficient?
It's on the
No,
same
because what if the
sign.
bell doesn't work?
Okay,
The phone, what if the phone doesn't work?
No
The
problem.
bell, right?
with you.
Because they need to get downstairs as a, okay. All right, so we could close it, I suppose. All right, so for a motion to close?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Thank
So
you.
December 4th, decision, right?
Yeah.
Submission date is November 30th?
Yes.
Yes.
Okay.
Thank you.
Item number 21, 2017-235BZ, 1102 Supton Boulevard, Queens. So this matter is being withdrawn?
Yes. Is there anyone here for this?
No, I don't think so.
No? Okay, so for a motion to withdraw,
Chair Promoter?
aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Withdrawn, sorry. Item number 24, 2017-288BZ, 7-10 Whitestone Expressway, Queens. 1 second to get the phone. Okay. You're the only one speaking? Your team's got to come up. Whoever's speaking on this case in Whitestone? Yes, but they have to be all sworn in. So everybody gets up, raises your right hand. Let's go. Hello. 1, 2, 3, 4, 5. Good, raise your right hand. Are you a neighbor or you a member of their team? Yeah, okay. Anyone who's a member of the team is going to be speaking, representing, owner, anything, raise your right hand. Okay, everybody, that's everybody? No, neighbors don't have to be sworn in, hon. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Okay. Please sign in and proceed. Ms. Randall.
Good afternoon, Lisa Orantia from Ackerman LLP for the applicant. Here today with Larry Cohen, who's the Chief Operating Officer from Jetro, Adrian Allen from NK Architects, Jeff DeRosier, who's a civil engineer, and Robert Newell, who's a lighting designer. So they're available to answer questions and provide more detail. Just to briefly go over the comments that I heard from the board yesterday. We did make reference to other roof parking in the area, and it's notable what's in the area because you see that open parking, whether on grade or on a roof, it's common in the surrounding area. And the garage that we pointed out on 15th Avenue between 143rd and 142nd Streets, that address is 1616 Whitestone Parkway. It's a two-story open parking structure, and it does face residential buildings. That's just to the east of our site. And it's roof parking at a lower height. It's 2 stories, and we feel that that's notable because you can see more of the rooftop from a lower level. And so the comparison is important to make because the height of our proposed building at 44 feet with the 3'9" parapet, the distance to the other houses, and then in combination with the lights being turned off after 8 p.m., all of the effects of the rooftop parking are minimized on our site, and we feel that there's less impact off of this proposed garage than there is on this neighbor site that's 2 stories high. That's why we made that reference. The next comment was that there were two...
Sorry, where is this 2-story one that you're saying? I thought that's a 1-story.
This one garage here.
Well, so that other one faces commercial, right?
This faces residential.
Well, not really, it faces one home, right? Does it?
It's a area. So this is the garage.
Right?
These homes have view of this 2-story garage. The roof lighting is visible at that site. The next comment was that P501 and 502 are too light to read. We're prepared to provide the board with a clearer copy. The next comment is that the board would like us to address light and noise from the lower levels of the garage. Our focus was on minimizing the effects of the roof parking, but we did also of the light plans. Our focus was on minimizing the roof parking impact, but we also looked at the lower levels of the garage as well. And again, I just want to emphasize that there is no visibility of lights from the roof level. This is a 44-foot-high garage. It's 110 feet from the neighbor houses. There's a 60-foot wide buffer between the garage and the street's 50 feet wide. There are 2 lamps with 4 fixtures. They're on 15-foot-high poles. They're positioned at the center of the garage to prevent spillover. And the roof lights and the car headlights will all be blocked by the 3'9" parapet on that northern side.
Can I ask a question? Is there a reason why your client is unwilling to make the changes that we're requesting? Lower the lights down in a way that we have seen on another parking garage where everything is at the level of the parapet, their little maybe you have the wrong one. They're bollard lights that shine down from the bollard.
Yeah, Robert Newell is the lighting consultant, and he's here
No.
to present why the applicant is not going with that option, which would actually end up, well, he'll be able to explain.
We've already seen one version where it says if we mount the lights above the parapet level, they'll shine out onto the street. That's not what we're actually asking for.
He considered lower level lighting on bollards, lighting at the parapet level, multiple lighting, and he'll be able to explain to you why that option is not beneficial.
Beneficial to whom? Yeah.
Well, in terms of minimizing the effects, this
He
proposal,
believes that having the light higher is going to minimize the effect of it's shining down?
that's right, the
Onto
light
neighbors?
poles are positioned towards the center of the garage roof. And at that 80-degree angle that directs the light downward, you don't see any spillover off the side of the garage. There will be no lighting that, I mean, you can see from this diagram, you see this shaded area. It blocks all the light.
How would that be less than the lighting lowered then? If
If you lower the lighting, you have to put multiple light sources. And I'll let him provide the details on that. But we carefully considered the board's suggestion, and I think that today we'll be able to present that information to you. Like I said, our focus was on the roof, minimizing the adverse effects of roof parking, but we also looked at visibility of the interior garage through the first through fourth levels. And that's where you see, so this is an open parking structure, and there are 4 foot by 1 inch high openings at each of the levels. There was, I understand, a community concern about some lighting that was visible in the interior of the garage. That is temporary hanging service lighting. Permanent lighting will be mounted to the ceiling, and it won't be visible.
The car lights are visible.
Car lights will be visible to a small extent. We looked at what the board had suggested, the angle of car beams as they're driving through the garage, and the extent to which the car beams would be visible on those lower levels.
But that's the beams. That sort of assumes that the cars don't create an ambient light source inside there, right? So the part that I'm having a lot of trouble with is the neighbors are upset about the project, right? A simple solution for dealing with the imposition of the project on the neighbors is to use some sort of a shielding material like vines, grill work, there are any number of solutions. And what I'm hearing is instead like scientific reasons for why you shouldn't do it. And what I'm trying to get at is how do we protect the neighbors from what is viewed by them as an imposition on their residential lives? It's not hard to do. It's not expensive to do. So why are we having this whole back and forth about science and so on? I don't understand that.
The science is to address the concerns about the lighting, but we're also aware of the complaints from the neighborhood, and the owner is sensitive to those issues. Larry Cohen was speaking with one of the neighbors just before the hearing, and we are carefully considering what options are available in order to be a good neighbor in this area. So the green wall, the wall with ivy growing on it, would require a support system to be installed, and the ivy can be planted. The only concern with the ivy is that this is the northern wall and it's shaded, and it may be difficult to grow it, but we will consult with a landscape designer, and the owner is willing to install a green wall on that north
Great.
face.
That's good.
So like I was saying, we analyzed the car beam lights as they traveled through the garage, and the only issue there is where the light beams will tilt upwards on the incline at the second level. Everywhere else, you're either on a flat surface, and the car beams will be blocked by the parapet, or the beams will be pointed downwards and also blocked. The point where you might have some penetration of light through the outside of the building is that second level incline. And we have been reviewing what options are available to block that opening. So there's a screen option that can be put in that location. Certainly when the trees reach maturity, they will block that area.
Okay, but you're not relying on trees reaching maturity, right?
When the trees are planted, they will be 14 feet tall.
That's not maturity, right? Right.
Right, at planting, they'll be 14 feet.
Okay, but you're not relying on the trees reaching maturity in this story, right? Trees die, trees whatever, trees, right? You're trying to solve the actual problem of the light beams affecting the neighbors, right? So, again, instead of sciencing us into it, right? The future tree, et cetera.
The owner is happy to provide the landscaping that's necessary to give additional screening at this
Well,
location.
it'd be the only screening we have yet at this time, because the trees aren't at maturity.
Say again?
At this point, when the trees are not at maturity, it is the only screening. It wouldn't be additional to
Right.
this particular lighting issue. Okay.
I'm Larry Cohen, I'm the owner, and it's hard for me to sit there and you guys asking questions about how I feel, so I'd rather just come up and tell you how I feel.
Okay, good.
First of all, I received a bunch of letters this week about complaints from the neighbors. And at the last meeting, I testified that I'd met with the neighbors, and that was questioned. So I wrote a letter responding to the board that, I'd like to put it on record that when we first started this project, we immediately reached out to the community board, because that's what we were told we should do, and we met with them. We met with them informally in our offices. They recommended that, and this is for the neighbors and for the public, they recommended that we then go and present before their board. So we presented before their board, they had a lot of questions, we met a lot of neighbors that night, we shook hands, we tried to address concerns. They brought us back for a second meeting, which we attended, and they approved us unanimously. We then were contacted by the Queensborough president, and I went and met with her. And I presented her board, which had over 100 people there that night. We spoke to everybody, we tried to address as many concerns as we could. We were then contacted by Senator Tony Avella, and we went and met with him, and told him about the project. Up until that point, and two people at the community board had complaints, and I said, why don't you come join us? I'll walk you through the site, and I walked them through. Up until that last meeting, I had never heard of another complaint. After the next meeting, we received 3 letters from 3 neighbors, and they were the 3 neighbors right across the street from the project. I tried to find their phone numbers, I couldn't, so I wrote each of them a letter, and I said, I would like to talk to you about it, I would like to discuss your concerns. One of them reached out to me and said, I'm in contact with all the neighbors, we'd like to meet with you. I said, great, we'll meet Friday on site. Friday morning, he texted me and said, we can't meet you Friday, but we'll reschedule. So I said, fine. I texted him again the next couple of days, and he finally said, we don't want to meet with you, we're going to go to the Department of Buildings. And I left it at that. So coming back to your specific questions, when we talk about science versus what we're willing to do and what we're not willing to do, after that night, we employed a lighting expert, a so-called lighting expert who is here with us tonight, and we asked him to tell us what the best options were. And he came up and said, by far, this is the best option because you will not see it from the floor because of the height, there'll be no spillover. And I specifically asked him, what if we do lower lights? He said, if you do lower lights, you need a lot more of them and you're moving closer to the edges. And rather than talk about lighting, we brought him here tonight. I'd like him to tell you specifically about lighting. When we say science, it's the science that there's the perception that maybe another idea will be better, but there is also what is the best for the neighbors for spillover. So that's what we're going with. We then, the board recommended ivy, and we've had a lot of conversations. It's very expensive, and we're willing to do it. Our concern with the ivy is that it may not thrive. It's on the north side, we're in cold weather. We have to put a big grid on, and then we would plant ivy. And as long as everybody understands that we will do our best, we will employ professionals to do it, but if it doesn't thrive, it will not thrive. And that's our concern there. Just in the last 15 minutes, we've been here since 10 a.m. Last 15 minutes, one of the neighbors saw us talking about it, and I thanked her. She walked up and said, can I put my 2 cents in? And we spoke to her for a while, and she said the ivy would be great. And I said, we're willing to do it as long as with the understanding. And she said, how about screening off the portion? Because we told her that only the second level may have some light penetration. And she said, how about popping in some screens? So I left meeting with her, and I went and I called our garage expert. He actually just emailed me and said he looked into it, and on that second floor, we can put in screens without it adversely affecting an open air situation, so we're willing to do that. I'm open to other suggestions, but we'd really, we'd like to get this done. And one other thing, and then I'll...
okay.
The point of this variance is for rooftop parking. A lot of the complaints we've had are about everything but rooftop parking. The real question here should be the rooftop parking, are there adverse effects to that? Is the lighting an adverse effect? And we've really looked at it and we've decided that this is the best possible solution for the neighbors. It's no better for us how we distribute the light, but this is the least spillover. And whether you can see the cars, which I don't think you can because it's too far up. The other option, which is as of right, is to put a roof on top, which would make the building higher and to me not as pretty, and we've been trying to avoid that. It's very expensive. We've designed the building structurally so we can put a roof on top. We're trying to kind of appease everybody so we can go without the roof and have the best look for the neighbors. So that's our goal. And we're open to options that'll...
Okay, so if you're so interested in moving this along, my problem is that the last submission we got was not different than the one we had before, so we looked at the drawings and we didn't see any difference. So that's kind of frustrating. It sounds like we're not being listened to, and you're sticking by your guns and you're not moving. And by the way, when you come to the board for any kind of special permission, the board then can look at the totality of the impact on the neighborhood, because it's looking at, should it permit rooftop parking in an area that's close to residential use, right?
Agreed.
And so it has to ask, why do you need so many parking spaces? It has to ask, look at how much parking there is around there, look at the height of the buildings around there that are parking. So it's actually all relevant to help us figure out whether your rooftop parking request is justified.
Agreed, and that's why we're entertaining all the other options, and we're trying to work with the board and with the neighbors.
Would you be open to screening and using the vines?
We would be open to screening the second floor and using the vines.
And
As opposed to screening entirely, is that what you're saying?
Well,
You're looking at images of
Right.
screening.
Screening being what? Filling in the gaps.
Filling in the gaps, so
No,
like
but it's not filling it in. Screening, which is sort of defined as 50% open, right, is some kind of a decorative element that functions as a way of concealing, of hiding the facade, or concealing the cars, or reducing the amount of light spill. If you just went on, my favorite is Pinterest. If you go onto Pinterest, you see like 1,000 versions of screening on a garage, right?
It just depends on the impact. We don't want to put a full HVAC system in all the floors.
Right, understood.
So-
I think that none of these screen solutions on garages are air conditioned. That's the whole point, right?
So they allow air to flow.
They're allowed to flow. If that were to be done on the backside, perhaps with vining, I look forward to hearing from the lighting expert, because if that's something we'd agreed on, the lighting's really the only issue I have left.
Right, well,
So
right.
I'm not,
Well, but the screening is about the lighting.
No, the lighting,
It's
the-
about cars and lighting.
I'm on the top floor, the lighting, it being stationary as opposed to on the floor, which we've had cases, we've had other cases, and that was a great solution. So this is going to be new to us here, that in this particular case, it's not going to be as great of a solution.
I would, how about we let the lighting expert answer your
Right.
questions, and I'll go out and call he said I can call him back. Let me see if I can do it on all the floors.
Okay.
And let me try to understand what the impact is. And just to further, we had when you say we didn't respond, we had questions we left the board with. We feel like we came with answers to the questions. And again, the ivy is something we've been going back and forth on, if that would really make the neighborhood happy. And the neighbor said it would make her happier to have that. But we did a rendering. What we did here,
Bring the microphone with you if you want to.
so I had told the board last time, these are the three neighbors. And when we first looked at what the three neighbors did, this is one, it's open, there's nothing. These are all facing the residential. And in fairness, this one is over a little, but it's all on the same street facing the residential. This is the second neighbor, and this is the third neighbor, and this is what we decided to do. And it's pretty clear that we took the most expensive and the best option for the neighbor's point of view. What we had our artists do is take those trees and place them in front of our building just to show the impact. And when you look at it now with nothing, and when you look at it with what we're proposing, and this is mature, but when you look at what we're proposing, we really think it does a nice job screening it and taking some of the impact away. That being said, we're amenable to putting in the ivy.
Okay, so when I was looking at that, I was seeing renderings are amazing things. They can just do whatever you want them to do.
Absolutely true.
Right?
Yes.
So it's a pretty rendering, yay. But then you look at the landscaping drawing, which, by the way, I couldn't read. So, right, they were
we
too
brought you
light to read, so I wasn't possible to match the pretty drawing to what's actually proposed. And I actually thought that what was going to be proposed was 2 rows of planting, which is what we typically see as a buffer area, where you have a staggered 2-row, right? So they, sort of the trees are set like this, and that's not what's being proposed on this landscaping drawing. It's one continuous row. And in order to accomplish a solid buffer, you need that staggered 2-row situation. So,
Know that we have the room to do that.
but that's the thing,
I
you
know that
have
you do
this
have-
detention tank, and you have a slope, and so on. So we asked, those were the same questions that we asked the last time. Why can't you plant into the slope?
Okay, well, Jeff is our civil engineer. Jeff, we can do the staggered trees, we have enough room?
If you're going to speak, you have to come up here.
Gotta come up. State your name for the record.
Jeff DeRozier,
Okay,
we have enough room to do 2 rows.
okay.
Okay.
So you should do 2 rows of trees, staggered. The goal is dense screening, that in maturity is dense. So one of the things that we see with trees in maturity is sometimes they're the opposite of a screen. So they grow really, really tall, and they really reveal everything because the trunks are exposed. That's why you vary the vegetation so that.
And again, what we did is we we mimicked exactly what was there, which is one row of trees, I believe. This is a picture of that just superimposed. So it's not a drawing, it's an actual physical picture. We took what was in front of one building, put it in front of our building.
Okay.
So, but if we can stagger it, as long as we have the room, again, I can't do anything that we can't do.
And it seems you do.
That we can.
Then you're.
So I would like to turn it over to the lighting expert, Rob Newell, who is already sworn in.
My name is Robert Newell, N-E-W-E-L-L.
You were sworn in, correct?
Yes.
Yeah, right, I see it.
The discussion of rooftop parking.
Oops. Don't break my mic, Mr. Newell, I have to charge you for it. City property.
Does it work? Yes. The proposed lighting solution is to mount fixtures on a 15-foot pole. These are high cutoff DLC, dark sky approved fixtures that are all LED. They're less than 100 watts. They shine down light. No light goes above the 80% distribution. And in that case, the light from this fixture here will not go over the parapet. The 1-foot candle mark will be short of the parapet, and the half-foot candle will hit the top of the parapet. This house over here, these houses across the street will not even see the posts because of the proximity.
They won't see the top of the lights?
No, they will not. That 15 feet is well under by 3 or 4 feet the closest to the roof line, and when you take the distribution of that fixture, no light will be.
No part of the post will be visible.
The post and the light fixtures will not be visible to these houses across the street from the site. The discussion about alternate methods about using bollards can't conform to lighting codes. We're required to have anywhere from a half to 2-foot candles with a 10-to-1 distribution. And if you start putting light fixtures out here, less than 3'9", bollards, wall packs, continuous row of lighting, all the lighting is in front of the cars. And when there are cars in that parking lot, the light will not get through to the roadway area and in here and provide the required lighting for safety for pedestrians walking on the lot.
So how come on the last project we just reviewed, they used bollards on the rooftop parking?
I would have no idea why they would do that, because all that light there is wasted because once a car parks in front of it, it doesn't go out into the parking lot. I mean, I imagine you can stagger them and have handicapped spots in certain spots where there will be no cars, but that line of light will go down a 9-foot wide parking aisle, out 18, 20 feet, and then just disappear, and it won't be uniform.
You would just need more lights. You would need more lights to make it work.
You could put one every 20 feet around the entire parking garage and have a full parking lot, and there will be no light on the drive.
Right.
Because they're all blocked by the cars.
You're suggesting only putting them on the perimeter. You would also put them in the center.
There is no center.
You would.
Where the pole is, right?
There's a pole here, but what, is that parapet? This parapet here is the same 3'9"? What is this wall here?
There's a 3-foot concrete base and a 12-foot pole on top.
Yeah, but what is this line separating this and the opening?
Yeah, there's a 3-foot wall.
There's a 3-foot high wall. They could be there, located on this 3-foot high wall in this location, but that won't get any light out across into the parking spaces as efficiently and as uniformly.
So you're proposing only 2 light structures?
We're proposing a 15-foot pole with 3 light fixtures here and a 15-foot pole with 3 light fixtures here. 3 less than 100-watt LED fixtures.
3 facing in 3 different directions?
Yes, they're facing here. Well, right now, they're actually facing here and here. 3 fixtures, they have a square pattern of light, and they overlap each other to create one luminous element on top of the pole. That will create this, that's the wrong one. that will create a 1-foot candle line all the way out, and here's a half-foot candle line. Real good uniformity across the entire space.
So, but what you're talking about is ultimately the cheapest solution, right? Cheapest, most efficient solution where you only need 2 fixtures, essentially, 2 torchères effectively, right? As opposed to the more expensive solution where you have bollards, in the floor solutions, in the parapet wall solutions, which, by the way, we see in parking garages all over the world. So you mean all those people all over the world don't have enough light on their parking garages?
You may see them occasionally all over the world, but they're not normally that low, and they don't light the entire parking lot, and cost is a consideration. And if we can adequately illuminate this parking lot, have no off-site negative impact, why not use a less expensive solution if we can?
So what about the idea that the parking lot will, never mind, you're talking about direct illumination onto the house. I'm talking about the glow of the building, right? I'm talking about the fact that you've got light sources way up in the air and that the building will glow at night. And no, I can't read by it while I'm standing in my front yard, but I'm aware of the glow of a large building in a residential neighborhood.
The glow that you will get from this building is reflected light off of the I'm assuming it's the concrete deck, off the concrete deck reflecting up. You will not get any direct light off-site.
Right.
And you will have that reflected light with bollards or wall packs or anything else also. You'll probably have more reflected light with more fixtures.
Yeah, I'm just gonna go.
Is this legislation to scale? Is it a true scale?
Speak up, sorry, speak up.
Is this figure is a true scale figure?
Is that true, full scale or true scale? I did not do the renderings.
It is not.
It's blown up of an actual.
So how?
Sir, if you're going to speak, you need to be near the mic because we don't pick up your voice.
Adrian Allen, okay. The 11 by 17s are a true scale. This is a blow up of those.
But they are scale.
So they are to scale.
Yes.
Proportion.
Yes, correct.
So it's to scale.
It's to a scale, yes.
Okay. I just want to make sure that the distances are proportional to each other. So the angles, the directions, the orientations are kind of consistent. How can you make sure that the light is not going to go like above the panel?
The light fixture
Do you have some
itself,
sort of shielding?
it doesn't need it. LEDs are very directional, they're very well-controlled light sources, and I can pass around the specification if you want to see it.
We have them, right? Isn't that one? Oh, that's a different one.
You have this? On the last page, last couple pages, so show the distribution. The red line indicates a square pattern of the type 5 distribution. The blue line shows the wide bat wing but low distribution to extend it out the full width without having any light above the 80% distribution, or 80 degrees.
So here's the thing. I'm not really persuaded by this argument. So I would like to see, since you are a lighting designer, I'd like to see you show us, which is what we asked for the last time. So that's part of the frustration. We asked for a proposal using bollard lighting, in-ground lighting, in slab lighting, and so on, and we didn't get it.
Well, can I ask what you, in slab lighting shines up and puts no light on the parking garage?
So then all those parking garages that I've seen all over the planet must be really badly lit, and I don't know how I got out of one. So that's the thing, is I've been in parking garages in lots of different places where they have incredibly beautiful lighting systems that somehow work without a pole in the center of the room that's looks like football field.
And you're talking about rooftop parking?
I'm talking about rooftop parking, doesn't look like a football field, handles, is responsive to the fact that it's in the middle of a residential neighborhood and can't be
can't be imposing on the houses that are right next door to it.
Can I just add one more statement, is that this is a garage that is going to be used, as from the statements provided, from 7:30 till 6:30 PM, and the demand is for 200 spaces. 25% will arrive before 8 AM, 50% between 8 to 9, 8 AM, 50% 8 to 9, and 25% between 9 to 10. And the peak usage is 9 to 4 PM. So pretty much before sundown, most of the garage is going to empty out. So we are only worried about for that period up to 6:30 or so, where it needs to be lit. To have this and rest of the time, the light is going to be turned off when the business closes. So to have it lit with that intensity is what I'm concerned about for such a short duration of time, and for not even 100% utilization, where your most peak utilization is going to be during the daytime, where people will be parking closest to the lower floors, won't even get to the rooftop parking. That's only when you have the maximum 100% occupancy, and that's not every day and every time, all the time. So that's the other reason why I'm kind of pushing as to why you need this kind of lighting, and why can't you have a little bit more subdued lighting that allows for the subdued in the sense, the structure of it, and that allows for the similar amount of lighting exposure that you need for the safety of the drivers who are going to drive there, yet not be so visible and not have these other perception issues.
The lighting fixtures on the roof and the lower levels will be on sensors, daylight sensors or occupancy sensors, and if there's nobody up on the roof at 8 o'clock at night, the lights do not need to be on.
I thought we were told it's going to be turned off after work hours.
Yeah.
They will be turned off after hours.
Yes, after the business closes, that is, which is 8 o'clock. So that's what we were of the understanding. You know, the case that we recently reviewed and approved was a two-story, rooftop parking garage on the second floor, surrounded by buildings that are 3 stories high. And it has similar dimension exactly as this proposed parking garage. And they used basically, and I was counting it, they provided 10 parapet lights, and these are 4-foot-high CMU parapet wall, and then in the middle of the parking spaces, like for every, if you had 2 back-to-back parking spaces, there were poles, 4-foot-high poles along the way in the median, and those were the lightings that were provided, and this is for an operation that would stay open till midnight.
Do you have the address of that?
Well, it's not built yet.
It's not built yet. We just approved it, but, you know, this is maybe,
Yeah.
I don't know if you're allowed to.
Why not? Yeah, we all
Yeah,
can
it's
talk about
approved.
the actual address.
It's
Yeah.
approved.
You could review the plans.
Yeah.
Yeah, the case is 2017-314BZ, and this was for a rooftop lighting plan. Address is 1571 McDonald Avenue.
Montgomery Avenue?
McDonald in
Avenue.
Brooklyn. And it has exact similar dimension, off by a few feet here and there, but it's very similar. So please do look into it, and that's why I'm also concerned about the light pole, and if there's an alternative, given the utilization of the space.
That it's unlikely because of the utilization rates at between the hours of 4 and
Yeah.
6:30.
It's not going to be high that would warrant that high level of
That they may not even go to the roof.
Yeah.
Well, it's not so much a high-intensity level. As Robert noted, they're 100-watt LEDs. They provide sufficient illumination, which is required. We can't provide less illumination than is required by code. However, I just did want to make the point that this is a precast concrete garage that is already built. We are limited in the arrangement of lights that can be made. We don't have back-to-back median areas where in between that we have We do have center portions here and here where the cars are facing it. However, we are limited to lighting the perimeter and the center. So
Right,
we-
and that's exactly
did.
what McDonald has proposed. Basically lighting along the entire perimeter, all four walls, and then have the bollards, the 4-foot-high bollards right in that median.
And as Robert noted, as this is a wall and with lights on it, cars parked in front of it are going to block the lights that are along that perimeter.
So I don't want to keep going through the same argument. You heard our request. We have another application that was just approved where that was the lighting solution. We asked at the last hearing that we see this lighting solution also, and we didn't get it, and so you're forcing us to have deja vu all over again. It's really a waste of everyone's time. I really wish you would have been responsive to our last.
We did respond to that request, and you'll see it in the Plan L001 Alt. That's the alternative lighting plan that was considered, and that shows that in order to light the entire rooftop, you would have to place lighting sources closer to the edge, and that results in spillover.
But they're facing the other way. It wouldn't.
They were facing out.
No, they're facing
The
inwards. You
spillover
see,
would happen if it was facing.
no, that's not what the diagram shows. It's L001 Alt.
But these are light poles mounted on top of the parapet wall.
Right, which is necessary to light the surface.
Okay.
You can't put the light in the parapet.
Stop. Now I'm feeling like we're doing something that's, I don't know, I feel like the Mad Hatter or something like that. We keep telling you, we just approved an application where they put lighting in the parapet walls at 4 foot or some height like that, right? And that was a solution. We told you at the last hearing that we wanted to see that solution presented to us, and instead, you provide 10-foot lights at the parapet walls, which is not at all what we talked about, which is obviously going to be worse. If we had talked about that at the last hearing, we would have said, no, don't do that in advance, right? So,
Please
I don't know
just
how to
keep-
explain it any other way. You have to do it like this, okay? And we need to be able to look at it. You can show us lumen diagrams, you can show us the data on these drawings, but you have to give us this information so we have something on which to base our conclusions.
At least look
Right.
at that alternate, the other project, and review it and see, give us a plan indicating how it does or does not work for you, and lay out those arguments so that we can understand
Okay.
why maybe in that particular case it worked for whatever reason, and in this case it
Yeah, we're
wouldn't.
gonna get
So,
wanna take testimony from the
just,
neighbors?
Yes, we'll take testimony.
give us
Okay,
that.
it's just, yeah. Okay, thank you, thank you.
Neighbors?
Neighbors, anybody want to speak? Yes.
Please come up, please state your name for the record, and you'll have 3 minutes to speak. 3 minutes. No, this one, it's on this. Yeah, because you're opposed, right? No, you're opposed, right? Yeah, it's okay. Okay.
My name is Paulina Makris, and I'm one of the owners. I have one of the houses right across from the location of the buildings. I don't know if you received them because I sent them last Sunday night. We walked around the neighborhood.
We received
it.
them,
Okay,
yes.
so nobody that we spoke to that day that was home knew anything about this construction. Nobody likes it. Nobody's happy. Nobody wants the approval of this application. I'm going to read you what I have, and then I just want to answer some of your questions, because you had a lot and I have a lot. So thank you for the opportunity to speak to you regarding the construction directly across from my house. I first became aware of who is the owner of the buildings and what they are building when I watched the online video on the first BSA hearing on September 13th. Up to that day, nobody in my neighborhood was contacted regarding this project. We're all upset and disappointed with the poor design and location of the buildings and the lack of consideration for the residents' livelihood. Jetro moving into our neighborhood does not really provide any benefit to the residents. They are saving millions of dollars from sales tax exemption, mortgage tax abatement, and real property tax exemption. They talk about future expansion, but they never discussed about investing any of that money into beautifying and concealing the buildings from the adjoining neighborhood. They're only willing to do the minimum that the code requires, which is not enough to ensure that the daily quality of our life will not be impacted. So we are asking not to allow 58 extra parking spaces on the 5th level. They already have 302 vehicles. They're more than enough for Jetro to meet their current and future needs and exceeds the minimum required. All the buildings around them have way less parking spaces, and nobody has even close to 5 levels garage parking. We would like to ask that they remove the 5th floor of the side of the faces 15th Avenue at least, because it's already up the 5th level, and make the rooftop parking on the 4th level. This way, the residents can get some of the sky exposure back, and the building being lower will be easier and faster to conceal. This is a recommendation similar to what you've been saying, like a rustic metal plate with a modern design can cover the openings of the garage to ensure privacy and conceal the vehicles and the lights, while at the same time giving the facade a modern look. Because it's not just, especially from my 2nd floor, I can see the cars, I can see the people coming in and out in the cars, and now I can see the workers, I can see everything, it's not just the lights. We also want to see that they push back the chain fence, that they say they're going to leave where it is now. I actually want them to replace it, make something nice, a nice fence, and push it back and create a planting strip along the lot line. And I think that, I believe the articles of the College Point Special District require that, quote, "There shall be a planting strip of at least 4 feet wide along the portion of the lot line adjoining the residence district," end quote.
So we already read your testimony, so if you could wrap up because
I know the time.
Yes, okay.
Okay, so obviously we object of what they're saying. I'm objecting of even these things that they say, that there's never another open rooftop. Can I just hold this?
Yes.
Yeah, absolutely.
There isn't another, there are 2 more. They are not visible from any houses. Only you have to walk, to drive down 15th Avenue to see them. No house has to face, and it's only 1 level, and really you do not notice at all. They don't bother you at all. We were not aware of anything. Like, you started this huge construction, there were
Please speak to us.
there were never any permits on the fence, over 200 feet long, 15th Avenue, not a single permit. We were never aware. We could see activity, like last spring, I saw activity over there. Then, even with excavation, we never received an excavation. It's like literally 70 feet away from my house. I didn't get a letter. Later, after I go away July, come back in September, and I see this huge cement block, 5 levels high in front of my building. So, and I got your letter, actually, this is how I found, I got your letter for the hearing. So I tried to contact the community board. I wrote letters, the Department of Buildings, I did some research trying to get into the code, like how could this happen? There's only one, the school, which is 2 levels, and it's situated away from us. And I always assumed whoever builds in this stretch would be something similar, away and 2 levels high. So, and after the hearing, within 5 days, boom, the second building, huge building, 5 levels, again, the office building was done. It just so fast, I don't know, I'm speechless. When, again, the community board, I write them a letter again, I complained about that. They told me that they did meet with him 2 years ago. I spoke to the vice chairman. He called me after I wrote the letter to complain. So he told me that it's an as-of-right construction.
It is.
They told us it is an as-of-right, they can do whatever as long as the code, okay. No common sense, no common courtesy, like, yes, all right. But then I said, they come in for the hearing. She says, after that, they came 2 years for the rooftop parking. All right, how do you let the people know about the hearing? Again, nothing on the on the site about a hearing coming up. He says, oh, we sent flyers out. I'm like, flyers? I didn't get any flyers. He says, yeah, there are always residents that say they never got anything. Like, I don't know what is going on, but really, overnight, we feel as a community that this has happened. We spoke to almost 100 people, the 3 blocks across from this building. Nobody knew anything. Nobody was contacted. So it's just frustrating. And then I'm looking at these 14 feet. I don't see 14 feet, these trees. The trees are 7 feet high. I mean, I'm sorry.
I just want to, first of all, the zoning allows for the use that is being proposed. I just want to be clear.
Right, yes. No,
Second of
yeah.
all, as per zoning, the number of parking spaces that would be permitted is 387 spaces. That's the maximum. And the minimum is 237.
That was so confusing too.
Right? So there is a huge amount of parking that is required for this site. The fact that they're providing the parking on site, which is great, because this, as you know, there isn't that much parking available, and the applicant has provided that information. The other thing is that they can also add another floor to it and roof it off, and then they won't be here before us. But the only reason they're here before us is because they're proposing a rooftop parking. The rest of the parking spaces below is not for our review. It's only the rooftop parking is what. If they had put a roof over it, it wouldn't be even before us. I just want to let you know.
I just want to understand. So now there is the 5th level is up there. So you mean a top on that? Isn't that the roof of the 4th?
That, on the roof of the 4th floor, if you're going to use that as a parking space, then they have to come to us
If
for
it's the
approval.
roof.
Right.
But
If you
on
say
top of-
no, then
Right.
what happens?
But
That's
if-
what I'm confused.
They can put a roof on top of that.
Yeah, it would get higher.
It would
be a
just-
roof.
they
So
could
how
just
about
put
the
a-
sky
it-
exposure that they say it
It's all
doesn't?
within it.
This is a complying building, and
It's a
the only thing
complying-
we're looking at is whether or not they're allowed to have rooftop parking. The question of rooftop parking we look at is whether the parking would have a negative impact on surrounding residential neighborhood.
rooftop
That's
parking.
the rooftop parking. But having heard comments from the community and concern from the community, we do have the authority to request modifications to the building to try to alleviate some of the issues of the rooftop parking. There are times where the relationship of the rooftop parking to the residences is so close that we don't allow it. But in this case, because it's across the street and set back really far from the property line, it's something where and there's other parking garages on this site, and it's a manufacturing district. That's where we say, okay, maybe it's okay to allow the rooftop parking, but we try to do something to ameliorate or say alleviate the impact of the parking garage on the residential properties. That's what we're doing here. We don't have control over whether the building's 4 stories or 8 stories or whatever it is they're allowed to build. That's for you to take up with the Department of City Planning and your council member and so on if you don't like that zoning.
What kind of a roof? You say a roof. What kind of like,
It's
what kind?
not our
That's
department.
for us, and we cannot opine on it.
I think it might be good news that they're not doing that for you, because if you don't want it much higher, roof is going to add height to it.
Okay.
So you mean like another level and then the roof on that? Like a 6th level and then the roof? I'm
Well,
just trying to
we
imagine
don't
kind of
know
always
what-
We don't-
say what
No.
level is your roof. I don't
Let's
know.
stop. We're just using that as an example, that they're allowed to build a lot of different things on this site. They chose to build this parking garage at 4 stories with a roof on, with parking on the roof. They could have chosen to build something else that arguably was taller.
Many choices. They could have
Okay.
done something much better and still meet their
Okay, but
needs.
it's not up to us, so we need to move on to the next speaker, so thank you very much for giving us your testimony, and we have actually read all of your
So with the
submissions.
landscaping,
We're working on the landscaping
they
with
has to
them
be
right
thicker and
now.
higher though.
We're working on them with the landscaping, okay?
Hide it.
Thank you. Any other speaker?
Yes, the neighbor. Yeah. When you're finished talking.
I know you've been here since.
Yeah.
Yes.
Good afternoon. My name is Joanna Pena. I'm one of the residents surrounding the project here. I'll keep it short because you have clarified that they do have the right to the size of the building and all that. I just would like to be on record stating that because this particular strip along the corporate park is unique in the sense that it directly neighbors R2A zoning. We're a very low-profile neighborhood. All the houses are 1 or 2 levels, single-family homes, which is very much different than the rest of the corporate park, which has no residential neighbors. So in consideration of that, the residents do want to see dense landscaping, the ivy wall, to basically hide the project. We have a beautiful neighborhood. We're concerned about our property values, of course, and the aesthetics. When I wake up in the morning and look down the road, I don't want to see a building. I'd prefer to see trees. We don't mind having a corporate neighbor. We obviously know we live in a corporate area. That's a chance that you take. However, we would appreciate, the extra care if Jetro puts an extra investment in the landscaping to hide this project. Because we do care about our neighborhood. And it's a little disappointing to have a building very close to you. The comparisons made, 2 points, the comparisons made to the other parking lots, there is no comparison. You don't see the other lots. It's not in direct line of vision of the homes. That's a big difference. The rooftop parking, on the lower level, the 2-story, you do not see it at all.
And that's because?
The way it's offset, it's more towards, there's a church and the rectory building, so there are no residents on that side. So that parking garage is sort of slightly offset, so there is no direct line of view. You don't see it. You don't see it. So it's not an issue for the community. They just built that maybe a year ago. No one has said anything about it. Another point about the landscaping, they made a comment about the ivy not being able to grow. English ivy can grow in low light environments. It's very hardy. It's evergreen, so it never loses its leaves. My concern would be the conifer trees that they want to plant as a dense screen. That is a north facing. The garage is so high that there is no light there. So they're saying the ivy won't grow. I think the trees won't grow. So there has to be special consideration there because the way the garage is so high, it blocks the sun. The trees may not grow, whereas the ivy will grow because ivy can grow in semi-light. It doesn't need bright sunlight where evergreen trees do need a fair amount of sunlight. So please take that into consideration in your decisions. I thank you very much.
Thank you. Any other speakers? No? Okay. Yeah.
Thank you for coming.
Okay. With respect to I think I mentioned this in the review session, my understanding is that the engineer who's working on the landscaping is actually a stormwater management specialist. That's not a landscape architect or a landscaper, right? So unless they have someone in-house who is a landscape person, landscape architect, it means, because I actually used to do that as an architect. They put me on working on a hospital once where they said, you do the landscaping. And I didn't know anything. And so I turned pages in a book and I picked out trees. And, good luck. I doubt they still are there.
Jeff DeRozier, the site engineer. I retained the landscape architect.
You did. So there's a landscape architect that was retained, but their name isn't on any of the drawings.
That is correct. It was prepared
So
underneath
please
my-
identify who the landscape architect is, so that we can, and then bring the landscape architect so that we can discuss the viability of the landscape at the next hearing.
Provide that info.
Thank you.
Okay, how much time do you need?
Okay, February. End February? What do we have?
February 5th, 12th, and 26th.
How many on each?
We're up to 8.
Excuse me, can we just make one more statement?
Yes. Well, we're just trying to pick dates, but go ahead.
I just want to say that, look, the neighbor who was up here second is the one we spoke to, and she was very reasonable, and we really will do our best to try to appease anything we can. I spoke to the parking lot designer, who's a structural engineer, and he said that he has done these 50% screenings, and that can be done on one side of the building. So we will look into that.
Great.
We are willing to do the ivy. We are willing to look at and even meet with the neighbor, with our landscape architect to talk about whether these trees will grow, because she brought that up before the meeting as well. And if not, maybe there's a tree that's better suited. The lighting seems to be an issue from all my professionals. We will look at these plans, but I just want to, we'll be reasonable and we'll try our best, and we would expect the same from the board.
Okay.
If it makes sense to do this, we will look into it. If it doesn't, I just want a recognition that you're right, what you have is just as good. Is that fair question?
No,
or-
I mean, I think that the board always tries to be reasonable, but we also get frustrated when we don't see responsiveness,
Look,
right?
we don't want to come back, but we will because we understand what you're requesting.
Right. And so I would also say that just as you're doing screening around the perimeter of the building, however it is, and I suggest really, if you want to make this a lot more pleasant, that you meet with the neighbors when you come up with your design solutions and actually show them what you're proposing to do. And that way, you'll have maybe somebody, as we did with another case just today, send a letter saying, I'm good to go,
I
right?
reached out immediately to the neighbors, and I welcome it.
I'm taking-
Right,
taking
no,
out the
that's
screening
not what I
design.
said.
Yeah.
There's several.
No,
design-
I welcome meeting with them and showing them what we're proposing, because
Right.
you're right, it would, if we had met before and been on the same page, it would save a lot of effort.
Right, okay, so, but what I wanted to say is because you're looking at screening and landscaping and things like that, maybe there's a way of screening the lighting better than, and if you were to maintain these poles, not that I think it, to Commissioner Chandra's point, I don't really understand the need for such intense lighting for a 2-hour window when probably no one's parking up there, because according to your utilization rates, you're not going to need that upper level at the last 2 hours of the day.
We don't expect to. That's
Right,
correct.
so therefore, all of this argument about those poles could be alleviated by you just doing the lower lighting, knowing that you're probably not going to actually need the lighting on the rooftop.
Right, but if we're talking about taking a very simple solution and making it an extreme extravagant solution that's 10 times the cost for this limited hour, we look at it the opposite. We're probably talking about at least $200,000 extra for the IV, plus landscaping, plus whatever, and we're looking to be reasonable, but to invent a solution that's no better and much more expensive, and it's hard to do, we'll have to drill into the driveway. Again, we will look at it with an open mind.
Well, here's another, and I don't know enough about how parking garages are regulated, but what if the rooftop parking wasn't available at night? It gets closed off at night, that top floor. Then you don't need to light it, except for fire department emergencies.
I'm not sure if it's legal or practical.
Well, that's why I'm asking you to find out,
I mean,
right?
the worst thing in business is to create a situation that creates accidents or unsafe conditions. So we can look, first and
look at that
foremost,
solution and-
right, can we get a copy of those plans or reach out? I don't know.
The project manager will email it.
That's
to
wonderful.
Laura.
And look, and we'll look at it, and we'll look at it with an open mind, and it may make sense.
I would just suggest that I think it may be difficult if cars are already parked there and then to close it. What are you going to do?
Don't park here unless you need to leave by 6 or something.
Yeah, late night parking. Go
But
up
someone
top.
may
Yeah.
park there and then need to leave at the end of the
Okay,
day.
fair,
and
fair.
Okay, and thank you.
Okay, thank you. All right, so tell me how many on the first day in February?
The first one we have 19, the second one we have 8, and the third one we have 1.
Oh, so we could put it on for the first one in February.
Okay, so February 5th with a submission date of January 16th.
Okay. Thank you, everyone, for coming. Appreciate everybody.
Yes, okay. McDonald Avenue.
Item number, new cases, item number 1, 2017-258 BZ, 6161 Broadway, the Bronx. What happened?
Okay. I'm gonna go to my aqua source. We're swearing in. Let's go.
That's it? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Yes.
Okay.
back, right?
Yeah.
Pass this down. Just make some- It's a sign analysis form. Pass it down.
You may as well, you could have been done if you had just walked.
What happened? Oh, it's different. They're different? Oh, okay. Okay, that's all.
Okay, give Jella, Marquez.
Did you submit this?
Oh.
Good afternoon, Elise Fullader from Eric Latin Peace. I have with me today Larry from High Point Engineering, architect, and Frank from Stonefield. Firstly, I handed out, Larry redid the sign analysis form and the signage on the plans to break up by frontage and clarify the numbers, because I know they were a little unclear. So all the signage has been redone to clarify. There'll be 49.1 square feet of frontage and signage along
251st.
251st and 97.2 square feet along Broadway. There's an illuminated sign on 250. Larry, you want to say what he did on the plans, please? Yes, on the corner.
Larry O'Brien, High Point Engineering. Yes, we had some questions regarding the ID sign on the corner. And the first thing we did was the square footage was reduced to a 6 by 4, so it's 24 square feet. The height is 25 feet.
Go to Z00.
I'm sorry,
What are we, where are we?
So there's an ID sign that they talked about.
Tell us what page to go to, please.
Z00. It's the proposed condition.
So that sign will be on the corner within the landscaped area.
There's a concern that signage would be, we talked about it, the TV thing, and it would go into the light field of the residential neighborhood. To change the sign.
The sign itself is changed in size to 24 square feet. However, it's internally illuminated, like a standard gasoline station sign, so there won't be any projection or LEDs or anything on that particular sign. It will be directed toward the Broadway traffic. So internal illumination, it will reduce any kind of spillage that you might see on a light fixture.
Right,
So it
right.
won't affect the adjoining neighbors in that fashion. And then along with that is the standard price sign on that pole. So that was with regard to the questions on that ID sign.
So, probably.
Yeah, okay, yeah.
Okay, in terms of curb cuts, you said you did not see this curb cut, or it was unclear, it's really hard to see, but I have a picture of the curb cut.
Because it looked like you were showing us the handicapped
There is the
access
handicap-
ramp.
Yeah, but there's also, you can see where it kind of stops like this, and the curb cut begins, it's just really hard to see. But that's a curb, it's an existing curb cut.
I'll take your word for it, okay.
I'm trying.
And just so I understand, you don't have the sign for parking?
We eliminated that. Our total would not accept that portion to include on the square footage allowance.
In terms of the fence and asphalt, all will be new. So he's redoing fencing and asphalt.
Okay.
So with the new gas station, as far as being rebuilt, the building will remain as is. The repair shop will continue.
It's in operation right now.
Yes, the repair shop is operating. The underground storage tanks will be new, along with the piping and the 3 dispensers underneath the new canopy as well. And the tanks, piping, and dispensers will be approved by the New York City Fire Department. and it'll also include fire suppression in that canopy over the pump islands. We will, in listening to your review yesterday, we will include a metal picket fence along that portion, which would be the north side where the apartment building is behind the station. And we'll have...
North side.
I think it's the west.
So on
The
the
west
north side of the
side,
property.
yeah.
so
The top of the page.
Right, the building will be to the top of the page. And we'll have our fencing on top of what is a retaining wall. And to improve that wall itself, we can add to the front of that, like a finish. Even as, because we don't want to rebuild the wall, it's a retaining wall, but we can finish that.
We don't have any photographs of the inside of the site, so when you're talking about a retaining wall,
Okay, so between the apartment building on the right and the gas station, there's a level difference. The apartment building area is a little bit higher. So that wall itself is a small retaining wall.
okay.
So rather than rebuild or replace it, we can actually finish that on the gas station side to a new finish.
We can give you pictures of it.
Yeah, you need to give us pictures because we're, and drawings.
And we'll provide drawings for that finish, yes.
I had one question. The proposed trash enclosure, that would be located less than 60 feet from the property line, right?
That's correct, yes. We brought it away from the residential as much as we could.
The other reason I'm asking that question, I realize the property next to it on the south side is vacant currently. And if there were to be any development, typically it would be, let's say, 60-foot wide building.
There's a building here now.
No, there's a vacant site and then there's the
Oh,
new
and then
apartment
there's a
building.
building?
Yeah,
Oh,
and that
okay.
vacant site is about 50-foot wide or so. And then so if there's to be a building there, an apartment building, most likely, with a commercial storefront, I just want to make sure that that trash enclosure is not located right below someone's window. And I think that's why I asked 60, it's less than 60 feet, then it would not be right at the edge of the building. That's why I asked that question.
Yeah, that would be fine. No bad. The location's fine in case there was...
So assuming a 60-foot deep building,
Yes.
this trash enclosure will be within that 60-foot
Oh,
and
just
not
making
would
sure.
be someone, close to someone's
Okay.
rear window. That's really what I'm getting at.
Okay. And then I guess the only other issue you discussed is the existing attendant parking area. We could put on the residential sides in the back, the two residential rears, we can put 4-foot landscaping along those two edges, and along with fencing. So there's a double barrier there.
Where? Which part?
On this
Oh,
and this,
okay.
we can put a 4-foot landscaping area as well as a fence behind it. So there's a double barrier
Okay.
along these two edges. And then maintain what the historic use of the attendant parking, because it's been there forever. We'd like to maintain that.
And I'm sorry, that part, that's transit parking?
It's attendant parking, meaning the commuters, there's people that work at the station that will bring the cars to the back.
Oh, but that's different than the historical use. Historical use says it was accessory, it was attended parking,
It was public parking. It
was public
public parking.
Yeah,
That's
I
different
just-
than using it as storing cars that are being worked on.
I just want to clarify, sorry, just for the special permit, our authority is only under considering the automotive service station. That sort of parking, I mean, if it's permitted under the underlying zoning district, and that's an as-a-right use, that's one thing, but...
You can't get to it
But
without
it
going
can't be
through.
considered an accessory to the automotive service station.
was public parking here, and we wanted to maintain it as public parking.
No, but so the thing is, but you're not using it as public parking, you're using it as parking for the,
No, they're using it as public parking for commuters, they said.
for commuters.
We have that other, the cars for awaiting service is in a different space. It's next to the,
To the right of the building.
here
So
along the.
I don't understand because when you look at the satellite view, it's overgrown there.
It does look like that, yes. There were, I don't want to call them garbage trees, but there were trees that were overgrown and also weeds that did grow up through.
It's just weeds, because
So
the
it-
site hasn't been in use for.
So the Google map view is a little misleading.
So the use is no longer used as attended parking, as public parking, correct?
The use of the backspace, public parking by attendant. I don't know if
No,
that's-
but in other words, if it's overgrown and there are garbage trees back there, it implies to me that nobody's parking back there.
It's, at this moment, it's been cleared out, and it is.
So it's not being used as public parking.
It's not being used at anything right now.
Okay, so wouldn't then, now I need to look at what the zoning, so this is the C22 zoning district, is public parking allowed as of right in a C22?
I think so.
Because in order to get to it, you must go over this, through this service station in order to get to the parking. It's impossible to use it otherwise.
Yeah, I mean, if it's permitted in the district, if it's permitted in the
But
district.
this is different than, we had another case like this, remember, where we insisted that they separated out from the
It
application?
can't act as an accessory to the automotive service station under 1210, definition of automotive service.
No, but that one was not accessory. It was in the corner, and it kept floating with the application. So we told them, take it out, because we don't want to know about it. We're not regulating it. In this case, you cannot get to this facility, the parking area, without going through this proposed service station, right? And so the question is that they want to bring the service station back online, right? And my comments were, this is an apartment building complex that this is in, and that it should be better shielded from the proposed guest service station and all of that. This public parking area that's not being used at all, so the use is abandoned effectively,
So-
right? Let me just finish my sentence. It's not being used at all, that area could function, at least some of it, as a buffer zone, so that it protects the residents in the area from this new use.
At least
So-
you mentioned maybe earlier about the rear portion of that parking area and the right side of that would be adding a 4-foot landscape buffer in addition to the screening, fence screening.
So then you wouldn't have nearly as many
You would
parking
have
spaces.
less, yes.
Yeah, so we're willing to give up less to give up more screening, to give more screening to residential.
Okay, so we would need to see what that looks like.
I don't have the numbers of the parking that
For
would remain.
zoning, this is in a C2 district, it's a use group 8.
Yes.
Yeah, use group 8.
And it is permitted,
Yeah,
public
she's got
parking
it. I
is,
got it. I mean, she's got it. Thank you.
public parking is permitted, public parking garage or public parking lot with a capacity of 150 spaces or less.
Yeah, so for just, I mean, this is just procedural, because we're under a 73-11. If agreed upon and permitted, it'd have to just function as its own primary use, not accessory to. So it can't take on the 16B use, it'd have to be a standalone use group 8.
Right.
So does that mean they should not show it on the plans because it shouldn't be under our jurisdiction? And then they go to Department of Buildings to legalize the use? Or like, how do we handle that?
I don't know the answer. I mean, it's obviously traveled with the BSA decisions before. Maybe there's a notation that says it's not, but it's on the zoning law. So it's part of the zoning law.
And this This old one gives a license number. I don't know, they just
Well,
said
that's
what
just the Consumer Affairs license
That's
number,
what it does.
right? So,
And according to that, you had license for 25 spaces.
Yes.
25?
Yeah.
How? How in the world?
There was parking along the left side of the property, but no longer feasible with the...
Oh, but on the, no, but that's not the same thing. No, just for that back area, it's not 25 spaces.
25 cars.
How could you fit 25 cars in there?
I wasn't here during this time, but that is what.
So that's cars stacked on their sides?
May have, I don't want to, may have been lifts involved, I'm not certain.
I don't see how you could do it with lifts. How do you get into the lifts? It's cars stacked on their sides.
I think they assumed even the site.
Yeah, I think they were including the side, even though the side is within the gas station.
Yeah.
And so that was the other thing. You're reducing very much that's a vacant lot side, which is going to be housing eventually. That's what we're saying, right? So my question was also, why can't you provide more screening on that side?
Screening to which side?
The adjoining lot that's labeled vacant lot, which we assume will become housing.
I mean, it might also become commercial.
Ground floor commercial, full lot coverage.
Well,
with
full
an-
lot coverage
with an
house
apartment.
with an apartment building, likely, right? So by providing no screening for it,
I mean, we are putting a fence that will,
Right.
and it's not going to be like a clear fence. We can put a fence.
And 4-foot landscaping.
but what's the problem with having it be actually screened?
Well, if we screen it all around, then we can't use the public parking really at all.
Oh, you mean along the property line?
No, I just mean along the property line,
Oh, we
the
can do
southern property line.
Yes, that is possible, yes.
But
Screening, sure.
Oh, for screening.
Yeah, screen that side, yes.
Okay, okay.
Right, just landscaping this portion. So, yeah, it's
We can screen the whole thing, but landscaping keep it.
Well, I mean, when I say screening, I mean landscaping. 4-foot wide vegetation with a fence behind it. You're already showing
Yes.
it up to the trash, which, by the way, is adjacent potentially to residential use, right?
But I think, given that this is not a very wide lot, I mean, most likely there's going to be a retail store that will probably go all the way to the property line. This is just 50-foot wide, so to maximize it, it's going to be a one-story retail use very likely. So there will be a wall along that edge, so having a landscaping there, it's not going to benefit anybody because a residential building is going to be, it's not going to be a full lot, it will be
No,
much
I'm not
less.
talking about at the parking lot. I'm talking about next to the trash.
Oh.
And why can't the trash be up against the building itself?
That's the typical path for the vehicles to get to the rear?
Okay.
Right, but they could,
And if
if you put the trash enclosure up against the building, they would travel along the lot line to get to the back too.
But then this landscaping along the edge will not be possible.
That's what you said.
Right,
Why
that's what
couldn't
you
you
said.
just continue that straight to the back? You have 26 feet, and a car is only like 5 feet wide. So if you move this here, and that takes care of 10 feet, you still have about 16 minus 4, you have 12 feet wide for them to get to the back.
And what is that protrusion that's shown on the building? There's a little nose on that lower left corner of the building.
That's why it's valet.
I believe that was an
These aren't
attendant
gonna stay.
key, like a key space, holding keys for vehicles, like an attendant for the parking.
That's there now?
Still there, yeah.
Yeah. Because this has been the use.
Right, but it's not the use anymore, right?
The space, the
The-
physical building.
But you could take that away, right?
That could go away.
Because what it's doing is ruining your circulation.
So if we relocated the trash enclosure to the building side
Yes,
and continue the buffer
yes,
to the rear,
correct.
to the parking, yeah, yes, we can incorporate that.
Okay.
And also there'll be, already put it on, he dimensioned the planting beds, but we'll make sure to have it.
All right. What other comments did we have? I think that was the gist of it, right?
But my only question is, how would you like us to then mark the parking area? Is there a way? There's always
I'm not sure how to handle this, and to do this on the fly is a little weird. I mean, we had it shown on the prior drawings, but I'm not sure how the board responds to something that's outside of its jurisdiction, yet it's on the zoning lot. So we need to talk about it. So why don't you, before, obviously, in the next couple of days, after the holidays, get in touch with the project manager, and we'll talk about it, okay? And then we wanted traffic studies, right?
For the record, Frank Feliciotta with Stonefield. Based on the review session comments yesterday, it sounded like the board was interested in some information pertaining to the traffic light at Broadway and 250 First Street.
Yeah.
So we did obtain the signal timing from DOT. It runs on a 90-second cycle continuously throughout the course of the day. It doesn't really change much. It's a T intersection, which really means there's just two phases of the signal. There's the Broadway phase, and then there's the side street phase. What's interesting here is that earlier this year, DOT put in a protected bike lane along the east side of Broadway. You might be able to see some of that evidence on Street View. So the parking was moved out from the curb, and the bike lane is now shielded between the curb and the parking. We did also request accident data for this intersection. We got it this morning after hearing your request. And from 2014 to 2016, there were a total of 11 accidents over those 3 years. It's about one accident every 3 months on average. We were informed that there were no pedestrian or bicycle accidents during that period. But we will summarize that for the board if you'd like and submit that as well.
Well, so when you have, that's not a little number of accidents, right? So when you're potentially increasing the activity on the roadway, don't you need to do something to show how you're going to mitigate?
Well, the accidents that typically DOT looks for in terms of the hot button intersections is 48 in a 3-year period. So we're less than a quarter of that amount. Again, we need to look at the severity of those accidents, what kind of accidents they were, in order to really figure out if we can do anything about that. Just an increase in traffic doesn't alone necessitate a higher accident rate. There could be some prevailing issue here. I'm not even convinced there is an issue yet. This could just be human error as a result of a lot of traffic on Broadway. So again, what I would say is let me do the analysis, I'll submit it to you, and then we can recommend whatever needs to be recommended.
But is there I don't see a traffic light. Is there a traffic light at that location?
There is.
At 251st?
Yes.
Yes?
I think there's also a bus stop on the eastern portion, just north of the traffic light on Broadway.
I think it's southeast and northwest corner. So the southbound is at the northwest corner.
No?
Yeah, the southbound's on the northwest corner,
And
but
then
I
the
think the
northbound's
northbound's
on the
it's on the south, oh, that's right, the southeast,
Yeah.
not the northeast.
It's the BXM3 and the BX9, I think.
Right.
So, let me see, this was taken out of service when? When was this taken out of service?
I had it in my.
Yeah, I thought I wrote it down.
2 years, that's why it didn't work.
Yeah.
It was like 3 years ago or something.
So then it's relevant. So the question is, could any of those accidents have been caused by exit or entrances to the service station?
And that's something we're going to have to take a look
And
at.
if they were, then how do you mitigate against future accidents?
Yeah, I mean, one of the things is we look at curb cuts and figure out what curb cuts are necessary, for the use to subside, and what curb cuts might be either closed or limited in terms of turning movements.
Right. Or maybe even some kind of a dry, what do you call it? I don't know what that's called. The lane that that comes close to the curb to encourage you to merge more gradually.
Decel lane or something.
Something.
Yeah. Yeah, I mean, you'd probably do some striping or something to guide people over earlier. But yeah, I mean, all things that we can take a look at.
Okay. Are there any speakers on this? Did I already ask? Okay, so we need you to make all the changes to the project as discussed, and obviously the additional information on the traffic studies?
Yeah.
Okay, and in terms of the traffic studies, it's the same as on the other project. As soon as you have that information, please send it to us, and we'll forward it to DOT for review.
Be happy to.
Okay. All right then, so could you put this on maybe for the 2nd February?
February 12th with a January 23rd submission.
January 23rd. Good.
Item number 2, 2017-278 BZ 405th Avenue, Manhattan. 450th. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board is silence and board member questions?
I do, thank you. Good evening, Madam Chair, Commissioners. I attended the executive session yesterday, and I believe there are 3 questions that were asked I'm prepared to answer. One was the status of the massage licensees, and I do have copies of updated licenses for all the massage therapists at the premises, and that will be filed formally tomorrow. You mentioned 17 open elevator violations. There are actually 11 on record, and they have been cleared. Information I've received from our consultant is that they have been cleared, they just don't show up in the systems yet, but they've been resolved.
They've been resolved.
Yes.
Is there something that you can show us that shows their resolution? How do you know they were resolved?
Because I asked the engineer who's responsible for it, and he said that they're still listed as open, but that he's resolved the issues and taken care of the problem with the elevators.
But
So you're just waiting for the system to be updated?
Right, that's correct.
But usually, there's some piece of paper you get that indicates compliance.
Certificate of correction.
Right, a certificate of correction. What about a certificate of correction?
I will ask them to supply that. And the third question was regarding the need to travel along and in front of the residential elevators, and the concern about access to those residential elevators from people who attend the spa. The only access to those elevators is through a card system, a key card system, so that people entering from the outside will not have any access to those elevators.
So wait, so you do walk past
You
the
do walk past
residential
them, that's correct.
elevators, but you can't, if
You
you
can't-
got, it won't open on the floor, or if
It
it
won't.
did, you can't go anywhere?
Well, it'll open on the floor only to the extent that the residents of the residential portion of the building can get off on that floor and utilize the spa. But people from the outside can't gain access to that elevator because they don't have a key card to gain access to it.
But if a residential tenant is coming out of the spa and wants to go home upstairs, do they just push the elevator button, or they have to have
They
a
have
key
to have
card
the
to
key
make
card.
the elevator open?
They need the key card for access.
No, my question was, they're standing on the elevator lobby, they push the elevator button. Do they need a key card in order for the elevator button to
Yes.
receive their call request?
Mhm.
Okay.
That's true of both the hotel guests as well as the residential occupants.
Okay. All right, what else? Was there anything else on this? No. Are there any speakers on this? Okay. Does anybody have any problems with this? I mean, no. We're not going to have time to get the certificates of correction if we, no, everyone's okay
His
with that?
representation is fine for me.
Okay.
Yeah.
And I think you were the one who raised
I
the
was
issue.
the one who-
Yes, okay. So then I'd like to make a motion to close.
Chair Promoter,
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley-Brown.
Aye.
Commissioner Shedder.
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant.
Chair Promoter,
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley-Brown.
Aye.
Commissioner Shedder.
Aye.
Commissioner Shabeta.
Aye.
Thank you.
Thank you.
Item number 3, 2017-305 BC, 6626 Metropolitan Avenue, Brooklyn, Metropolitan Avenue, Queens. Raise your right hand. Do you affirm to tell the truth, nothing, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? I do. Thank you.
Sandy Anagnostou, representing the applicant. The board had questions regarding accessibility to the proposed physical culture establishment. On the cellar level, where this proposed PCE will be located, there are two ways to access it. One is directly from the parking area in the area where is currently located a loading area. We're proposing a new stair and new handicap ramp. You could see that area in the photographs that we submitted, and also on the proposed plan sheets P5 and P12. We're proposing a new stair and a new ramp. There's an existing ramp there and a stair, but that's a loading area, so that whole area is going to be replaced. Also, there is a main entrance where you can access from that parking area into it's like an atrium mall area and walk down to the proposed PCE. This site is very steep. You can see in the photos that we submitted on December 12th. You can see in views 1, 4, 12, and 14. If you don't have them, I have the hard copy here. It's a very steep site. It slopes down. So the question was if you're...
Slopes down towards Metropolitan.
Yeah. So on Metropolitan, there is an entrance actually, but if you go through that entrance, you'll be on the first floor. There's a lobby area. You'd have to take an elevator down, but when you get to the cellar level, you're actually in the BJ's area, and you'd have to walk through that area in order to get to the PCE. So that's not the best way, but there are reasonable accommodations. Also, if you look in the photographs from Metropolitan, there is a sidewalk where the entrance ramp is to go up to the other level parking. There is a sidewalk and a walkway where you can walk down. There's also another walkway on the other side where the exit ramp is. I don't know if there are any other questions, but, or if that's clearer.
Yeah, so, but to sort of cut to the chase, it's
Yes.
that's the main entrance.
Yes.
And so in terms of the disabled, I just want to make sure that they're not being sent around the block.
No, they would park in that parking area and either go through the ramp, which is the new ramp that we're proposing that's shown on the proposed plans, or they would go through the main entrance, which is again located in that parking area, and it's at the same level. They don't have to go use any steps or and go down to the PCE.
Okay, great. Any other comments about this one? Any speakers on this? Okay, then I'd like to make a motion to close.
Chair Kamara?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shibata?
Aye.
And a motion to grant.
Chair Kamara?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shibata?
Aye.
Thank you.
Item number 4, 2018-133 BC, 450 West 33rd Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? Go.
No pressure, no.
Good evening, Dan Braff on behalf of the applicant.
we don't have any questions. It's a delightful project with all of those box within a box, so we're not going to hear about neighbors complaining about the rowing and the treadmills. Okay, so I'd like to make a motion to close. Oh, are there any speakers on this one? I'd like to make a motion to close. Aye.
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 And a motion to grant.
Aye.
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 Thank you, Chair and Commissioners. Have a good evening.
Item number 5.
Yes.
2018-19.
Wait, we're a 3-minute break?
Yeah.
3-minute break, sorry, 3 minutes. And those videos,
Okay, back in the record.
or maybe, I might be able to do it.
Mic's on?
Yeah.
Mic's on?
Uh-huh.
Item number 5, 2018-95 BZ, 120 MUM, Brooklyn. Everybody raise their hands? Do you, raise your right hands, I want to see. I need to see. I need to see you raise your right hand. Sorry. Your hand?
He's a speaker, he's a member of the
Anybody who's a member of a team who's going to represent the owner, part of the team, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Okay. Go ahead. You sign and then start. Go ahead.
Chair, Commissioners, good evening. Richard Lobel of Sheldon Lobel for the applicant, HASC Center. We're joined today by members of the HASC community, including administrators of the facility, the project architect, an environmental consultant, David Rosenberg from my office, and others who are related to the facility. So I understand that the board had a number of comments, which we had a representative at the executive session to hear these comments. And so I know that there's some questions relating to HASC's program, which I think are going to be better addressed by their executive director. But I will just start with what I think is probably a gating item, which is that the board discussed the deference that would be due to HASC as an educational institution, and I'm happy to discuss that deference. I think, though, that at this time, I know that Councilmember Yeager has been waiting for some time to talk. He's indicated that he would wait and listen to some of the testimonies, so we appreciate that. HASC is an institution which is dedicated to the enabling of mentally and developmentally challenged individuals. It is an organization which has helped hundreds, if not thousands, of these individuals throughout Brooklyn and beyond. It currently operates 5 different day programs throughout Brooklyn, and so the variance application here is one which is going to be extremely instrumental in allowing HASC to operate and allowing them to efficiently provide for their services to the community that uses their day programs, medical facility, and everything else. And so as an initial matter, whether or not they're entitled to Cornell deference, we feel that they are. We will, and we have submitted some of this in our statement of facts and findings, but we will elaborate on this in a legal brief. Cornell is obviously a case which allows deference for educational institutions. And so while there are specific special permits that are set up under the zoning resolution which address schools under zoning and which define school and discuss the requirements therein, Cornell is somewhat broader than that in allowing deference for schools, but also the decision talks more widely of educational uses. And so the cases which we've cited and have discussed within the statement of facts discuss that these type of habilitation programs for developmentally challenged individuals, they really operate as schools. The learning and the classes which take place for members of this community, this is really their high school, their college. This is what they use in order to gain basic social skills, which allow day-to-day activities and also vocational skills which allow them to operate in the greater community. It is indeed heartwarming, and I'm sure that the HASC administrators can talk about this, about the fact that this is a challenged population. It is important for them to be able to have access to all of these programs within one place. So you can imagine the difficulty that you encounter during your day when you are forced to go from one appointment to another appointment, and maybe you're taking a taxi or you're in Uber. These are individuals who, most of them in these day habilitation programs are in wheelchairs, and so and many of them are unable to talk. And so the idea and the ability for them to be able to receive these services in one setting is of critical importance. For them to be administered to by educators and others within this one building is of primary importance. So I would just note that in addition to the educational programs here, we also have a medical treatment center for individuals from the school, and we feel that that is an important part of this as well. There's been questions with regards to whether or not this is accessory or whether it constitutes a valid accessory use. We feel that it does. We note that that the cases surrounding Cornell, such as Lawrence School Corporation, which was decided by the Court of Appeals in 1992, dictate that reasonable accessory uses will be considered under the same deference as was allotted in Cornell, and that when talking about such educational uses, that the definition of what constitutes a reasonable accessory use is expanded. And that's from a long line of cases starting at Diocese of Rochester, which preceded the Cornell decision, through cases in the modern era. So that's just an initial statement with regards to our legal grounding. And I think probably what I would do would be to allow allow members of HASC to approach and just discuss the program that actually will take place at the site.
Good evening. My name is Dr. Waxluck. I'm the clinical director of HASC, and I'm proud of the work that HASC does in providing essential services for this population, which includes, as was mentioned, developmentally disabled individuals, individuals with autism, individuals that are physically challenged. We really provide a network of services. We have a very active day program in which individuals spend their day at a facility. They learn skills that constitute social integration, basic activities of daily living. They have a recreational component. And also, in addition, there are therapists that provide speech and physical therapy, as well as occupational therapy. They sometimes go out on excursions, they go on visits and trips, all designed to enhance their level of independence, depending where they actually are functioning, and basically to give them a day that is meaningful and that enhances their overall life experience. That's one component. We also have other components, but that is more variable in that the individuals who are served do not necessarily come to the facility at all times, but rather services are rendered in their own homes. They sometimes are rendered in vocational placements. In addition, they sometimes come for medical appointments, but that is much more variable. I want the board to understand that what we do is mandated very, very closely and monitored by the Office of Developmental Disabilities, a state agency, and we are required to have meetings and to write up programs, to have conferences on a biannual basis, if not further. We have requirements to provide various psychological services. And again, those programs are a little bit more flexible, and they tend to fluctuate. In addition, we also have a residential program, which includes at this point approximately 35 to 40 residences located throughout the Flatbush area, and each one is an independent unit, but they do come back to the mothership in order to have their conferences, in order to have meetings, parental interactions, all take place on a more centralized level. Furthermore, there's a tremendous emphasis by this state agency in training. So training is a very, very important component, and it's mandatory training so that before anyone actually is allowed to work, they need to take a series of these training workshops, and it needs to be reinforced at certain given intervals. We also have a vocational program, which is not, vocational is probably a misnomer. Basically, what it is for those individuals who are functioning at a higher level, basically it's giving them the skills, how to fill out a resume, how to interact with a boss. So even though there is a vocational area, it's not, nobody's actually doing the work there. They're actually, again, it's part of their training and preparation for eventual placement in the work arena. Our major goal and our mandate and our mission is really integration. And I think that throughout the years, HASC Center has grown primarily because of the wonderful reputation and the job that it does. It was really the first organization that saw a need when the general population did not appreciate that services were necessary for people with special needs, and they tend to shun them. A HASC Center came to the fore and was one of the original organizations to provide these services. Furthermore, there's also the cultural element. Even though there were, in fact, other agencies that were providing services, but there are certain cultural sensitivities that dominated the thinking and the way the program was planned. HASC Center also has a magnificent summer camp for the most severely disabled individuals, and basically it is the place of last resort, not only with regard to the camp, but also with regard to the way that we provide services and the individuals that come to us. There are other agencies who are able to provide services to a less demanding individual in terms of their needs. HASC Center has never refused, has never turned away even the most medically challenged people who require a significant amount of personal care. We have always taken them and tried to provide the best possible service that we can. Now, in terms of the medical component, it's also important for the board to understand that, first of all, these individuals all have Medicaid. The medical profession is not always interested in providing services for that population. Furthermore, we have managed to create a team of doctors who specialize in dealing with these particular individuals. Some of them can't talk. Some of them don't acknowledge their own symptoms. And it's a very difficult task. So for them to go out into the world and look for medical treatment, the doctors don't want them in their waiting rooms. They cannot wait. They have to be treated immediately or they become agitated. It's critical for them to have a place that they can call their own and a place that recognizes and doctors who are professionally trained in dealing with this particular problem. I also believe that a building such that we are proposing, it provides a dignity so that these individuals understand that they are coming to a place which is aesthetically desirous. It's a place which has a wonderful appearance and that they can spend their days or receive their required treatments in such a facility. I thank you very much for listening.
Thank you.
You may want to ask one question.
Sorry.
You were speaking of the need for some of the students to have medical assistance immediately. To that note, if during an educational class, would a doctor or medical professional come see the student or would they be transported up?
They would be transported, they basically would be transported to the doctor.
Okay.
To the doctor where?
On-site, there is
In this on-site.
In this, right, there is a
Right.
medical facility there.
So that's what I was trying to understand, the relationship of the medical facility to the educational program.
Okay. The medical facility is, as I said, was designed specifically for these individuals. And
let me try the question this way. I'm sorry for interrupting.
Yeah.
Would you say that it is necessary in the education to educate these children? Is it necessary to have a medical facility within the site?
They're not, by the way, these are adults, they're not.
Well, these
That's the point.
adults, sorry. Is it necessary to have a medical facility? I just always make it, when I say education,
I know, that's the point.
Yeah.
That's what we have to
Is
deal
it-
with for this case.
Is it necessary to have a medical, on-site medical offices or on-site medical assistants?
I believe that it's very much preferential.
Richard, before you speak, I would really like to hear from the person
think
who
it-
manages the program.
I think it's preferential to have it, and I'll tell you why. Because again, since we're regulated by the state, there's ongoing protocols that have to be. They have to have an annual physical. They have to have different evaluations by specialists. To take them out of facility is to disrupt their program. To disrupt their program, they don't deal well with change. So it's a smooth transition. It becomes overall. Now, if you tell one of these individuals, "Come, we're going to see a doctor," well, that's not something even normal people are frightened. Are frightened. So I believe that yes, it is a very important component to provide the totality of care. As a matter of fact, there's changes now in the system mandated by the federal government that we used to have what was called an ISP, which would deal with the different treatment plans. Now,
What's an ISP?
individual service plan. And now they changed that, and it has become a life plan. And what is very important as part of this plan is the medical component. It becomes a medical necessity. And it's not only the medical, but it's also psychiatry, it's also psychology, and the fluidity of going from the medical to the day program, and for the people who are coming to the facility, it really enhances the overall.
So the people who, typical person who's in the day HAB program.
Right.
Who's in your program as opposed to an outsider who's just coming for an occasional day. I'm not really sure how that works. That's part of our questions.
Right.
But one of the people who's enrolled in your program.
Right.
How often does that person get brought down to any of the sort of what we'd consider to be medical treatment, like the psychologist, like a doctor, like,
Right.
you know?
So I would say psychology, the average is on a weekly basis. Psychiatry is anywhere from once a month to 2 times a month, and depending on the severity of their condition, it could be on a weekly basis. And there's also an exchange, which means the psychiatrist will consult with the individuals who are treating in the day program, and there's this back and forth exchange of information.
Okay, and what about the medical program?
And the medical program as well. I mean, if they need the medical treatment, whether it be to have, if they have a neurological condition, or they have a medical, a medical condition, so they go see
Well,
the
for instance,
doctor.
Mr. Lobel said that some 50% of the people who are participating in this program are in wheelchairs.
Right.
So are those people in wheelchairs in need of regular medical care that would be more often than, say, I might go for my, once a year, check all the body part type thing?
Absolutely,
right?
because many of them have secondary conditions. We have diabetics, we have a tremendous amount of seizure disorders, we have, all different types of conditions that require a more frequent medical attention.
So I think what we're trying to get at is whether or not it's integral to the education and training program at this site, that there be medical and psychiatric facilities, or is it a convenience? And that's what we're trying to get at.
Right. And the reason for it is, to the extent that the medical program, which takes up the entirety of the first floor, drives waivers that you're requesting, and you're asking for educational deference, which is the arcane zoning discussion that we have to have here at the board. We need to know whether the medical is an integral part of the educational program. And while the two lawyers are in the back smiling at each other knowingly, I just want them to hear. Yeah, you can't see that. I want them to hear the example of the School for Medically Frail, which was maybe, I don't remember whose case, but that's an incredible situation of in that case it was children, so it's yet another thing, but children who had desperately difficult physical problems and therefore needed to be almost in a hospital setting, in which they're taught sometimes at their beds or are brought into a room for teaching that's 3 doors away from their bedroom. And so that's an exaggerated version
Right.
of this, and so I'm directing this to the two knowing lawyers, that they need to be able to make the connection that's similar to the connection that they made
I would just
in that
hope
case.
And would cite and some examples of what a typical emergency could be that would make it necessary.
So David Rosenberg of Sheldon Lobel PC. I'd also add to the discussion about medical programs, in addition to the psychology, psychiatry, and the day-to-day medical care, there are additional components regarding occupational, physical, and speech therapy.
Yes, that's not what we're talking about. We're talking about the medical offices. The occupational therapy, I personally understand that as part of the training that Mr. Lobel referred to as sort of high school and college equivalency. I get that. Speech training, dexterity training, those kinds of things. We're not talking about that. We're talking about the endocrinologist or the gastroenterologist in the building, that kind of thing. Sorry?
I'm Samuel Kahn. I'm the director of HASC Center. I would like to respond to your question. The individuals that we serve are medically frail, and many of them, quite a few of them are very difficult in transition. When they have to go, if they come to the day program, and they have to go for therapy outside or to a different site for therapy, or they have to go for the medical to a different site, the transition becomes a challenge. Their behavior sometimes becomes a major challenge, and therefore it's so convenient for them to have their medical in the same facility. The reason why we need this building is because right now the people that are going to be coming to the new building are coming from 4 different sites. The sites that we have are 1221 East 14th Street, where we have about 70 to 80 individuals there. I'd say 50%, close to 50% are in wheelchairs. About another 20 to 25% are very behaviorally challenged, where we have staff one-on-one taking care of them. Either they're running or they're not just misbehaved, they can hurt themselves and hurt other people. That's why they have one-on-ones. We have a site on Fort Hamilton Parkway and 42nd Street, where the site is girls, elderly and frail girls, where if we plan on bringing them together to a more comfortable site and much bigger, and the facilities will be better for them. We also have a site in Williamsburg on South 8th Street, where we have the site was built for 25 people. We have close to 35 people there. And they just need more room, they need more bathroom facilities, and as well as they need closer medical attention because those people are a bit older and medically frail. So I think this site will enhance the lives of the people that we're serving. It will enhance their daily activities because they won't have to be transferred from one place to the other for medical or therapy. So I think this site is very important for our entire agency to be able to serve these individuals better.
So another question would be, can they be educated in the absence of medical care being on the site? Can the program run without there being medical care? Will it be as good a program? Probably not, but is it possible? So for instance, going back to the medically frail, there needed to be rooms that were large enough to have beds and also space for teachers to sit next to the beds, because the young people had to be on ventilators for a portion of the day. So there could be no education of these young people if there wasn't a space where they could recline and be hooked up to a ventilator for certain hours of the day. And so the program was that the teachers would visit the young people at their bedside and they would go through their lessons. So without the bedside accommodations, you couldn't have education. It couldn't exist apart from it. So that's the same kind of threshold question that we're applying here.
Yeah, and I think we'll address that.
Yeah, right.
The direct quote I was referring to before from Lawrence School Corporation was that the court noticed the Court of Appeals noted that noted that educational institutions are generally entitled to locate accessory uses that are reasonably related to their educational purpose. As noted by the court, greater flexibility than would attach to applications for variances made by commercial institutions is required, and the controlling consideration must always be the overall impact on the public's welfare. So just generally speaking, we're going to go into accessory uses. We're going to discuss the fact that an educational facility on average would have a nurse or doctor on site.
It would, a nurse or a doctor.
Right. And so to the extent that we are addressing the needs of a very special population, we intend to demonstrate that that is a critical need here. So that's our burden, and we understand that.
So can I ask you a question? So, the issue is driving the waivers, right? Does the medical facility drive the waivers? If there was a way to lay this out, and I don't know if there is, because there's also, as we talked about, there's no cellar. You could put all these medical facilities in the cellar and then it wouldn't drive the waivers, right? So a lot of the waivers, well, there's waivers for floor area, there's waivers for setback, all of that. So Some of this is, I'm not even sure how to accomplish this. I am personally having trouble with making the connection between the medical and the educational, because you're asking for two extensions effectively on the Cornell doctrine. You're asking for an adult facility that's not a university. So we're expanding it to include something that's more, for lack, occupational and physical therapy related, right? For a very particular population. And in terms of your papers, you have to distinguish it so extremely that it doesn't open the door for other kinds of programs for adults who are not in a university system, right?
Yes.
But then you're asking, on top of that, for an extension of deference to include what's effectively ambulatory care. And that's really problematic unless you tie that into some kind of a university program, because as you know, we've done lots of ambulatory care centers that are connected to a university teaching hospital.
Right.
Right? So you're potentially opening up ambulatory care to the Cornell doctrine, and that gives me a lot of concern.
Right, and I think that, that we're going to have, I think once you tie this as a valid educational use under Cornell, then I think that the medical facility that services the student population reasonably flows from that. So I don't think we're going to have a hard time bringing the board to allowing Cornell to be used with regards to developmentally challenged programming, because that's been done before. I mean, we cited them in our cases, but we're going to drill down on that, which is fine. Once you basically say, okay, you're operating as a valid educational use, it's whether or not the medical facility here is reasonably related to that educational use, and I think we're going to well be able to prove that. I mean, this is, for me, again, as I've said before, I think Cornell, in a large part, comes down to the ability of local populations to object and to voice their valid concerns over waivers that are requested in zoning applications by educational institutions. And, I would add here that considering everything, considering the bulk, this building, the floor area, and everything, we've got a unanimous community board which says that we feel that this is within the character of the area.
But
Understood. So
really, the issue is,
yes.
the next applicant, probably you, will come in and say, I should get a variance for a doctor's office because, look,
No.
you did it on that one.
Oh,
Right?
I would.
Oh, never. You could never do it.
Schools, I will, if we grant it today, Haskell will be my last one. I can do that. I can make that deal right now. But in all seriousness, we'll fully develop this and brief this for the board. It is in the interest of, we understand the importance of precedent, and it is in the interest of the board to be able to narrowly decide in favor, we hope, of this institution. So, thank you.
So could you also then, after, assuming you make that threshold, could you then write more about the nexus between the accounting and fundraising controller offices that are taking up half of the third floor
Correct.
and driving the program up to the fourth, and education? Because when you look through the programmatic needs statement, it talks about how they all have to be co-located
Right.
to run, but it doesn't say they have to be located in the same building
Sure.
or at the same site as the school.
We will do a better job making that connection.
Also, on the other 5 facilities that exist, I'm looking at the map. Can you provide data on how many of these have the medical facility in it?
Sure, and I think that.
And whether the availability of the service is just limited to the students inside these locations, or it's available for outside?
Yeah, well, I think we can provide that as part of the materials. I know that to the extent that space is available, I know that one of the facilities does have medical offices on site to treat the population there, but we're happy to provide that.
The other 4 do not?
The other part was, so for example, the one that we discussed previously, which was too small to house its existing population, sadly, the space isn't there. So it's a discussion of accessory uses, and it's a discussion of what's reasonably related to the underlying use. When we look at Exxon Corp versus BSA, and we look at accessory uses, it wasn't necessarily that every gas station in that case had a convenience store. It was whether or not a convenience store could be found in connection with gas stations. And when it was found by the court that that was a reasonable assumption to make, the court necessarily expanded a gas station use to include a convenience store as a valid accessory use. So as that is here, not every one of the institutions that we discuss have medical facilities in them, but the test would be whether or not it would be found in connection with that, whether that would be something which would be found, and we do have both our example and other facilities in the local neighborhood which treat these populations and also have medical care on site.
Yeah, but for the case of Exxon, they are not looking for the same waiver we're looking for here.
No, well, yeah, I'm speaking solely to the issue of accessory use, in which that case was decided upon the definition of accessory use within the zoning resolution.
Okay.
That's it. Okay.
I'd also add to that in the board's comments, there were specific questions about asking us to provide more information about the existing facilities, which we will do in the subsequent submission.
Great.
I'd also just note that part of this application is to address deficiencies in the existing program. And so, in addition to what Mr. Lobel said about that the test for accessory use is not that it has to be in every such facility, just that it would be typical of such a facility to have it, I wouldn't necessarily read into saying that because some of the existing facilities don't have the medical center on staff, that none of them need it. In fact, the fact that the application is in part because the habilitation programs require having the medical use accessory to them, which is why we're moving forward to consolidate the 5 disparate locations into one new facility.
Right, but the discussion you're going to have is a more nuanced discussion because you're talking about extending deference further than just the initial education/training facility if you meet that threshold, but then also to the accessory use.
Yes, absolutely. Our submission is going to address both the board's concerns on the legal side of making sure that we're covered on accessory use and that their deference is applicable, but also on the factual side with respect to the existing conditions and the proposed conditions to make sure that that connection is not just theoretical and is practical.
And that you are going to close this so tightly that there is no one, including you, the collective you, the guy whose name is on the door, right, can get inside of it with a different kind of an application that doesn't look exactly like this one.
Yes, understanding that, of course, the board has also been instructive in this in prior cases with respect to expanding the Cornell doctrine, the Catherine Sheridan case specifically, where the board found very specific constraints to the expansion of the Cornell doctrine, where that was in relation to affordable housing, where the board put restrictions on not only the level of affordability, but also certain conditions about who the operator could be. And specifically addressing concerns from certain non-party, or I guess, amicus submissions, worrying about possible expansion of the Cornell doctrine beyond what was intended by the board at that time.
Right. Okay, thank you, thank you. Anything else you want to bring up? So you're going to respond to our questions about the programmatic needs analysis, right? Okay.
Correct. I'm not sure whether or not we would take this opportunity noticing the lateness of the hour, we're happy to answer any other questions that were raised with regards to the physical plant of the facility, or we can further address that in submissions and really it's at the discretion of the chair.
I think taking advantage of the director being here, I'd like to understand why there's men's, a women's, a co-ed, and a community hab program.
I just quickly jump in before Mr. Khan speaks about the 3 habilitation programs.
Four.
The community habilitation program is separate insofar as it doesn't actually exist on the site. The community habilitation is there where the clients are served in their homes and in the community by staff that are both paid and volunteer. Primarily geared towards those that, for whatever reason, cannot make it. The only ones on site, which Mr. Khan will speak to why there are 3 of them, are the men's, women's, and co-ed habilitation facilities.
Like here.
why there needs to be a men's, a women's, and a co-ed day hab. Why can't they be combined, or why isn't men's and women's sufficient, or co-ed sufficient? Explain, because they're taking up a lot of space. Each one has half a floor, right? So trying to understand the programmatic.
Yeah, we serve all types of, anyone that wants services from Hass Center can get services. Some people would like a co-ed program, simply they're at their own will. And some people would like Orthodox, and they would only like a separated men's or women's program. That's
But so that double.
And if people who are not religious or people who are not affiliated with the, if they would like it's up to them as well to decide which program they want to go into. Right now, we have a co-ed program at East 14th Street. We have a women's program on Fort Hamilton, 42nd Street, and the men's program at in Williamsburg. We also have two other men's programs that we're not planning to bring into this building because they're functioning very well where they are.
Okay.
We have one in Sunset Park and one in the outskirts of Borough Park.
But so you don't share, or you do, like for instance, the cafeteria area is shared between the men's and the women's. So for people who don't want to intermingle, I don't understand that, for example, that it's a shared kitchen. So then it seems like it's almost functioning as a co-ed activity. And meanwhile, you have 3 times the amount of space because you've got all of the space, all of the program for this one, the same identical program for that one, and identical program for this one, in terms of the amount of floor area that you're taking up.
So this is really addresses the needs of the individuals. Some of the individuals come from Hasidic homes, and one of the basic tenets of their living arrangement is complete separation between men and women. So what we need to do and what we have done is to satisfy that requirement. We have separated the men. We created a men's program, created a women's program. Now, there may be some crossover, let's say if they share the same kitchen, but it would be at different times. In no instance is there any real mingling between the males and the females. And then there are people who come to our program who are less stringent, and they don't have that requirement, and therefore we provide them in just the opposite. There's something to be said for a co-ed program because it enhances socialization between males and females, but that's not really our call. We're really addressing what the families and what these individuals require for themselves. So, there is some degree of duplication, but there's no real way to get around this. And there are many other agencies within this religious spectrum that provide the same kind of service, where basically females and males are kept in different programs.
Okay, thank you. And then in terms of the programmatic needs report, what we really need to understand is how it was decided that you needed X number of exam rooms, X number of classrooms, all of that, because the way that it's reading is you had all this space, it fit this many, therefore we need this many, right? I don't need for you to address it now, it's to address in your response to our questions, because, right?
We're going to address, I think the chair's right, we're going to be responding in writing, and we will include this response as talking about, from the architect's perspective and the design needs of the client, as well as the regulations that drive some of these designs.
Based on the number of participants in each program, how many participants per room, how often someone goes into a therapy room, and therefore you need this many therapy rooms, et cetera.
Yeah, as I think it was Vice Chair Chanda who pointed out yesterday, that it is a lot of information in terms of occupancy, and we understand that we need to break that down further for the board.
Right. Well, but, it was a lot of information, except that all it did was replicate the floor plans, and then just say, here are the floor plans, we need this, here's a list of the things we need. That's not, when you're designing a building for the first time, you meet with your client, and your client says, these are the things that we do in my program. We have this many participants. We do the following things, and you ask questions. How many people sit in a room together? How many people are in each program? Okay, according to that, the standard size for a classroom is X, but it's a different kind of a classroom because different, maybe family attend at the same time or something like that, right? And so you need to tell us how you got to these conclusions.
Okay, so good evening. My name is Charles Schwartzoff. I'm the project architect here.
Hi.
And just to shed a little light, so we have food for thought of where this came from, we spent extensive time going through and meeting with all the programs and understanding, delineating required as far as square footage is based and driven by occupancy and by Department of Health code compliances.
Right.
And all of the needs for the different programs and different staffing, that's how all of this has been generated. I'll do a little, I think I'll separate it a little bit more, delineate a little more of how the actual programmatic charts read, but it's all been driven by code compliances, the number of occupants, and how these programs are run. And when they exam rooms, for instance, just momentarily, not only do you have a client in a wheelchair, but you also have the staffing, have the helper, and you need enough room to get around the, to break it down to the.
That'd be great, if you can explain it like that.
Well, I thought I did on this, but there is a lot of information
No, actually,
in it.
this was more like backing into the answer. What I really want to see is when you first met with this client and you started your interview process of speaking to the administrators and the teachers and all of that sort of stuff, you created sort of your spreadsheet and then you
Yes.
made bubble diagrams,
Absolutely.
right? I'm interested in the bubble diagrams. I'm interested in
I have-
how you.
I've got those.
Okay,
And that's how
good.
we broke it down and spent meeting with all the different programs and all of the directors, and we have that. If that's something you'd like to see,
Yes.
we could see that.
It's like
because
what you did as you were learning about the project, right? Okay, good. Okay. I don't know if there's anything else. Oh, to correct the parking calculations, but you're going to listen to the review session and go through everything, right?
Yeah.
And the architect will therefore hear the review session too. You need to listen to the video because we had lots of questions for the architecture, and just go through that and respond to all the questions, okay?
Okay.
All right, any other?
Just very quickly, one
Yeah.
more thing. I'm looking at the website of HASC, and is this like a not-for-profit organization?
Yes, this is a not-for-profit organization.
When I click on the medical center, it takes me to an entity called Blank.
The Blanche Kahn Family Health Center.
Is this part?
Yes, this is the health center. Blanche Kahn, this is the health center that currently exists at the East 14th Street location and is proposed to be located in the proposed
And
building.
it sounds like it provides medical services to like special needs and other categories of.
So as Blanche Kahn operates, and Dr. Waxlaw can speak to this more, the Kahn Family Health Center provides medical care to people with developmental disabilities and other special needs. HASC Center is an organization, and I think the local council member who is using some discretionary funds to fund it HASC is in the process of developing a separate medical clinic for the general public that will be done at Brighton. It's not part of this application.
I just have one question. Do you know if the Sunset and Borough Park facilities have medical offices in it? Or medical, medical?
Say again?
I was asking if whether the Sunset and Borough Park facilities also had a medical component to them.
He said that one of them did.
They have the physical therapy programs, the occupational therapy programs, and the speech therapy programs, but the main medical facility is in the East 14th Street facility.
Okay. So it's going to be a little bit of a hurdle for me, because if those two facilities are running well, I'd just like to know why this one would need it.
Well, as part of the submission, when we talk about the existing facilities, we're going, right, so as we spoke before about both the legal side of this is at what is required, what is going to be the reasonable extension of the accessory use in order to entitle Cornell deference, is also going to be talking about the current deficiency, what drives the programmatic needs in this, are the current and future needs to address the deficiencies in the current spaces. And so to say that the spaces, say the Borough Park, Sunset Park location, is it running well in terms of that HASC bends over backwards to make sure that the clients and its facilities get the treatment that they need with the facilities they have? They do, but that's separate from the fact that the facilities themselves, that we need to have better facilities, which is the point of this application.
Right, we need to have better facilities, but maybe not on site, that's the issue.
Right.
And if it's occupational and physical therapy on site, I totally get that. If it's 1 or 2 doctor's offices like you might have in a school, I totally get that. But the idea of creating an entire ambulatory care center on the grade and then applying deference to that, I'm finding that really tricky and opening doors, and I just wanted to add that Commissioner Otley Brown said yesterday that you also have issues about the human resources, fundraising, and accounting that could be really going on in any of the other facilities. Why does...
That's what I said.
Oh, you did? I'm sorry.
Yeah, I said that that's the other hurdle.
Oh, I'm sorry, I missed,
Yeah.
I'm sorry.
And those are all things that we're going to address in the submission,
Yes.
with the understanding that the board wants us to make sure that this is tied very tightly, so my boss cannot come back here and expand it at some later time.
Exactly that. Or you, when you open your own office. Right.
Not so fast.
Okay. All right, so I think we've asked, are there any speakers on this from the public? Yes, please.
Council member?
Madam Chair, I defer to the neighbor. Please go.
He wants to hear all the testimony, I'm
Oh,
guessing.
okay.
Okay, yeah. say
Please
what?
state your name for the, I'm sorry. Please sign in. No, you sign on this one?
Print. Yes.
Print, sorry. That's it. And then you state your name for the record, and you'll have 3 minutes.
3 minutes, that's it?
3 minutes.
It's not a lot. Okay, so name is Aaron West. How are you? I don't know where to start. I didn't know what this is about. I just got this little page over here that says there's going to be some variance request for educational institution. I didn't know what it was exactly it's all about. It's terrific that HASC is doing the work that they're doing. I think it's necessary to be done. It's great. However, right now it's 2-story building on Avenue M and by McDonald Avenue, and I think the proposal says 4 stories. 4 stories is double the size. It's double the size of what it is. It's really large, it's big, it's going to be big, and it might be disproportionate for the neighborhood that this building is going to be in. I understand it's for special need children. I don't know if
Adults, and special needs adults.
and adults. I don't know if I can ask a question of how many.
Yeah, you can ask.
And I'm not sure who to ask, but how many.
You ask us.
Okay,
You speak
how
to us.
many children or adults will be
It's
housed?
adults.
Only adults.
It's adults, it's 1,500 adults who are the clients and 400 or 450 staff.
At any one day?
That's a question we could ask.
450 staff?
That's what we
1,500,
understand from, yeah, so we figure about
members.
2,000 people inside this
That's a lot of
building.
members in that building. So let me say this here. I also learned now that there'll be consolidation of 5 separate areas into this place, into this area. And I think, and again, I don't want to ruin the party over here, and I'm sorry, but, you know, it seems, and I'm very nearby, about half a block away, but it sounds like it'd be too congested, too much traffic, and when you have special need, you're talking about vans, maybe not even buses, that are bringing the students over, because I think they're going to stay overnight maybe and going back and forth.
Please talk to us.
Oh, I'm sorry.
The board,
I
please.
apologize. So the population is going home at night,
Yes,
right?
yeah,
So
no
you're talking about
sleepover.
back and forth, back and forth. You're talking about a staff about how many?
400 or so, 450.
Where are they parking? The parking is jam-packed as it is right now. They're double parking. A couple of years ago, there's a supermarket on East 4th, about 2 streets away, which has been enlarged. It's called Moishe's Supermarket. It's for the Orthodox community. And when they requested the permission to expand over there, they also came back and said, we'll do certain things with parking and accommodate this, that, and so forth. And it is some, but nonetheless, there are big trucks, and major parking, double parking, and spilled all over various streets and honking and all that. So the concern is, it's terrific that it's done. It's just, I'm not sure if it's the right place to do it at the size that it is, with what the neighborhood is all about. A while back, 2 streets away also from this place, somebody got a variance, I think, or zoning exception, whatever it is, to build a 5-story building where the whole neighborhood is 2-story high. So again, it's just a very busy neighborhood, and it's not what is being done in the building, it's not the space, it's not the ambulatory piece, it's not all that, but what is it doing in terms of congestion, in terms of parking, in terms of the busing, in terms of the staffing, where are they parking? And you might say, oh, they work till 5 o'clock and it's not an issue in the evening, but some will work at night, some will work on the weekend. It just, I just want the board to consider that and take that into account and see what, maybe it's not the right place, I don't know. That's my concern.
Okay.
And so,
Thank you. So,
basically, that's it.
just to let you know how this process works, they submitted to us a pretty hefty application with a lot of information. You're welcome to look at that. You can go to our board offices, which is really just down the street at 250 Broadway and the 29th floor, and you are welcome to look at the materials so you can understand the project better. Your community board and your council member also received a copy of the application, so if it's more convenient to go to their offices, you can also do that, to take a look at what it is. Your community board held a meeting about this and discussed the application. You may not have gotten notification, but
Okay.
they also held a meeting about this, and that we're going to be asking for them to respond to things that you said, the questions that we had, and submit that in writing to us again. So we'll tell you what date it is, but they'll be submitting it, and then you'll be able to again see a copy of it at either your community board, your council member's office, or at our office.
So it's not finalized yet?
No.
And there could be adjustment based on
We're
concerns
still
raised.
learning. We're learning, we're trying to understand what the project is and what's a reasonable request.
So it's not on a website? I cannot have a password or something I can just...
No, because the materials are so big, it's not possible to mount them on a website. It's just hundreds of pages of materials.
So how can I find out about developments and updates and anything like that?
So the next hearing, which we will schedule, we're going to tell you right now when it is, and we'll tell you when the new materials will be submitted, which Mr. Lobel will make sure is submitted to the community board and the council member, so you don't have to come all the way here to view it. You can go to your local office, okay?
Thank you for the opportunity.
Sure, thank you for coming, appreciate it. Okay, council member?
Chair, if I could just respond for a moment before the council responds.
Oh, okay.
Just that first, I want to thank Mr. West for coming out. I know it's been a long day for everyone, and it's really been there, and we got a chance to talk a little bit before this hearing, and we understand the community's concern, particularly about neighbors. Kevin Williams, the environmental consultant, is here to speak about some of this, even though we are going to be submitting detailed responses. We understand the board had extensive questions about our parking.
Yes.
Just to clarify a few things, there aren't going to be sleeping accommodations on the site, and with regard to total staff and client numbers, I think those numbers are a representation of the total of everyone in all of the programs, including the programs that exist in the community, such as the community rehabilitation program, some of the vocational support services that occur off-site. And we understand that in the subsequent submission, when we talk about this to clarify the numbers, we have to clarify exactly how many of those staff and clients are going to be on the site at different times.
Yes.
And not just the blanket, because I think having 1,500 students and 400 staff would be quite a lot for this building.
But the thing is, but the other part of it is overlapping program space. So far, we see these distinct programs, and each one has its own set of rooms, its own part of a floor, and all of that. To the extent that any of those could be double duty, the double function, that would reduce the size of the building, right? So the way the programmatic needs report reads is those things are occupied from 8:30 in the morning until 5 or something like that. So we're not seeing any breathing space, right?
So looking at and we are going to be addressing this in the submission, but I'd also point to page 6 of the programmatic needs report that shows peak occupancy for the different spaces. And so understand that there are going to be different populations in different spaces at different times, and we're not going to have everybody in at once, and that our numbers to show how many people are going to be there are going to show who's going to be in different spaces at different times, understanding that clients don't just occupy one specific program and stay parked there, and they'll often move in between from program to program.
Within the building?
Yeah.
Okay.
So it's going to be similar to like the kind of chart that we would ask for a school?
Identical?
Yeah.
The chart, yes.
Yes.
Yes, okay. Okay, and then,
Councilman.
Sign in, or?
After you.
no, you don't, after.
All right, Madam Chairman, thank you very much. Good evening. Good evening, Commissioners. I'm Coleman Yeager. My second time appearing here before the board. It's my third time in my life. The first time I did it was in the mid-'90s when I was aide to a council member. I was years old then. You weren't here either. I'm here, you can imagine, in support of the application. One of the reasons I asked the neighbor, my constituent, fully 50% of all my constituents in the room is the gentleman who opposes it. So this is not an easy place for me to come, because it's frankly much easier for me to say, no, don't build it here. It's true, it really is. The people who are going to use this program, they're not donors, they're not voters. Just be honest, they don't carry petitions for us, they don't participate in our political process for the most part, and they'll never know the difference, frankly, many of them, if I didn't support it. I think in good part, a lot of the reason why somebody like me and perhaps many like you are in public service is for the people that HASC is trying to build this for, frankly. People who need somebody to speak up for them. I know well the organization. I know the camp upstate. I've seen it. It's incredible. You're on the website, Commissioner. Look at the pictures, see the people that are being served. It's incredible. They really do not have another place to go. This is not, said just, facetiously in any way. I'm not throwing it out there just, because it's a great talking point. They really don't. There is no other place. The public school system is not able to handle children. I know these are adults, but children who come up to the point where they're now adults. And then once they get out of their educational structure, whatever they had, what do they do then? Where do they go? They're adults. Their families can't handle this. So HASC, it's an acronym. It's no longer called the original name, but I happen to know what it is. It was the Hebrew Academy for Special Children. It's a sentence. They don't use that anymore for, I don't know if it's branding or maybe they just don't say special. But really, that's how it was created many, many years ago, the Hebrew Academy for Special Children. I started off by saying, it's not, I don't do this lightly. I am, anybody who follows me on Twitter, I'm not suggesting you should, I rant and rave about traffic all the time. I rip into DOT all the time. I think they're out of their minds. They make more traffic in my neighborhood than any facility can possibly make. I don't advocate for more traffic in the neighborhood. I served on a community board for 18 years. I hate traffic. I hate things that cause traffic. But I also recognize that things have to happen. If this was a private enterprise that wanted to build a 4-story building for commercial purposes and was going to create this kind of traffic that we think might happen, maybe I wouldn't be able to stand here. Probably wouldn't be able to. But what we're talking about is not just the benefit of a community and benefit of special children, but I also don't think that the traffic is necessarily something, there will be some traffic, I'm not going to pretend there won't be, but that is necessarily something that wouldn't otherwise be there with whatever as of right would go there. It was once a bowling alley. What kind of traffic do we think was there every single night? When I grew up, it was a bowling alley. I don't know how long ago it was a bowling alley, but I'm sure there was traffic there every single night when it was. It's right near a subway station. It's a block away from a city bus. It's literally the perfect place in the neighborhood to put something like this. And I'm not, of course, I'm not going to make legal arguments. I don't know as much as the attorneys. Never studied this in law school. I don't know as much as you folks do. Surely, I think there's a place where you're able to find that the accessory uses have a reasonable relation to what's going on in the building, the core function of the building, that you can make the case narrowly enough to find that that accessory use should be considered to be an integral part of the program. For example, and I don't remember who said this, it's being built as an educational institution, if you will. Every educational institution has some sort of healthcare. I would view, and even though the healthcare component of the project is larger than what one would normally expect, but also the program is different from, it's not a college. It's a different kind of program. I think that given what kind of program is being put there, the healthcare component is no different than an infirmary in a school. It isn't.
But an infirmary is a couple of rooms.
Sure.
Right?
In a school that's a regular school. But this is not a regular school. And, you know, I want to make sure that when we're comparing apples, it's not just not comparing them to oranges, but I surely don't want to compare them to Volkswagens. This particular place, this particular service that's going to be provided there, the particulars of what kind of people are going to get served, necessarily means that their infirmary is going to be the size of the medical facility that's there, because they need that as part of who they are and as part of the education they receive. Their entire, I mean, and anybody, you know, there are volunteer programs in my neighborhood for folks in the community to actually come out and be a part of helping these kids and trying to interact with them so that they can interact with regular folks. I mean, and you can see the pictures all over the website. We have many, many events in the neighborhood where this is a basic part of the chesed that our community does. The kindness, the working with others, the working with those who are less fortunate. But when you're talking about a special needs population and we're trying to give them a life that's as normal for them as we can possibly make it, doing our part to make sure that we don't alter it unnecessarily by saying, you know, once they know that 5 days a week, this is what they do and this is how they go and these are the things they do, taking them to another floor so that they can get whatever treatment is necessary is helpful to them and it's part of their program. Putting them back on a bus and driving them somewhere else creates chaos in their educational programming, in my view. And I'm not at all an educator, and I'm surely not an expert in this field in any way, but it's a layman's view, as I would argue it if I was somebody who was an attorney representing these parties and trying to make the case to you that I think there's a way you can find the exception necessary to apply that Cornell deference to this. And I don't think that and again, not arguing their legal points because I'm not well versed enough, but I don't think it's necessary to look for how could we make it not fit. I think we could look for how can we make it fit and draw an exception very narrowly tailored to this kind of institution, this kind of location, because I think that's also very important. It's a commercial strip. We're not doing this in the middle of a residential block. A yeshiva could build here and go 4 stories high. I think there was actually a yeshiva there at one point, I'm not sure how long ago. Public school can take the property by condemnation and put up a 6-story high public school, put 3,000 kids in there with no problem.
Yeshiva can't build a 4-story building.
No, not without permission, but
Not without a variance.
we would make the argument
Standards
that
and appeals,
we would make
right?
the argument that
Subject to deference.
that there would be no good reason to deny a yeshiva the opportunity to build at the corner of Avenue M and McDonald Avenue, Madam Chair. And I'm sure that over the course of the next 3 years that the people have given me, I may be here again urging you, Madam Chair, to allow a yeshiva to build at a good location in my community. That's what the community is. It's a uniqueness. I refer to it as a village. It is. It's very small. It's part of the suburbs in many ways, even though it's part of New York City. We keep our stuff inside, and by that I mean our programming, our education, our food shopping, our doctors. I don't see a lot of people traveling around to get out. Everything people do is in the neighborhood. The people who are going to attend this are from the community. It's not a business that's being built and they're going to hang up a sign or take out an ad in the Times saying, you know, this is where you should send your kid, or this is where you should send your special needs adult. There are people in our neighborhood, unfortunately, who need this kind of specialized service. And the applicants, I believe, will make presentations, if they haven't already, about why it's necessary for them to combine, or why it's advisable for them to combine other locations into one, but they're also doing a wise thing, right? They're taking many different locations that they have, and for efficiency, they're bringing it into one centralized location. Frankly, the East 14th Street location is when I was younger, it was a former bus garage. It's around the corner from a brownfield. It's across the street from another brownfield, and it's around the corner from the garage I currently use, and half a block away from the garage I used to use, which is no longer there. It's not a person-friendly place. It's a manufacturing zone, in fact. This is a good place to put this. And, again, I don't want to, I'm a new politician, but you give one of us a mic, and it's hard for us to pull ourselves away from it. And Madam Chair, I do appreciate the lateness of the hour and that you've taken the time to allow me to continue. I will come back, Madam Chair, if the next time that it's on, if the applicants would have me, and to help maybe answer the questions. But what I would say, with respect to why is it, the broader theme of why is it necessary for this to be here. I think that, the unanimity of the community boards are not interested in bringing unwanted things into our community. I have to face voters again. I'm not interested in bringing unwanted things into our community. My colleagues in public office are not. There was a letter submitted into the record, I believe, by a colleague of mine who represents a district outside this immediate area. He's not looking to make trouble for the community either. We're doing this because we really do believe fundamentally at our core that it's who we are in the community, that we try to do this. So much of the funding that HASC gets is actually privately raised. It's true that this will be, some of it will be government funded, but a lot of what HASC does is raise money privately to support the children who receive services there, to support the adults who receive services there. And with that, and again, in recognition of the lateness of the hour and appreciating that, I think we're the last item on, right? So I can keep going. Okay, thank you very much, Madam Chair, and I appreciate the due consideration you're giving this project, Commissioners. Thank you.
Thank you very much.
I have a question, though. While the council member was speaking, I went, as he suggested, onto the HASC's websites, both the camp and HASC itself. I can't find any reference to adults. I only find reference to children. Did you find reference to adults? HASC Center?
You have to come?
Okay. HASC Center. Okay.
You have to come and speak.
It doesn't matter. Okay. Whatever.
Okay.
All right, so,
How much time?
February, how many, wait, let me, I want to see that, we said 7221s on February.
Just as far as process and timing, I've spoken with the architect who's told me that much of the information that's been requested by the board with regards to program needs and establishing those, that he has that available. Yeah, but he has it here, but we're going to provide in writing. So I would say that in light of the desperate need of the program as well, we're happy to come back as quickly as possible.
Right, so then we have our calendar, so just give us a second. Okay. So, 21s, 7-story penthouse.
February 12th?
The 12th, is that okay?
Yeah.
I'm just checking on you. Okay, February 12th with a January 23 submission.
Wait, can you give me a moment, Chair?
Yeah.
Madam Chair, may I be heard?
Sure.
If there's any way, if there's a
There isn't.
blank space in the
There isn't.
calendar that this
There
can be
is not.
accommodated.
Sorry,
How about if there's a cancellation or an adjournment?
we don't work like that.
Don't do wait list?
No, it doesn't, there's no wait list. We don't work like that because we're giving notice to the public about the next hearing date. So this is the notice to the public, so we don't move it up the calendar or anything, but we have a very, very, very full calendar, and the next availables are in February.
Okay.
So,
Thank you.
yeah, thank you. So February 12th with a January 23 submission.
Thank you, Chair. Thank you, Commissioners.
Thank you.
Excuse me, you can't, sir?
He's just showing me the website. No, it's okay, I found it, thank you.
That's it?
Thank you. Thank you.
Item number 6, 23115BZ, 5278 Boston Post Road, the Bronx.
I don't know if anyone's here for this, but they're adjourned, right? Postponed? Right, postponed hearing. But did we give them a date? So, we choose a date. And this is
February
7 to
25th?
21, it can't be on the 12th.
The
right?
25th of February, yeah, 26th of February.
Right. Yeah.
Yes, and just to note that a new notification should be sent out.
Right, but so say again into the record the date of the submission?
February 26th and February 6th.
Is
For
submission
the public
date.
hearing.
So submission is February 6th, the hearing date is February 26th.
Correct. Thank you, everybody.
Yes, I have a new notice. This could, yes,
Yes.
new notice. I put a note.
Make sure that we
here
speak
are.
with staff to send out a new notice
Yeah.
of
This concludes the public hearing for November 20th, 2018.